Yeah. Hi, Mr. Jett.
I think you're muted. You're still muted.
How about now?
That's much better.
Okay, we have an external mic for the room. That's
Yes.
why I'm muted. All right, well,
I understand. I understand. I'm on for Chris DiCaprio. I understand we aren't on till 11 something, so I just figured I'd check in and make sure everything worked.
okay, well, I'm glad you did. We're gonna keep ourselves on mute for a while, so you feel free to do the same.
Very good. Thanks very much. I'll
Yep.
mute and stop video.
Thank you. Now, what do we say? Alex Brindley. Let's leave it on now. Okay. Alex Brindley. Why do I see your name?
Because I'm here.
Are you now?
I sure am.
You're supposed to be out sick.
Well, I guess I'm unsick.
Okay, awesome. Well, it's nice to see you. You look fabulous.
Great, thank you. I'm doing the commission meeting from home.
Okay, cool. All right, you'll let me know if you don't feel well.
Yes.
Okay. Hi there. Can you let me know your name and what case you're here for? Can you unmute yourself? Should be a little microphone button. There you go.
Oh, yeah. My name's Christopher Fugier.
Okay. Yep. I will just change the name on your little block so we know who you are. I'm going to keep you muted for now. You can keep your camera on or off until it's time for your case. So that's up to you. Okay.
All right. Thank you.
Yep. All right. Because no one needs to see that. Yeah, I really wish people would turn off their screens. You end up seeing a lot more if you want.
I'm sorry, I'm definitely negative for COVID. I just have that after.
I also just remembered that this is streaming, so I need to.
First case has an interpreter.
Us, yeah. You ever work with ASL?
I have not.
What's that? I can't see that. Should be a message.
Oh, there's a cat.
I'm good. We're actually not having a party. You're on the first case.
Yeah.
So yeah.
Oh, we're not having a party.
Well, we have an overflow room so that we only have people for one case at a time,
Oh, okay.
but you're in the first case.
I know. In and out.
Huh?
In and out.
That's the idea, right? Mhm.
How many commissions are gonna be here in person?
Three in person, 2 remote.
Oh, that's pretty good. I thought they'd all be.
They actually like being here. It's just one comes from Presque Isle. Yes, yes. We got one from Portland, one is in Canada right now, so he's definitely. How are things over at DRM?
Good. Things are good. I mean, busy. I mean, it's still a bit chaotic.
It's never gonna be unchaotic, right?
That seems to be the,
Yeah.
the new Like I work I work out of Mackworth Island now.
Hmm. Do you really?
Yeah,
That's cool.
well, it's a lot shorter than going to Augusta,
Yeah.
but I had a really nice office in Augusta. And Mackworth is kind of decrepit shape.
Indeed, I have been there. Yep. Spent a lot of time there. Decrepit is a fair way of describing it.
So, but it only takes me 20 minutes to get to work rather than 45.
Sounds awfully good. Yeah, you live in Yarmouth?
I live on Sugar Island.
Yeah. So we have similar commutes, although yours is even worse.
I take a boat every
Week.
morning.
Yeah,
You live in Yarmouth, right?
Shabik though, that adds another,
15 minutes.
yeah.
We cut 2 minutes from my house to the boat, then 15 minutes. Then there's like this morning, like north wind, walking down that wharf.
It must have been awful cold. This is Jen Manzano Roos. She's.
I do too. I'm Peter Rice.
Peter Rice from Disability Rights Maine.
I used to be legal director,
Are you not?
but I'm not. I'm now on council.
Oh, well, that's very exciting.
Like yes and no.
Alex keeps warning me we're unmuted, as if we don't know. I know, she's warned me on there, on here and on here.
I'm sorry.
Thank
I
you,
didn't know
Alex.
it was intentional.
Thank you. Thank you. Thank you. Thank you for protecting me from myself. I need it.
Oh, money.
Oh, no, I do. Did they unlock that? I just emailed building control to get them to unlock it. I told them.
Morning, Jen emailed them on Friday.
And it was still locked?
I don't know, I just had a habit did it.
We are asking everyone to be masked in here.
Yeah.
I forgot, even though I have one here. Thank you, Chelsea, for reminding me.
I don't have to mask when I talk though, right?
No, you do not. You may
You know-
have a mask.
Mask, hearing aids, and glasses do not mix.
I have never found, I've tried all the things for glasses, the tape, everything.
But that's just too much behind the ear.
Good morning, Amy. Amy, can you hear me? Okay, I believe I'm just here as table interpreter and there are two others coming. I can't hear you though.
It's,
We have a room mic that turned itself off. Can you hear me now?
I can hear you now, yeah.
Okay.
So do we have, I think Meryl is one of the interpreters and Eric?
I actually don't know who the second interpreter is.
Okay. Okay, I guess I can go off camera for now. I'm not sure.
Yeah, I will definitely let you know. That is the first case we're gonna hear, but not even all the parties are here yet, so.
Okay, well, I am here and just shout if I need to come. I'll come on camera when I see Meryl and her team.
Awesome. Thanks, Margaret. Hello. You weren't there. I wasn't sure if you were ready. Hi, Maria. Here she goes.
Hi.
Jane.
Access to a Google Drive, so that's fine. We need to restart. We already tried, done that like 16 times. We'll figure it out. Okay. That's not true, actually, I can get in a backward, I just can't get in. I have no access to Word documents. Only to Google documents. Okay.
No, luckily, right now, that's a later problem. Not good.
But like, that's all we can have, you think, that's.
Colin's watching. I'll email you the information. Lunch for the commissioners. I can't do it. Jen can't do it. Chelsea can't do it. So Colin can do it. It's not in case it's on the agenda.
Change that.
And we're talking about him. He's watching.
Hi, Colin.
Hi, Colin.
Can I get some water? Is that okay?
That is actually for the commissioners, but
Okay.
I feel bad saying, no, there is a water fountain right around the.
That was my guess. That's why I asked.
Yeah,
Go ahead and
crazy.
get myself some water.
Just to talk to course. Starting here.
I'm gonna
There are cups. You want a cup and you can go get water.
accidentally leave in front of Colin.
Look at this, a nice person, Amy.
We like to have one of us be the designated vice person today for. Most
Thank you, Barbara.
for-
I will go fill it up if we run out, because that's on me.
We do a solid mean mom, nice dad routine. She's nice dad.
It didn't say, thank you, Barbara.
At least half the time. You're welcome. Lest you think I'm ignoring you.
I gotta go back.
Hey, look. Yeah, but it's in Google Docs. I told you I can get in through that way, but I can't get in through the normal way. Or I remember that, but it didn't.
Where are my materials? Because I too can be nice. Everything in the working. All right, Elsie, on you to let people in. Got a pen. You have two pens? I think so. Hold on. There's a pen, yeah, right there. Thank you. Would that be a nice paid off?
For me,
I'm not sure it paid off for you.
except for I've lost a pen. I'll get by.
All right, hopefully we will have Tom Douglas here in person shortly. And first time in the building, and Julie. Ed is,
I was to say, it's not even in the country.
yeah. One watching. Oh, that one person.
What? Call it like-
Hi. Oh.
Huh.
Reviews there. There's some right there. The writing card, it's downstairs.
It's downstairs.
Yeah, it's wallet in the bag, which is not very helpful. No, wait, one here. I take that back. No, it's in my pocket. I thought of this ahead of time.
I have a picture of it on my phone.
That's terrifying. Yeah.
Okay. And you want to hear about them? Where it's
Just
at?
pick it up.
Okay, they already have the order? Or?
I forwarded you the email
Yeah.
that
I
had the
just-
order in
they
there. I
didn't
haven't heard
respond.
back.
I'll follow it.
Thank you, Colin. All part of the learning experience, right?
Yeah.
Just think, soon there will be somebody less
That's
senior
right.
than you that
Soon
will
someone else
do
can do
that.
that. Starting next week. Thanks, Lily. Hey. Whoops, mask. Mask, there's a bunch right there. Thank you. Hi.
Hi.
Hi, Commissioner David, you made it.
Good morning. Good morning. I just had a scare. I tried to get on and it told me I couldn't open a Zoom meeting from Canada.
Oh,
Well, that frustrated me because I've done 4 mediations up here, but I'm the host, but there's no problem. But I've fooled it. I've used a VPN. It thinks I'm in New Jersey, so it's silly. But here I am. Thank you.
good to see you. Now, our commission meeting interpreters are not here yet. We do have a deaf person in the audience. So I'm going to ask that we hold off for a minute until we have interpreters. And
Okay.
we're waiting for one more commissioner as well.
Amy, this is Margaret. Do you have a confirmation or does somebody from, I think it was through Pine Tree?
The investigator does, I think. I think so.
Well, what is that? He is here.
Yeah. Bob,
He is like, oh,
yeah, he's on. Bob, can you let us know what the interpreter information is?
I do have that confirmation, Amy.
And did it tell you, Merrill is one of the interpreters, who the other interpreter is?
Certainly, hold on, please.
And one, Tom Douglas. This is the place, yes.
I suppose that mask.
yeah, there's one right there.
Sure, Mark Franco, come on in. TLD, you're right here. You're over there.
For you. How are you?
Ready for one now?
But thank you. That was wonderful forethought. We're gonna be here. till-
You're over there.
Exactly.
We are in here, but it is 8:21.
So
you're.
For later. Pearls for the peanut butter.
That's so nice. Oh,
They're good.
thank you. So, Tom, this is Julie O'Brien, Mark Walker.
Hi.
Tom Douglas,
Nice to meet you.
Morning, Tom.
Mark
Nice
Walker.
to meet you.
And on screen, we have Jeff Ashley
Excuse me, is there a mention?
there.
Yeah, it's wild.
And Jerry as well, all right.
Yep.
So that means like 5. That's 5. So I just want to check on the interpreters. Bob, can you tell me where they scheduled for 8:45?
Looking right now, one moment. Yes, 8:45, Merrill Troop and Eric Workman.
Okay, so that means, we don't have proceedings interpreters at the moment, so that, that makes our business meeting inaccessible to the deaf consumer who is here. Now, the interpreter that everyone is watching right now is here to interpret the relationship between, case, a complainant and the complainant's attorney. There, Margaret, who you see, is not the proceedings interpreter. Which means that that's our commission's failure to get the interpreters here for 8:30. We should wait to start our business session so that it's accessible to everyone. And I see complainant here. What the interpreter is explaining, right?
Amy, this is Margaret. So are we just gonna wait? What's,
Yep, if we don't, if we proceed, then what we're doing for the next 15 minutes is not accessible to everybody on the call.
okay, thank you.
So apologies, everyone, we're just gonna have to wait a few minutes.
You said last time, any note that we take would be. So we should.
Is that right?
Yeah.
Those we take in advance.
There is no provision of the Freedom of Access or Freedom of Access Act.
Has it ever been?
Everybody got it?
Never know. Never know it.
You said it. Absolutely crazy stuff.
You know.
Crazy.
Recording here? Yeah, I think it should be, yep. It's gonna record us sitting here. Do you have tissues?
I've got my own basket.
Oh,
You're all,
That's good use of your old knots.
yeah, exactly. I have a scarf if you, okay. Don't know Rebecca.
Okay.
So Julie, while we're waiting to start, I have your expense report for the prior year, your per diems. That you would sign here, so we could get that process where it says traveler. We need your vendor form. Can't pay till we get it.
You know you're in for the money.
Right.
Pure mercenary.
You. Oh, yeah, yeah, no.
100%. Married killer.
He doesn't. You even get paid for that?
I
Well,
know,
I
it's so fun, you would
So
say.
much True. Paid just like you were a babysitter in 1960.
Well, I've got some better ones.
Well, sure, but.
Yeah, I think I can get 3 of us here. And agree on pretty quick.
Yeah.
Yeah.
But one of us cannot agree for.
So for folks who are just tuning in, we are waiting for our proceedings interpreters to arrive so we can begin the business session, which we will move through quickly. And as people did notice, and Margaret, thank you very much for interpreting what I'm saying. I really appreciate it, even though you don't have to. If you notice, we have an extremely long case agenda today, so I'm going to encourage everyone at the start to be as brief as humanly possible. Thank you, Margaret.
Amy,
Yes.
this is Margaret. I have a message. It says only the host and co-host can see my video.
We will move you into, once we start the hearing on that case, we will move you into the into a focus room. But so do you think that that Ms. Draper cannot see you right now?
No,
I
think I'm not sure. She just went off camera. I'm just wondering when Meryl and Eric arrive, you'll just set it up so that they're visible, correct?
Absolutely. Yes.
Okay, yeah. I'm not sure. She could just see me, but then I got this message, so I'm not sure.
We're gonna work it out.
Okay.
Folks in the audience are saying none of us can see anyone except me and the meeting right. So Chelsea, can you interpret? Yeah. Yeah, Chelsea here. How's that? Better? Still can't see the interpreter? Oh.
Can you spotlight?
Yeah, we're working on it.
Oh, okay. It says focus mode is ending.
Yeah, that's what we use during a hearing, but.
Okay.
Not sure I know what focus mode is.
It's
Sue
not
Ann is saying she can see the interpreter right now.
good. Ed, don't worry about focus mode. It's just what we use during a hearing to winnow down the number of people that are on the screen.
Okay.
In the exact room. You can't use them there because you can't speak.
Forget us.
For folks who are just joining us, we're just waiting until we have a proceedings interpreters here to interpret the business session, so everyone in attendance can access the meeting.
Amy,
Yes.
I just got a text from Meryl. Neither of them have the link.
Okay.
Do you,
Yeah, where should I send it?
do you have Meryl's email? Or should I?
If you happen to have it right in front of you, that would be great. Otherwise, I have Meryl's email. Bob, could you send that to the interpreting agency, please?
Sure, let me try.
Amy, let me see if I can make this happen.
Thank you, Margaret.
I just got an email from Eric Workman, so I can forward the link to him.
Great.
Would you ask him to share it with Meryl and then they'll both have it?
Certainly.
Thank you.
Thank you to everyone for your patience. And thank you to Margaret for continuing to interpret for the proceedings, even though you don't have to.
just forwarded it to Eric.
Thanks, Bob.
Yes. Head chef, that's a river.
He's my dog.
I don't think I could get him to cook for me, but no. Only if I go to a restaurant.
Good by that. I thought of most. Last night. Hot chocolate. Real hot chocolate. She took a bunch of chocolate chips and stuff, then I melted it down, and basically poured it.
This was this part?
That's what I was saying.
What time do I come over? Yeah.
I drank half of it, pretty sure I did.
Right. And she was really hot.
Oh my God, it's delicious.
How old is she? That's a lot.
I cooked up the whole.
Right?
That's a lot. No, that's a lot. 16.
Sons. Yeah, she was not.
What?
Oh, yeah. I'm serious, I drink half. Need to have one of those sugar things, like when you stick your finger.
Yes.
One would.
And yet, here we go.
Yay, one. We're starting with one.
That was proud.
Her team can join her. Along the way. We're about to start. Hello, Interpreter Merrill. We're going to start with one. I know you have a team, but we're starting anyway. Good to see you. Okay. Mr. Ashby.
Good morning. I'm Jeff Ashby. Everyone can hear me all right?
Yes.
On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device like a cell phone, etc., to ensure that they are silenced now. We have Additional agendas, including the consent agenda available, is it correct, Amy, in the back of the room? It's
It is
also been-
correct.
It's also been provided electronically. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be considered further today. And so for our first order of business today, it is to adopt our agenda, and I'll entertain a motion to do that.
Second.
Second,
All right. Amy, it's been moved and seconded.
Yes, thank you. So when we have people attending the meeting remotely, we are required to utilize our remote meeting participation policies. So I have to ask each commissioner for every vote to signify their vote both orally and vocally. So we'll go in order of seniority. So the motion is to adopt the agenda and consent agenda. Commissioner Ashby,
Yes.
Commissioner David,
yes,
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Okay, we're gonna do that every single time. I forgot to ask if there was discussion, but I think not.
Right. Next on our agenda is for us to approve our minutes of our November 2022 Commissioners meeting. I know the minutes have been provided to the commissioners. I'll entertain a motion.
So moved.
Second.
So it's been moved and seconded to adopt the minutes from the, that should say November 2022 commission meetings. And if you say yes, you're in agreement.
Hang on. You weren't here.
That was. Oh.
You
Not
want
for the whole thing.
Oh, that's true, not for the morning.
We need a new motion.
Uh-huh.
So moved. Do the minutes. Because
You don't know if the minutes are correct. So is that motion and second withdrawn?
He knows.
Well, excuse me, Commissioner. Sorry to break it up, but is the motion withdrawn? The second?
So moved.
Thank
Adopt the
you.
minutes.
Is there a second from somebody who was here at the last morning session?
yes, second,
Second.
Thank you. I think there might be some muttering under someone's breath over here about rethinking this commitment.
I was mostly here.
Yeah.
Talking.
Is there any discussion? No, okay, so if you're in agreement with adopting the minutes of the November 2020 meeting, you'll say yes. Mr. Ashby,
Yes.
Mr. David,
yes,
Commissioner O'Brien,
Yes.
Mr. Walker,
Yes.
Commissioner Nichols.
Yes.
No,
I mean, can I vote?
apparently you should abstain.
Abstain?
She's very positive.
She always
Yeah,
says-
people say that about me.
She always says.
So the
No.
motion has been approved. Now, Amy, the director's report?
Yes, I'm going to keep it brief so we can get back to cases. You all have a memo from me about personnel. For compliance, we have for pending reasonable grounds cases, 1 successful agreement since the last meeting, 1 unsuccessful conciliation, 3 cases still in pending. So we have 1 agreement that hopefully we will approve in PA 210113 Marquis versus Northern Maine Medical Center. You have a memo ostensibly from me, really from Jane, outlining the terms of the conciliation. I would ask that you approve it.
I move approval with the conditions that it remain open pending public execution, et cetera.
We will not actually execute anyone, but we will implement the agreement. Second, thank you. It's going to be a meeting today, guys. It's going to be a meeting. So it's been moved and seconded to adopt the conciliation agreement. Is there any discussion? Seeing none, I see you, Commissioner Ashby, wanting to vote. If you're in favor, you'll say yes. Commissioner Ashby,
Yes.
Commissioner David,
Yes,
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Okay, next we have, you have an update, a report in there showing new charges in November. We received 42, administrative dismissals 28, and predetermination settlements 8 with benefits of just over $100,000 to complainants. Meryl, I know I'm going fast, but tell me if I'm going too fast. Litigation, I would ask that we take after executive session, which brings us to new business.
Amy, I have some new business.
All right.
I would like to make a motion that we withdraw our decision from our November 2022 meeting in the case of Cassavant versus the University of Maine system. That's docketed at number EDPA 200470. And I can explain why. And I probably do so in my before anyone seconds my motion. I had at the time of our decision in that case an unwaivable conflict that I hadn't made note of and hadn't noticed or discovered. Upon discovery of that conflict, I'm mortified. I apologized to the commissioners and to the litigants. But I think the only recourse at this time probably is for us to reconsider that case without my involvement. So if you're inclined to second and then vote on this motion, I'll then subsequently recuse myself from the case, and we'll consider.
I'll second the motion.
Thank you, at our next meeting.
So it's been moved and seconded to withdraw the commissioner's vote, essentially to reopen the case in Cassavant versus University of Maine system, EDPA 20470. It's been seconded. Is there any discussion? Commissioner O'Brien?
Did I hear we will hear it again at the next meeting?
Well, we're not
We're not
sure if it will be January or February. There
Okay.
may be a scheduling issue.
Okay, parties, all right.
But it basically reopens the case. Any other discussion? Seeing none, if you're in agreement with withdrawing the commission's finding in that case and opening the case back up, you will say yes. Visually and auditorily, Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Thank you. The only other matters of new business are that we've met with the Bureau of the Budget on initiatives for the governor's agenda, and we do have our fiscal year 2021, you'll note we're a little behind in our annual reporting. It's not up on the website yet, but should be shortly. I did provide it to you all in your materials, I think. And I'd be happy to discuss it. Hopefully the FY22 will be finished shortly, so we're all caught up before we go to judiciary, which should be probably in January. That's all I have for new business, and I would ask that we.
That's a great report, Amy. I wanted to it shows a really good body of work and just a readable and good report. Thank you for that.
No one has ever called it readable, so thank you.
I actually read the thing. So.
I will take that. Thank you. So I would suggest that unless any other commissioners have new business, that we move directly into the morning session cases.
All right. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda, and as I call each case, the party who has submitted a written argument will be called to the podium or electronically to the electronic podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that the commissioners may ask questions, and I will ask you to introduce yourself as you come to the podium. Thank you. The first case on the agenda today is PA 200477. That's Sue Draper versus the City of Ellsworth Police Department. And that is, I have to find my notes. That's a reasonable grounds case, correct, Amy? And if so, we'll hear from the respondent.
Amy's recused from this case, Jeff, so it's me who will be timing and dealing with things. Just a reminder in this case and the subsequent cases to please not use third-party names during your arguments. And because there are interpreters in this case, what we usually do is allow up to 15 minutes so that there is additional time for each party while the interpreters are interpreting. And folks, I'm going to trust that the interpreters will let me know or let the parties know if people are speaking too quickly. So with that, we will turn it over to respondent if that works for you, Jeff.
Great, thank you.
Thank you.
Excuse
I-
me, please hold while we switch interpreters and make sure that Ms. Draper is able to see the interpreter clearly.
And this is just a reminder if folks could introduce themselves before speaking so that we can interpret correctly who is speaking. Thank you. I think the interpreters are all set.
Go ahead.
Thank you. Good morning. My name is Mark Franco. I represent the respondent, City of Ellsworth Police Department. We're here to talk about an event that occurred on January 2nd, 2020, involving the complainant and the respondent, whereby an incident was reported to have occurred at the complainant's home. And through the 911 operator, police officers were dispatched to that home. The issue that is before the commission is whether or not the investigator in his conclusion that reasonable grounds existed, whether that is based on whether some of the facts that he relied upon in support of his decision were in fact in the record, or whether or not they were misplaced. It's our position that although the investigator, in my opinion, performed was very thorough in his analysis. He spent a lot of time on this matter. We had a fact-finding conference. It lasted over two hours. That his conclusion that the respondent discriminated against the complainant is misplaced and should be reversed.
Excuse me again 1 second. This is the interpreter and I need to discuss something with the working interpreter. Just please hold 1 second. Disagree. Thank you.
Okay, we may continue.
Thank you. I think the crux of the case boils down to whether or not an ALS interpreter should have been dispatched or requested or required prior to the officers going to the home that day, or whether at some point during the process should have stopped and an ALS interpreter should have been required at that point. I think that it's important to focus on the exigency issue in this case, and that is there was a domestic assault, domestic violence issue involved. If, depending on how the investigator, how you interpret his report, I interpret his report to suggest that once a domestic assault was reported, that once the officers knew that it involved someone who was deaf, that they automatically should have called for or tried to get an ALS interpreter there before they actually went to the scene. I think that the investigator assumed erroneously that the officers had made up their mind in advance that an arrest was going to take place, which in cases of arrest, ALS interpreters are required. I think that that conclusion is misplaced. These officers, at least one of them, had had at least 5 prior interactions with the complainant in the past and had effectively communicated with her without issue, without never objected in the past to not having an ALS interpreter. That there were notes, that there were various forms of communications. Some of the information that was provided by the police department did not specify how the communications took place in the past, but some of them did indicate that it was through the use of written notes back and forth. I think that, you know, we don't use the golden rule when we go to court, but you almost have to place yourself in the position of the police officers when you analyze this case. And that is, should they have known that Ms. Draper required an ALS interpreter before they actually went to her home? And the answer is no, because they had effectively communicated with her in the past. If this was a first-time occurrence and they knew that someone was deaf, that might be different. But the fact that they had effectively communicated with her in the past, at least I believe, led them to believe that they could effectively communicate with her on this instance. And it was by no means clear to the officers that they were going to an effective arrest that day. A difference in this case is that the significance of this case lies in the fact that when the officers arrived and they knocked on the door and they asked to come in, they were invited to come in by Ms. Draper. And she was the one who had the notebook. They didn't hand her the notebook. She had the notebook. In other words, she was prepared to communicate with them in writing, which was effective in the past. It was only after the officers told her that she was going to be arrested that she started claiming that they should have had an interpreter present and that they were going to get sued, you know, and things like that. So I think that the issue in this case, as the investigator has identified, is whether or not the officers knew or should have known that an ALS interpreter was required before they actually went to her apartment that day, or prior to the arrest, whether or not she had requested or demanded an ALS interpreter. And the answers to both of those questions are no. I identified in my paper, and I'm not going to go through them and repeat them because I know you've read them, various factual conclusions that the investigator reached in this case, in which I believe that the record does not support. And I went through that, and I went through the prior events in which interactions took place without incident. At no time, it's important for the commission to understand, at no time during these prior events, including events in which communication was done by notes, did Sue Draper ever demand or request an ALS interpreter. If she had, that would have, at least with respect to Sergeant Wilmot, that would have told him that, hey, I'm going to her house again. She's going to request an ALS interpreter. I need to get one. And that was not the case. And I think the key fact is the fact that she let them in. If she had said, no, don't come in, or handed them a note, don't come in without an interpreter, different case, totally different case. The only difference in this case was that she was arrested.
Okay, hold on one second. This is Miss Draper. She said that the video is all shifted around. I want to make sure she can still see me. Can you still see me, Miss Draper? Okay.
If you could please repeat that last sentence, and then you can go from there.
Do you remember the last sentence?
No, I think that I was just saying that there were, if the officers had a prior experience with Ms. Draper in which she had demanded or requested an ALS interpreter, and they knew that they were going to her house on that occasion, then that, yes, I would agree that they should have furnished one right away before they even got there, if it was available. The exigency issue in this case is important. You know, police officers across the country are being criticized for not responding to scenes quick enough. So in this case, practically speaking, if an ALS interpreter was demanded and the officers would have been delayed in responding to a domestic violence or alleged domestic violence scene. So in other words, they would have had to stand outside the apartment, wait for an ALS interpreter. These are not readily available. They're not employed by the city. They're not employed by the department. And that's a whole different issue in terms of funding and the like. They would have had to wait while a potential domestic violence situation was actually actually going on at the time. So that actually begs the question on a broader scope, how a police officer or a police department is going to be effective in responding to an emergency situation, and if they're going to be hamstrung by the requirement that an ALS interpreter be dispatched to the scene immediately. Practically speaking, it's not going to happen. So in this case, they did what reasonable police officers would do under the same or similar circumstances. They used their experience in prior instances with Ms. Draper, where they were able to effectively communicate with her by exchanging notes. And she offered that communication in this instance as well. And that's what happened. And everything was fine until they told her that she was going to be arrested. And after that, that's when the shouting started. But I went through some of the, I think that, and I have tremendous respect for this investigator. He is so thorough and detailed, and he asked good questions, and he did a good job in this case. But he jumped to the conclusion in this case that the police department should have anticipated that an arrest of the complainant was highly probable. And then he says that the events leading up to her arrest strongly suggest that the PD knew or should have known that an ASL interpreter was required in this case. And I went through why, and I just explained to you why, that it was impractical, impossible, and illogical to conclude that Ellsworth PD and its responding officers should have called an ASL interpreter and waited for that interpreter to be available before responding to the call. If that's the legal standard and that's the law, it's impossible and impractical to follow. You can't do it unless you have one on staff, or if the police officers are actually trained in that form of communication. So I'm happy to answer any questions. That's really all I have. You've read my materials. Again, the linchpin issues in this case is the exigency of the circumstance, the prior experience of the police officers dealing with this individual, the fact that she invited them in and provided them with a notebook as a form of communication, and the fact that they were able to actually communicate with her effectively at the time. And then as soon as they arrested her, they requested that an interpreter be dispatched to the jail. And that's another issue that's not relevant to this case, but they did what they should have done under the circumstances. The investigator took testimony from the police officers at the time in the fact finding, and they basically it's in the record and it's in his report. They just didn't feel that it was necessary under the circumstances to wait, and it was dangerous. So happy to answer any questions that you have.
On the issue of exigency, counsel, you're kind of threading a needle here a bit, aren't you? I think you argued that the officers, when they left the station, when facing the prospect of a domestic violence situation, run into the problem of it being so exigent that they can't get an interpreter in time. And then you also, I think, argued that in this instance, these officers really didn't have any reason to believe that they'd be dealing with an arrest. And so the case, I'm paraphrasing, but the case maybe wasn't ripe at that point to acquire the services of an interpreter. You're kind of threading a needle here, aren't you?
Well, no, I think if you look at the entire situation from a practical standpoint, let's say that they knew from the prior experiences that she had demanded an ALS interpreter, and that they demanded or they dispatched one, or they called a service up to get there. But so they were between a rock and a hard place, where they would have had to go to the scene, an alleged domestic violence situation actually occurring at the time. And if in fact they were required to have an ASL interpreter there, they would have had to wait. They would not been allowed to enter the apartment. So I'm just painting a picture that the practical difficulties of enforcing this type of law on a first responder, that's all. But
So I think probably the most important, and your policy suggests this, the most important moment or the need for an interpreter arises when important legal rights are at stake, and that's why the interpreter is required at the time of arrest, correct?
That's right. That's correct.
Well, wasn't there time in this case, as I understand the facts, wouldn't that have been the moment to sort of put a pause on things and call the interpreter? As I understand it, the investigating officer came downstairs from having spoken to the victim in the case. And at that point, a decision had been made to make an arrest. And wouldn't that have been the appropriate time to pause, get on the phone, get an interpreter available before you then interacted with the complainant? Wouldn't that really have been the right time to do it?
So the police officers testified in this case that as soon as they made the decision to arrest and they had been able to effectively communicate with her up to that point, they did not have any interaction, or they didn't give her Miranda rights, for instance. And that the reason being they weren't going to ask her any further questions. So your question is a very good one, but they'd already made the decision to arrest, and the use of an ASL interpreter after that point would have been unnecessary because there wasn't going to be any communication with Ms. Draper at that time.
Sure, unless she had questions about her arrest, or why am I being arrested, or maybe what are my rights, or can I get an attorney, or should I call somebody, or.
And that all took place at the booking at the sheriff's office. But no, from a policy standpoint, you make a very good point. You know, should they just wait? And it could be very, who knows how long it takes, could be hours. But it's an excellent, question, but they considered that, at least I can only go by what the officers testified. I can't tell you other than that. And they basically said that the reason why they didn't bring one to the scene and why they called ahead for one to go to the jails, because they were not going to have any further discussion with her.
Thank you.
Pam, Ed, you've had your hand up, so Ed and then Tom.
Yeah, in the same vein as Commissioner Aspie's question, I think how do you respond to this, that you've set up a straw man by saying that the investigator has said that they should have had an interpreter before they responded to the call? I don't think that's true at all. And I'm not bothered by the fact that they exchange a note with her to enter the premises. It's after they interview the brother, the victim, that they make that decision. And this policy is just so clear. This is the SOP of the department during interrogations and arrests. The general rule is, and they know her condition. They can wait. There's no exigent circumstance in terms of, ongoing violence or confrontation that they can't separate people about. How do you respond to that, Mark?
Well, again, the SOP does say what it says, but they did not consider. They were doing an investigation, and I'm not going to mince words because you may feel like interrogation is the same as investigation. They didn't feel as though, and I'm only going by what they said to the investigator during the fact finding, they didn't feel as though they were interrogating anyone. They were basically just responding, and it was Ms. Draper who volunteered what had happened, and that she says, I need help. It was actually her saying, that it was her problem. She needed help with her son as opposed to vice versa. And it was during the investigation, not any interrogation and not any arrest, that it was determined that an assault had taken place. So you're right, Commissioner. If you read the SOP literally, arrest, okay, you have to decide whether or not the ASL is before the arrest, during the arrest, or after the arrest. The SOP is not clear. That I think that you could find that they followed the SOP because they made the arrest and then they provided an interpreter. I don't think you can interpret the SOP to suggest that if they are thinking of making an arrest or that they made a decision to make an arrest, that before they make the arrest, they have to have an ASL interpreter. That's not what the SOP says.
Thank you.
Please hold while we switch interpreters. Okay, thank you.
Yeah, good morning, Mark.
Good morning.
I'm looking at the investigator's report here.
Mhm.
And it characterizes the past interactions as not involving a potential arrest. I'm just curious, do you agree with that? There's a distinction between the past interactions and you know, this specific incident.
I think that I can't speak for the police, but and I don't remember each and every incident. It's all a matter of, I think that she was the one who actually contacted the police during the prior communications. One was like she happened to see someone at a store or at a mall. But I think that she was the complainant. She was the one who was making a complaint about someone else. So I don't think it's true. I don't think the investigator could conclude that they didn't involve the possibility of an arrest. For instance, one was to report a fraud on July 4th, 2019. You know, fraud, that's the crime. Another one is a reference to sexual harassment. Well, harassment is a crime. So I don't think you can conclude necessarily that those could not have resulted in arrest. They didn't. But I don't think that a police officer who goes and responds to a scene knows one way or another whether they're going to affect an arrest. I think the difference is that it was, in this case, someone else, it's Sue Draper's daughter from another state that called 911. Whereas in previous instances, it was Sue Draper who actually made the initial contact.
Right. Is there anything in the SOPs that addresses the sort of exigencies that you're describing and that you set forth in your paper?
The SOP is short. And it just says that with respect to it's basically I think there's some judgment that needs to be exercised on the part of the officers in this case. There are some sort of hard and fast rules, for instance, like if someone asks for one, you have to provide one, right? Even if, like in this case, okay, had she didn't ask for one initially, and it was only after she was arrested that she asked for one and it was provided. If she had, opened the door, gave the notebook, and then changed her mind 30 seconds later and said, I want an ASL interpreter, they had to stop right then and there. So in this case, it always says that the ADA requires the express choice of the individual with disability who is in the best position should be given primary consideration. For example, if an individual requests an interpreter, one should be provided each and every time. If one is not immediately available, the individual should be detained until the interpreter arrives. So that kind of dovetails with Commissioner Ashby's question and Commissioner Davis, should they, in hindsight, to me, that's the only issue. In hindsight, after they arrested her, whether they should have not transported her and waited for an ASL to arrive before they transported her. It wouldn't have necessarily changed the decision to arrest. She was under arrest.
Right.
At that point.
But and I don't want to get too far in the weeds of it, but the SOP say during investigations and arrests, the general rules that a sign language interpreter is necessary. Right? It used the word necessary. Doesn't say anything about a request. right? It just says it's necessary. So I guess what I'm wondering is, and I don't think there's anything in the SOPs about it from
Right.
comments, but what I'm wondering is if an arrest, if it becomes clear to the officers there's going to be an arrest, at that point, shouldn't that trigger an effort to get an ASL interpreter per these SOPs?
And that's what they did. They did. They called ahead. And the issue is whether or not they should have sort of sat in her apartment and waited for an interpreter to come to her apartment versus transporting her and then having the interpreter deal with her at the jail. The fact that the arrest, it's illogical to conclude that had an ASL interpreter been provided to her after she was arrested, that she was going to convince the officers to not arrest her. That, I think that's illogical. But it could be like in any SOP. This is a guidance.
I think the argument is that if she can't communicate her side of the story effectively, right, because she doesn't have an interpreter, then she's compromised. I think that's
I agree with you.
right.
I absolutely agree with you.
Right.
Yeah, but if you look at the notes back and forth, the notes between her and the police officers before, and they testified to this, that most of the discussion that day was with her son. And they basically accepted his word that their mother hit him in the face with a closed fist. And he had evidence of that. So they didn't really need to talk to her, because if she denied it, then it would have been, he said, she said, and then they would have had to make a decision to arrest. So they really didn't. I think we're going too far into how much communication did in fact occur between her and the police. And the answer is not much. I think the investigator will agree with that. It was very, very limited.
Thank you.
Yes. Can I ask a question of Barbara? I can ask. I had this in reading the case, I had the issue, and it's pretty basic. I had the question. An SOP in Ellsworth, is it the same SOP throughout the country? And is it based on ADA? And so is this case really hinging on the SOP or what?
I don't have any idea whether the SOPs are the same across police departments, but I do not believe that this case hinges on the SOP. Okay. You will have about 2 minutes.
Thank you.
Now we have Peter Rice for the complainants.
I gotta put my hearing aids back in. Please give me a minute.
Ready?
Yes.
Okay.
Morning. My name is Peter Rice. I'm a lawyer. I represent Sue Draper. Obviously, we agree with the investigative report that the Ellsworth Police Department discriminated against Ms. Draper by not providing an interpreter. A couple things I want to point out. It seems to me that this is the first time that Mr. Franco raised the that this is an exigent circumstance. First of all, the assault occurred the day before. Then after getting the call, it took them over 30 minutes before they left the station. Those are not exigent circumstances, facts. And then missing from the police report that was included in the record was when Ms. Draper's daughter, Crystal, called the Ellsworth Police Department. She told them that her mother was deaf, she did not lip read, and they needed to provide an interpreter. They ignored that. I mean, it was a domestic assault. that was the investigation. And the discussion around that, the policy, you're talking about the policy regarding people with disabilities. If you look at the policy regarding domestic assault, it says that if any of the parties are limited English proficiency, which Ms. Draper is, then you halt the investigation until you get an interpreter. So that is addressed in the domestic violence policy. Second of all, they knew they were going to arrest her, that was probable. If you look at the appendix 3, the predominant aggressor analysis, it leads to the arrest. I mean, our society's, how we treat allegations of domestic assault has evolved over the years. And the policy seems to be that people who are accused of domestic assault are arrested. To say this, first of all, and addressing the issue of the prior incidents, yes, Ms. Draper had a number of interactions with the Ellsworth Police Department over the years. A number of those did involve interpretation services. One of the officers said, what's that computer? She was talking to an interpreter on the computer. There were instances where, the times when she approached an officer at Pizza Hut. No, when she went to the station to allege fraud, no, she did not have an interpreter. But the other interactions did involve interpretation. I think it's really ironic that when the officers left, they told the dispatcher to radio ahead to tell the jail that they needed to get an interpreter, since they didn't get an interpreter, but they should have. The obligations of effective communication fall on the Ellsworth Police Department in this instance. The rules around effective communication, the Ellsworth Police Department's policy around people who are deaf, pretty much mirror their obligations under Title II, the Making Human Rights Act, Section 504. But they ignored those. They ignored those by not providing an interpreter for her when they knew. In the police report, there's a comment by Sergeant Wilmot that said, "We know she's deaf, but she doesn't like law enforcement." It shows some prejudice towards her. Yes, and she did ask for an interpreter. During the fact finding, she said every time that she's had interactions with the Ellsworth Police Department, she's asked for an interpreter. She uses sign language. They didn't know what she said, but she asked for an interpreter. And then in the notes, she did. Police breaking the law, no ASL interpreter. Police not allowed in without ASL. You not giving me my rights. So that's a request for an interpreter. She doesn't say, I request an interpreter, but she doesn't need to use those words. I don't think it really would have worked for her to tell the police officers not to come in. Yes, and she's, and again, looking at the policy, the Ellsworth Police Department policy and the law, the regulations governing effective communication, the length, complexity, importance, and context, those are important considerations. None of the prior interactions involved a situation where she might be arrested, or it was probable she was going to be arrested. Her liberty was at stake. She lost her children, so her children were at stake. Those are two fundamental rights that we have. And if you're going to take those away, you need to provide an interpreter. The importance. No interaction she had with the Ellsworth Police Department was important as important as this interaction. This was the most important interaction she had with them. It demanded that an interpreter be present. The Ellsworth Police Department failed to provide that. I guess I'm done. Unless anybody has any
Other
questions.
questions, anybody? Seeing,
Maybe just one question.
oh, okay.
Yeah, so I'm just curious. I mean, is it your position that Ms. Draper was not able to effectively communicate with the police via the notes as she had done before?
Yes, she's a person with limited English proficiency. English is not her first language. American Sign Language is her primary method of communication. And American Sign Language is not signed English. Those are two different things. ASL, American Sign Language, has its own grammar, its own structure. It is not English. So yes, those are two, fundamentally different things.
Thank you.
Sure.
Okay, seeing no further questions, you'll have 7 minutes
All right.
if you want them.
I want them.
No.
No, you don't.
Okay, Mr. Franco, you have 2 minutes left.
Thank you. Hopefully these are in the record, the police reports and the narratives, but I'm looking at them and I'm looking at sort of the 911 dispatch, and I don't see anything in here about the daughter. And I'll stand corrected, Peter. I don't see anything in this about the daughter saying that the mother needed to have an interpreter. The only reference in the timeline is at where it says after they arrested, advise the jail they will need an interpreter. And that, but that was after the fact. So I don't know, where that comes from. The sum and substance of the entire discussion with Ms. Draper was in the report. We were met at the door by Sue Ann and asked her if we could come in. We had to communicate by writing on a notepad because she is deaf. She told us to come in because she had been having trouble with son. Sergeant Wilmot spoke to son, and I tried to talk to Sue Ann. Sue Ann stated that that the son worries about and can't sleep. Further wrote that he doesn't take his medications and his mood is up and down because of it. She took some medications out of a cupboard in the kitchen and showed them to me. And then he went on and talked to another person, Therese. And then Sergeant Wilmot hadn't even talked to her.
I'm going to ask you to not use all.
I'm sorry, yeah,
names.
it's so hard sometimes.
Yes, I
But
know.
the police officer said he never did. There was only one of the police officers talked to her. The other one was talking to the other people. So again, it goes back to the issue of very limited contact communications took place, and at no time until after the arrest was there a demand, if you will, for an interpreter.
Great, wait. Any questions? Now you can go, seeing none.
All right, and now we'll hear from the investigator.
Nope, now we
Oh,
have.
I'm
Mr.
sorry, forgive me. I'm sorry.
I still have 7 minutes.
That's
Joe.
true. We're gonna hear from Mr. Rice for 7 minutes.
I probably won't use them all.
Okay, excuse me, we're gonna swap interpreters real quick during this little break. Ms. Draper, can you see me clearly? Okay, all right, we can go ahead and proceed.
Crystal sent me an email that said when she spoke to the Ellsworth Police Department, she informed them her mother was deaf, did not read lips, and they needed an interpreter. Because it doesn't appear in the police report, it doesn't mean it didn't happen. The obligation is on them, is on the police department to provide. Now, violation of policy is not against the law, but violation of the law is against the law, and the Maine Human Rights Act, the Americans with Disabilities Act, and its implementing regulations, and Section 504 which includes Ellsworth PD. Those all require the police department to provide effective communication that she can understand. I mean, effective communication is communication that as we would communicate. That's to level the playing field. That's the point. That's what's going on. This was obviously not. And Miss, you know, it's interesting. He said never did Ms. Draper request an interpreter. She during the fact finding, she said she did, but she did it in sign language. And again, what they interpreted that as gestures, but she requested an interpreter. So, thank you.
Commissioner, questions for Mr. Wright?
Is that the reference in the report? I guess there was a reference in the fact finding that she's trying to communicate in pantomime and gesture, and that's what you're describing here. She's trying to communicate silently.
In the report, I saw that. I don't know what. I mean, obviously, she was trying to communicate during the entire time the police was there. Sometimes with notes, sometimes with ASL. There's a kind of a hybrid, or another communication is called visual gestural, where you like boat, you make the movement of a boat. So I don't know whether she was using visual gestures. I mean, pantomiming and gestures is really kind of insulting for a person that's using American Sign Language. This is, she's not play acting. She's, this is communication, and at risk is her liberty and her children.
You're firm on the fact that she tried to use sign language when communicating with these officers?
Yes.
Okay, thank you.
Oh, other questions before I walk away?
No, I think we're good. Thank you. Now, Jeff.
The investigator.
There we go. Thank you. Good morning, commissioners, and good morning to the parties. Just to cover a few areas. At the time the police department headed to complainant's home, they had received a report from her daughter that complainant had allegedly punched her son in the face and blackened his eye. The police department also had a picture that had been forwarded from the son to the daughter and then eventually to the police department. So at the time they went to the residence, we're not dealing with simply mere hearsay. They had an actual picture of the bruise that was allegedly had occurred in this case. So they went there with at least a good reason to believe that she had physically assaulted her son, and that arrest was certainly a possibility, if not a probability. There were a number of prior interactions with the police department. On the majority of those occasions, Ms. Draper had used a video phone service, and at least on 2 occasions had used written notes to assist in communicating. None of the prior incidents appeared to involve solely the exchange of notes, and certainly none of the prior incidents involved any type of likely arrest. They were the majority of which she was making a complaint about other people and not that she would be subject to arrest. It is true that the officer did write a note asking if they could come in, and she allowed that. She had represented at the fact-finding conference that she believed that the police may have been there to assist her with dealing with the son. There was nothing she indicated at the time that she had any reason to believe that they were there to interrogate her or possibly arrest her. In this case, the officer went upstairs, spoke with their son, then returned to the room with Ms. Draper and wrote that she was being arrested for domestic assault without ever actually speaking with Ms. Draper. Despite the officer writing in the notebook that he had, quote, spoke with both sides, you and your sons, that simply didn't occur here. The sole communication was via handwritten notes. And even in those notes, there's nothing therein that indicates that they ever asked Ms. Draper what had occurred. There was no reference to the assault or having any other type of contact with the son. So at most, again, I forgive my use of words, but she had described that, or the officer stated at the fact-finding conference that he got her version of the event as she acted out what had allegedly occurred. So in this case, again, it is clear, even according to the notes, that she did reference the need for an ASL interpreter. And there's nothing, as the commissioners has noted in the policy, that this request has to be made at a particular stage of the interrogation. It's very clear cut that the individual is the one to best determine what type of communication is needed, and that if one is requested, it needs to be provided at each and every time. And there doesn't appear to be any sort of a loophole that it has to be at a particular stage. So there was no guarantee that an interpreter could have been summoned immediately. But again, there was no effort to even make that attempt here, even after she clearly indicated that she wanted an interpreter involved. So for me, again, especially given the stakes of not only the arrest, but also the possible loss of custody that could have been involved here, this was certainly a serious enough situation that an interpreter should have been provided, even if that resulted in a brief delay. As complainant had noted, the assault had occurred allegedly the prior evening. It was not in the process when they arrived. And they did wait, again, approximately a half hour longer to go over there. So it wasn't a rush situation, it appeared from their standpoint either. So under these circumstances, it appeared to me that since the request was made and one was not provided, whether or not that was seconds before she was handcuffed or not, didn't change what the policy required.
Thanks, Bob. Questions for the investigator? Seeing none, thanks. So there is one recommended finding, so we are looking for a motion. Yeah.
I'll move that we find that there are, we find that there are reasonable grounds to believe that there was unlawful discrimination against the complainant on the basis of disability, and the claim should be conciliated.
I'll second that motion.
Okay, it's been moved and seconded to find reasonable grounds to believe that Ellsworth Police Department discriminated against Sue Draper on the basis of disability. A yes vote means that you agree with the motion. So a yes
Any
vote.
discussion?
Oh, right, that too. Sorry.
You just knew that there wasn't going to be any discussion, that's all.
Yeah, exactly. So Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
No.
Commissioner Walker,
No.
Commissioner Douglas.
Yes.
Okay, so the vote is 3-2 in favor of finding reasonable grounds. That concludes the hearing on this matter. Thank you very much, everyone.
Thank you, counsel. Do we have Amy back or?
We do.
Yes, we
Thank
do.
the good Lord.
The next case is E20-0454 Mark Brooks versus Evernorth Housing Vermont Northern New England Housing Investment Fund. This also is a reasonable grounds case, and as a result, we will hear from the respondent.
Excuse me, may the interpreters be dismissed?
Yes, thank you so much.
Thank you so much for your service.
Barbara, thank you.
Thanks.
I don't know if you have anyone, I don't know if we have our folks remotely or if anyone's in person. We should have, Maria is on here remotely, and Mr. Gleason, are you on?
Good morning.
I'm just checking to see if respondents council is here.
John Gleason here.
Yes, excellent. Okay, so let's bring you into the room. Got him, Chelsea? Because we're going to hear from respondents council.
All right, you all set?
Yes, thank you.
All right, so this is 10 minutes, correct, now that the interpreters are not here?
Yes.
All right,
Folks, to keep it as brief as you can, because we're already behind schedule and we get a lot of cases.
understood. I'm John Gleason. I represent Evernorth and its two predecessors, Housing Vermont and Northern New England Housing Investment Fund. We did submit a written response to the investigators' report on October 26, and I recognize you have that before you, and I won't try to repeat it. I just want to highlight a couple of the objections which we have to the report. These are findings which we believe are not supported by the parties' submissions in this case, but they nonetheless go to the investigators' conclusion that there are reasonable grounds for believing Evernorth retaliated against the complainant. I raise these objections. I do want to acknowledge that the investigator, Ms. Burns, did prepare a full and comprehensive report on a complicated subject area, the working of the low-income housing tax credit system. And she did describe accurately the federal tax credits that are issued to state governments, the awarding of those credits to low-income housing developers, and the process by which entities like Evernorth and its predecessors over the years have put together investment funds to allow investors to draw on those tax credits, and how those investors are incentivized to invest in low-income housing projects. The respondents in this case, including the predecessors, have been involved in putting these funds together for the last 30 years. In the time I have, I want to highlight those instances in which the investigators' findings are simply not supported by the record and the submissions of the parties. First and foremost, the report seems to have accepted the complainant's belief, his assumption, that 1/3 of the housing projects in the fund being put together by Evernorth needed to be based in Vermont, and that Evernorth was wrongfully giving assurances to potential investors, to the banks, that they could rely on this 1/3 in Vermont allocation, and that these investors were enticed by these assurances to invest, when in the complainant's view, there was little chance that Evernorth could ever be able to meet this level of Vermont participation. And in the report, the investigator seems to have accepted Mr. Brooks's belief in this supposed 1/3 in Vermont requirement when she concluded that he established a prima facie case. The report said he had a reasonable belief that 1/3 of the tri-state investments would have to be in Vermont. And that represents a fundamental problem with the prima facie determination. There was never a 1/3 in Vermont or a 1/3 per any state requirement in the fund. For this fund or for its prior funds or anything developed afterwards by these respondents, there were no assurances given to financial investors about percentages or fractions by state or of individual housing projects by state. The documents from Evernorth, including the document that the complainant was working on, directly contradict this belief of his. The early informational materials, the promotional materials, gave no assurances of a 1/3 or a percentage allocation per state. And the private placement memorandum that he was working on, which was a template from prior funds, explicitly stated in this fund and in the prior fund that this was an unspecified property program. That's the so-called blind fund. And that means a blind fund or an unspecified property program means that investors are not assured of the inclusion of any particular project, but instead they rely on the track record and the history of the fund managers in making sound investment decisions. The PPM, the private placement memorandum, goes on for a couple of hundred pages of explanations and disclosures and disclaimers, but nowhere in that PPM is there any reference to any percentage or fraction of projects coming from Vermont or from any other state. And as we've pointed out in our written submission, in order to establish a prima facie case of retaliation under the Whistleblower Protection Act, the employee must have made a good faith report of what he reasonably believes to be a violation of law. He must subjectively believe it to be unlawful, and the belief must be objectively reasonable. It's our position that he alone believed that Evernorth was acting unlawfully, but his belief was not objectively reasonable. He seems to not have understood that the investors, the banks, close into the fund first, They do so based on the PPM, the private placement memorandum, a document that promises them nothing in terms of percentages or fractions of projects per state or any particular housing projects. And then after the investors close into the fund, the individual housing projects close into the fund in the year thereafter. So they have a 2-year window, the individual housing projects, between inception of the fund and when they close into the fund, and that's well after the investors close. The complainant seems to have thought alone that if a project was listed in the PPM as a, quote, possible project, it had to have been awarded tax credits and received the requisite permitting at that point. But again, that was not true. These listed possible projects were all at varying stages of readiness. They were listed as possible. And in a number of instances, the individual projects that eventually became part of the fund did not get those tax credit awards until 2021, a year later. And the complainant seems to have believed, again, without basis, that in order to list a project as a possible project in the PPM that he was drafting, the project needed to have closed into the fund before the investors invested their funds. But again, the investors closed. The deadline for them, for the investors, was January of 2021. The individual housing projects had the deadline of January 2022 to close into the fund. That was by the express language of the document he was drafting. And so that's our principal objection. After all of the submissions, the informational and promotional materials, and the PPM itself, the investigator still found that Mr. Brooks had a reasonable belief that 1/3 of the projects would have to be in Vermont, and that in his view, the projects would not be able to close in the requisite time frame, which he thought wrongfully needed to be by the investor closing deadline. But given the communications that were actually made to investors, this belief was not objectively reasonable. Finally, and briefly on the issue of termination, I just want to point to the record. The complainant says he first reported his concerns over Evernorth's conduct, his concerns over fiduciary conduct at a meeting with the co-presidents in January of 2020. That's where he first raised it, and says this is the start of his protected activity for which he claims he was eventually retaliated against. He doesn't point out that at that January 2020 meeting, after raising these concerns, he was promoted during that meeting to vice president of underwriting. He continued to raise concerns over the next few months. But what we want to address and point out is that it was the complainant who unilaterally, who on his own initiative, came to his employer and proposed a 2-year severance package for his exit from the company. He told his employer it was not tenable to work there any longer. He said he had 9 out of 10 toes out the door. And with that, he requested a 2-year severance package. And the question we have is, did he, in fact, under the law, suffer an adverse employment action because of concerns he was raising about unlawful conduct? In other words, was his separation the result of his employer retaliating against him? Or did the complainant actually walk himself to the door? Did he resign, or did he and his employer, given what he brought forward as a 2-year severance package and his statement that it was no longer tenable to work there, did they conclude together the relationship was at an end? So with that, we request that you not adopt the investigator's conclusions and that you determine there are not reasonable grounds to believe that Evernorth unlawfully retaliated against Mr. Brooks. And I'd like to reserve a couple of minutes if I do have the time.
You have about 50 seconds.
All right, thank you.
Yep. Then we turn to, oh, sorry, Commissioner questions for Mr. Gleason at this time. If you have them, raise your hand. Seeing none, you will note me markedly trying to scurry everybody along. Ms. Fox.
Yes, thank you. Good morning. My name is Maria Fox, and I represent Mark Brooks, the complainant in this case, who's here on the Zoom today. We are asking you to adopt the investigator's fair and reasoned recommendation reached after pouring through a robust record, including an expert witness opinion on securities law, and a full fact-finding conference with key witness testimony. This is a classic whistleblower retaliation case under Maine's Whistleblower Protection Act. To summarize, on June 2nd and June 3rd of 2020, Mr. Brooks sounded the alarm in an email to his supervisor, and then he forwarded it to the co-presidents of the organization, that the respondents were engaged in illegal conduct to deceive investors and that they were violating their fiduciary duties. He said if they didn't fix it, he needed out, and he proposed a severance. He said he couldn't be a party to the investor deception. This sounding of the alarm in June of 2020 was different than the January 2020 meeting that Mr. Gleason referenced, where Mr. Brooks did raise some concerns, but he raised them as potential lapses and irregularities in the underwriting. It wasn't until the June 2nd and 3rd email that he said, look, I think you're engaged in investor deception and you're violating fiduciary duties. 3 business days later, after he sent the June 2nd and 3rd email, he was fired as a direct result of those emails. As reported in those June email, Mr. Brooks's chief concerns were that in the spring of 2020, the co-presidents had directed him to include in a project pipeline that was attached to a private placement memorandum that he was working on. They wanted him to include in that pipeline Vermont projects that the co-presidents knew could not possibly close into the fund as the fund was set up at that time. The PPM was in draft form at that point, but ultimately this is a document that would be finalized and sent to investors. Later, at an acquisitions team meeting on May 28th, 2020, Co-President 1 referred to those Vermont deals on the pipeline document for the PPM as, quote, our dirty little secret, meaning it was secret among staff, but not to be shared with investors, that these Vermont projects would not close into the fund. Co-President 1 did not deny that he used that term at the meeting. He said he didn't recall and said that, very likely he could have made it. And if he did, that it related to internal communications to attract investors and development partners. Now, why did the co-presidents direct Mr. Brooks to add these Vermont deals to the PPM pipeline? They wanted to showcase approximately 1/3 of deals in each of the 3 states that they covered, New Hampshire, Maine, and Vermont, in order to attract investors. And we know this based not only on common knowledge through the organization, but it's evident by the number of projects listed for each state on the PPM, marketing materials that respondents sent to investors the month that Mr. Brooks was fired, and the number of Vermont projects the co-presidents directed to add to the PPM. There was no reason to include these projects in that PPM except to attract Vermont investors to invest in the fund under the belief that local projects would be included and allowing them to receive highly coveted low-income housing tax credits. Mr. Brooks and the co-presidents knew that at that time, the Vermont deals could not close into the fund because Vermont issues low-income housing tax credits only once per year, and that window had passed. So no credits could be allocated for these projects as the fund was configured at that time. The next time around would be March or April of 2021 for 2022 tax credit allocations. So when Mr. Brooks left this May 28th acquisitions team meeting, he was shocked and alarmed at Co-President 1's dirty little secret statement. As far as he was concerned, this was an explicit statement of intent to deceive investors. So he promptly reported it to his supervisor and to the 2 co-presidents in his June 2nd and 3rd email, and he was fired as a result of those emails. The crux of respondents' objections to the investigator report are that Mr. Brooks had no objectively reasonable belief that the respondent was engaged in illegal activity. The respondent acknowledges that the law is clear that Mr. Brooks doesn't have to prove that he was right that the law was broken. And they don't seem to be disputing that Mr. Brooks had a genuine belief that the respondent was engaged in illegal activity. They're saying Mr. Brooks was not objectively reasonable in his belief. But the objectively reasonable standard is not a high hurdle. It provides a guardrail so that matters that are reported to employers that are obviously not illegal don't get whistleblower protection. In no way does the objectively reasonable standard apply to situations that may require a battle of the experts on what is or isn't illegal on a thorny legal topic like securities law. Here, Mr. Brooks has provided an expert opinion from John Geismer at Norman Hansen Detroit, who practices securities law. This is a
Please don't use third-party names.
Oh, excuse me.
Thank you.
This is a complicated area of law, and so the expertise of this witness is helpful. This witness gave his opinion based on what Mr. Brooks knew at the time of the June 2nd and 3rd email, which is the appropriate time frame to consider in determining whether Mr. Brooks had a reasonable belief that his employer was engaging in the illegal activity. The expert witness wrote, "These facts could reasonably be determined to constitute a violation of the Securities Act of 1933 as amended." Mr. Gleason, respondent's counsel, is asking you to second guess an expert in the field of securities law, to ignore the dirty little secrets comment, or accept the co-president one's speculation on what it meant. He's also asking you to consider information about what happened after the fund, after Mr. Brooks was fired, what happened to the fund after he was fired. But that makes no sense when we're talking about what Mr. Brooks reasonably believed at the time he made the report. Mr. Gleason's asking you to raise the bar on what a complainant must prove to be protected under the Maine's Whistleblower Protection Act, such that the complainant would have to prove that they were right. And I think Mr. Gleason used the terms that Mr. Brooks seemed to not understand how this worked. That's not the standard. The law is if he had a reasonable belief, he's protected. This is far from the type of case where the objectively reasonable guardrail comes into play. And the respondent has offered no legal authority to support that it's warranted here, especially where there's a supporting expert witness on a complicated area of law. Based on Mr. Brooks's June 2nd and 3rd email, the dirty little secrets comment, as well as the expert opinion letter, there is more than a sufficient basis to satisfy the requirement that the complainant had a reasonable belief that the respondent engaged in unlawful activity. There's also strong evidence in the case to satisfy the two other elements, the adverse action and the causal connection. Mr. Brooks was fired and he was terminated as a result of his sending the June 2nd and 3rd email just 3 business days later. I think that the evidence on those two elements is well laid out in the investigator's report, but I'd be happy to answer any questions. Commissioners, we view this as a classic case of whistleblower protection, a whistleblower retaliation, and we ask you to find reasonable grounds that the respondent retaliated against Mr. Brooks when it terminated his employment in violation of the Maine Whistleblower Protection Act. Thank you.
Thank you, Attorney Fox. I see 2 hands already, so I'm going to start with, I saw Mr. Douglas first and then Mr. Ashby.
Yes, Attorney Fox, good morning.
Good morning.
Yeah, I'm troubled by the adverse employment action element of your claim. I mean, the report is pretty clear that, you know, at some point your client pretty much says, you know, I can't work here anymore. He basically says you guys are unethical and this is not the kind of place I want to be and all this kind of stuff, and proposes a severance basically. And, you know, 9 of my 10 toes are out the door, I think was the quote, right? And so, I mean, isn't this more like a mutual parting of the ways? You know, he doesn't like, your client doesn't like the company anymore. The company decides that, you know, if this is what you think of us, then maybe we should move on. I mean, isn't that more sort of what we're looking at here? Help me out.
Not at all, and I appreciate you raising that question. So at the fact-finding conference, Mr. Brooks described the meeting on June 8th that he had with co-president 1 and a colleague who was assigned to serve in the HR role for that meeting. in which he was terminated. At the meeting, there was some discussion about how can we still work together? But the co-president one made no effort to allay any of Mr. Brooks's concerns about the investor deception that he was raising or the breach of fiduciary duties. He didn't tell him he was wrong. They did not converse about this. And at the end of the meeting, Mr. Brooks was getting the impression, because he was offered 8 weeks severance during that meeting, and that wasn't going to work for Mr. Brooks. He wanted them to either change what they were doing, or he couldn't be a part. He didn't want to, couldn't be a part of the investor deception. So he clarified with co-president one, are you telling me that I should be out by the end of the week? And co-president one said, yes, that would be a good idea. This was followed up with a letter that says, you're terminated. And I'm reminding you, you're an at-will employee. Mr. Brooks immediately sent an email to the HR person who was in the termination meeting saying he'd been fired for raising issues of fiduciary duties. He sent the same thing to his supervisor. Nobody told him that he was wrong. No, you're resigning. The Maine Department of Labor found that he had been terminated when he applied for unemployment benefits. I mean, this is clearly, we view it clearly as a termination. However, if it's found to be, the other way you could think about it is that this is a constructive termination, if not an outright termination. It's a constructive discharge, because Mr. Brooks believed that if the organization did not change the way they were handling this fund, that there were illegal issues going on, and so he couldn't be a party to that. And so if they weren't going to change it, I think that supports a constructive termination, which is another way to prove the adverse action element.
Thank you.
Commissioner Ashby and then Commissioner David.
Just very briefly, I'm a little unclear about what the activity was that caused your client concern. There's a focus in the investigator's report of this belief on the part of the complainant that there's a requirement in this fund that 1/3, it's apparently allegedly a programmatic requirement that 1/3 of the properties needed to be in Vermont, and the respondent's submission seems to pretty strongly suggest that that's just not true. First of all, before we move on, is it the case that there's a requirement that 1/3 of the fund needs to be invested in Vermont?
Well, let me address that, and then I think hopefully I'll address the root of that question. So Mr. Brooks, and based on the evidence that I had outlined, indicated that roughly, it wasn't exactly 1/3, but the idea was to attract investors in each of the 3 states, and that this was something that he said what he testified was common knowledge around the organization and bore out in the documents that he was working on. Now, what he was actually blowing the whistle on was not that, hey, you don't have 1/3, 1/3, 1/3. What he was blowing the whistle on was the fact that the co-presidents were asking him to include projects on this private placement memorandum that could not close into the fund based on the way that Vermont allocates the low income housing tax credits. So that's what he was blowing the whistle on. He wasn't blowing the whistle on you don't have 1/3 of the projects to spread around the state.
Well, I don't want to belabor this, but that seemed to be, at least in the investigator's report, what your client was saying is that he understood that there was a programmatic requirement or a regulatory requirement that required 1/3 of the properties to be in Vermont. And I understand the respondent to be saying that's not a reasonable belief because that's not factually accurate. And so you're saying, no, that isn't the case. It's more a broader investment. It's a securities fraud issue because it's fraud on the investors to represent there are any Vermont properties in the thing when there aren't. Is that, am I putting it?
Yeah, yes, to represent, I mean, there are projects that are, as I understand it, there are projects that can be put in this pipeline document that's attached to the private placement memorandum that alerts investors. These are projects that may reasonably close into the fund. right? But what Mr. Brooks was saying is that they had him include projects that could not reasonably close into the fund as it was configured at the time that he was employed. That was what he was blowing the whistle on. And the 1/3 piece really was to explain, well, why, what would be the motive of them putting Vermont projects on that couldn't close into the fund.
I see.
That was his understanding, but the actual illegal, what he was raising that was illegal had to do with putting on that document projects that everybody knew internally to the organization could not possibly close into the fund. So that was the investor deception.
But counsel for the respondent in his submission and then in his presentation today represented that it was a closed fund and always, a blind fund and always had been, meaning that no such representation was made to investors. Is that factually accurate or not accurate?
It is accurate that it is a blind fund. However, the investors are provided with a copy of the pipeline with the projects. And there's also evidence in this case that the month that Mr. Brooks was fired, they sent out marketing materials with a list of projects that were associated with this fund, and that included a list of Vermont projects that could not possibly close into the fund as it was configured in June when they sent out those marketing materials.
Okay, thank you.
Commissioner Davis?
Thank you. Counsel, is there a state or regulatory agency that has jurisdiction over these securities?
Yes, the SEC.
And no complaint was made to them?
Yes, there has been a complaint made to them.
Before this complaint was made?
Before, I believe the timing of the SEC complaint was made after the Maine Human Rights Commission complaint was made.
Is there any action on that complaint? That's not in the record, I guess, I'm sure.
I believe we did. I believe we did inform the investigator, and yes, that there was an SEC complaint that had been filed, and it's pending. It is not, to my knowledge, it is still pending.
And there's a board of directors and no complaint is made to them, correct?
To Mr. Brooks's knowledge, Mr. Brooks did not make a complaint to the board. We do not know what the board knew or when.
Yeah, that's what I'm asking you. Mr. Brooks did not make a complaint to the board that this was an illegal activity.
Correct.
Right. Okay. And is it the case that 5 out of the 6 of those funds that were listed did close into the fund?
That is what respondents represented, but again, that is information that occurred following Mr. Brooks's termination. And really what I think the job of the commission is to determine what did Mr. Brooks know and understand at the time that he made the report. So the fund can change, right? They have the ability to change some of the timing of the fund. And so there are things that respondent has alleged that occurred after Mr. Brooks was fired, but they knew not only that Mr. Brooks had raised this in June, but they knew almost immediately after he was fired that he retained counsel and was filing a complaint with the Maine Human Rights Commission. And so what they did after he was fired with regard to the terms of the fund, we do not think is relevant here.
The law is that the violation that we're talking about needs to be a violation of law or a condition jeopardizing the health and safety of employees. And that health and safety seems to be the thrust of it. I agree that it also says a violation of law. Can you point me to a chapter and verse, a legal citation of the law that he reported was being violated? It seems to me that you're asking us to second guess what might be a complicated Securities and Exchange Commission decision down the road, that he's in a discussion with the presidents and there's a disagreement.
Commissioner,
So the question is, can you give me a specific citation as to a violation that he reported?
yes, I can. And that is why we retained an expert witness regarding securities law who gave the opinion that based on the facts and the record, based on what Mr. Brooks knew at the time that he made the report, was that these facts could reasonably be determined to constitute a violation of the Securities Act of 1933 as amended. That is a violation of law, and that is clearly a basis upon which to obtain protection from retaliation under the Maine Whistleblower Protection Act.
And you hired an expert that came to that conclusion, correct?
Correct. To help with this complicated area of securities law, because it is complicated.
Oh, I agree. It's complicated. And that's my concern, is that you're asking us unsophisticated commissioners in this area of the law to make a second guess a legal determination. But thank you.
No, I'm sorry. Actually, if I could respond to that, what we are asking you to do is to accept that Mr. Brooks had a reasonable belief. Whether he was right or wrong, that is not the issue. He gets protection from retaliation under Maine's Whistleblower Protection Act if he had a reasonable belief that there was a violation of law. We have an expert witness who said he had a reasonable belief that there was a violation of law, and it is the respondents who are asking you to dig into the weeds and say he didn't have an objectively reasonable belief that there was a violation of law. That, to me, requires you to second guess our expert witness, requires you to engage in a deep dive into securities law. And I just don't think that that is necessary or warranted in these proceedings.
Any other commissioner questions for Ms. Fox? Seeing none, you'll have about 30 seconds left when we come back to you. We're going to go back to Mr. Gleason.
Thank you.
We have just under a minute.
All right, thank you. First of all, on the third-party opinion letter, let me just say that what he indicated there was that there were non-complying Vermont projects listed as possible investments. And again, what bears emphasis is Evernorth had never made any assurances at all that these projects were ready for closing. The investors go by the track record of the fund manager. There were not representations in those promotional materials at the time of his separation from employment or in the PPM that said anything other than these were possible investments. And the closing for those projects was 2 years out. It was in January of 2022. And it does bear noting that Ms. Fox says these were projects after the fact. We were raising closings after the fact. There's a history at the fund.
Attorney Gleason, I'm sorry, but that's your time.
All right, thank you.
Yeah. Questions from commissioners for Mr. Gleason? Seeing none. Ms. Fox, you have about 30 seconds.
Okay, just very briefly, in response to Mr. Gleason said that these were possible investments, and Mr. Brooks raised that they were not, it was not possible for those investments to close into the fund, and that the co-presidents knew that, and that was the whole point. And the January 2022 deadline doesn't help either, because the next time the Vermont state authorities could issue these tax credits would not have been until March or April of 2021 for tax allocation credits in 2022. Excuse me.
Thank you.
Thank you.
Questions for Ms. Fox? Seeing none. Thank you to counsel. Let's turn to the investigator, Courtney Byrne.
Good morning, commissioners. My name is Courtney Byrne. I was investigator assigned to this case. I'll just say it was a closed case, and as I'm sure you're aware now, very complicated subject matter. Based on the information in the record, based on the information available to the complainant at the time, I ultimately came out with finding he had a reasonable belief to believe that potential violations of the law were occurring. I understand that projects closed into the fund later, but as mentioned earlier, that was after complainant's employment had ended. Other than that, I don't have anything else to add, but if you have any questions, I'd be happy to answer them.
Commissioner, questions for the investigator?
I just want to point out that was a really great report, and it looks like a very challenging investigation, Courtney. I'm impressed.
Thank you. I'm taking the thank, I'm saying thank you for her, as if I did it. Commissioner Walker?
Good morning. I'm not even sure this is appropriate on how to do this, but can we discuss footnotes? Footnote 14 on page 6 of your report, or on what we have. And it goes towards the 1/3, 1/3, 1/3, and that you concluded that complainant's belief was reasonable. If the 1/3, 1/3, as Attorney Gleason has argued, is not accurate, what helped you conclude that his belief was reasonable?
Sure. So based on complaints explanations of this being a tri-state investment fund and the projects listed on the marketing materials to investors that included projects from all 3 states, his explanation that Vermont projects would be listed even though the tax allocation deadline had not yet passed and was in fact later than the other 2 states' deadlines. The fact that those projects would be listed, even though based on the timeline that he was working on, they would not actually be able to close into the fund. That was a reasonable explanation to me as to why he would question why those projects would be listed. And in conjunction with statements made, referenced before the dirty little secret comment, although the person who said that comment said it wasn't necessarily meant in that context, in conjunction with that, and those projects being listed on the fund, or excuse me, on the marketing materials for the fund, and the expert opinion letter, that led me to believe it was a reasonable belief, ultimately.
Thank you.
Any additional commissioner questions for the investigator? Commissioner David?
Courtney, is he having an ongoing discussion with the presidents about his concerns that these are inappropriate things to put in the materials? It's more than one complaint, is it not?
Sure. So there was initial concerns about underwriting lapses that were raised in a meeting in January. And then I believe there was an email on March 31st, I believe. I have it listed on my report. Where he raised concerns about the timeline. Okay.
And what is the date of the, go ahead.
Oh, sorry, I just found it. Yeah, so it was March 31st, 2020. Complainant emailed co-presidents expressed concerns that Vermont's low-income housing tax credit allocations, based on that timeline, no Vermont deals could close into the fund. And in response, one of the co-presidents replied, "Let's make this an 18-month fund." And so it seemed to adjust the timeline based on those concerns.
Certainly the Vermont investors know the Vermont law and that they've missed the window of getting that credit that year, don't they?
I don't know if I can answer on behalf of them. I would assume that there's some
Maybe not.
awareness about the timelines, but again, based on the information that I had available, I believe his belief was reasonable.
What was the date? Another question. What was the date of the indication that he wanted 2 years severance?
So let me make sure that was in the email, because there's an email sent that was ultimately forwarded to the president. So
Well,
that was,
I want to ask about the first mention of severance. Was that 2 years or was that more?
So that was based on the record. So June 2nd, he mentioned
Of what
the
year?
2-year severance of 2020.
Okay, I thought there was something substantially before that, a year or two, about severance or leaving. When is the 10 toes, 9 toes out the door? What's the date of that?
So that would be the same communication on that same date.
Okay.
June 2nd.
Thank you.
Sure.
Any other commissioner questions for the investigator? Seeing none. Thank you, Courtney. So commissioners, at this point, you've heard from the parties and the investigator. There's one proposed finding. We would be looking for a motion.
I'll move. I'll move that we reject the findings of our investigator and find that there are no reasonable grounds to believe that respondent retaliated against complainant for engaging in WPA protected activity and that this complaint be dismissed.
I'll second that. You jumped in before I was going to do that, Jeff.
So it's been moved and seconded to find no reasonable grounds. Is there any discussion?
I mean, I'll just briefly say, I think this is a close case, but upon hearing the argument and reading the submissions, I think I disagree. I think there are reasonable grounds to find discrimination here, based on, you know, the reasonable belief of the complainant. I thought that the expert opinion offered by Attorney Fox carries some weight here, sort of resolves for me the issue of the objectively reasonable belief. And I think it's close, but I think there are reasonable grounds. So I'm gonna vote in the negative when the time comes.
Any other discussion among commissioners? Seeing none, the motion is to find no reasonable grounds. Oh, I'm sorry, Commissioner David, did you have something?
No, I'll let it go.
Okay. So if you are in agreement with the no reasonable grounds finding, you will say yes. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
No.
Commissioner Walker,
Yes.
Commissioner Douglas.
No, wow.
It's already been a long day.
I know I'm holding it too.
So the finding is no reasonable grounds. The motion carries with 2 opposed. And we thank the parties for attending, and the commission will send a letter confirming the finding. And with that, we're going to move on to, I'm going to try to move you as briskly as I can, even if you don't like it. So next.
Forgive me. The next case is MHRC number E200460, Christopher Fugere, forgive me if I've mispronounced your name, versus Patriot Mechanical LLC. This also is a reasonable grounds case, and we'll hear from the respondent.
Attorney Hoffman.
Yes, Executive Director Sneerson, can you hear me? I don't know what's wrong with my video, so I'll just do my quick intro and then I'll jump on my phone so that the commissioners can see me. I apologize, I'm not sure why it's not working, but you can hear me, correct?
Yep.
Okay. Good morning. My name is Attorney Kelly Hoffman, and I represent the respondent, Patriot Mechanical, in this case. This case involves an employee who is on a probationary status, and he worked for 24 days before he was terminated. He was terminated for a number of reasons, including, and this is the critical issue that we're before you today, not having a license to do his job. It would be a little bit akin to me coming before you right now and saying that I represent the respondent. And then today saying to you, I actually don't have a license to practice law, and my law firm has asked me to step outside the confines of my license. Or, Commissioner David, to your point in the last case in which you said you were unsophisticated commissioners, let's break it down to something that everybody understands. We all have licenses to drive unless something horrible's happened or you've just decided not to. If all of a sudden my employer says, hey, listen, I need you to get to the airport right now as fast as you can get there, and I drive, but I don't have a license, who ultimately is responsible for that? This case is as simple as that. This case claims that Mr. Fujari was asked to do work outside of his license. However, on day 2 of his 24-day employment, he allowed his license to lapse and didn't tell anybody. There is no subjective or objective way that he can avail himself of the Maine Whistleblowers Protection Act under the circumstances. My argument is as simple as that to this commission. Thank you.
Now that's the sort of brisk presentation we like to see. Thank you, Attorney Hoffman.
You're welcome.
Commissioner questions for Attorney Hoffman. Commissioner Douglas.
Yes. Good morning, Attorney Hoffman.
Good morning, sir.
I need you to clarify for me, I'm looking at footnote 3 in the investigator's report. And there's some language in there about how the master, whatever it's called, the master oil technician, right?
Yes, understood, sir.
Has a responsibility to sort of notify the agency that they're supervising this person. And because respondent didn't do that, the license was essentially in limbo. Can you give us your take on that?
Yes, sir. So let me back up some things for you very quickly so that you have additional background. Much like driving, or at least where I grew up, where I learned how to drive in Virginia, you had this 15 and 8 month period where you were overseen until you could drive by yourself. So you had to drive with your parents, Executive Director Sneerson, somebody that had a license and was old enough to supervise you. That's a lot like this case insofar as you need a master, and this man represented himself, the complainant, as an apprentice. So he stopped working, and that's in the file. He claims that he got laid off from fielding oil and propane. When he came over to the respondent here, who I represent, Patriot Mechanical, he claimed he had an apprentice license. And we checked that license on the day of his interview, which was February 19th, and his first day of work, which was February 28th. He claimed that he was going to keep his master during his probationary period time. And it's the company's practice, which we've admitted to throughout the conferences that we've had and in our writings to the Maine Human Rights Commission investigator, that during this probationary period, many times people do not switch over, and sometimes they don't switch over at all. So you need a master in order to do this man's job. And it is, according to that footnote, they're claiming they don't know when the complainant's license was inactive. We know that on February 19th, the day of the resume, to go to your point as to Exhibit 3, we checked it. We submitted documents to that. On his first day of employment on February 28th, we also checked it and saw he had a license. For the next 24 days, he didn't have a license. He let it lapse. And so the other problem that the respondent has, respectively and practically, is finding that there are reasonable grounds here has a practical implication of requiring respondents to go on every day. Is my law firm required to go on every day to check my law license? Is if I'm a truck driver and I need a license to drive the truck, is that something that the employer needs to get on there every single day? And the answer is no. If you look at the paragraph, footnote 3, which I agree with you is the most important part of this report, it says that Mr. Fujare, in that second paragraph at the bottom of page 2, the complainant is not allowed to work until such time as he acquires one. It is not the respondent's job as the employer to ensure that Mr. Fujare has a license. That is his. We submitted documentation to that. The Maine Fuel Board laws and rules in the application that he filled out, in the rules that he was to understand, require that says, Mr. Fujare, you are responsible for knowing and complying with all board laws and rules throughout your licensure. The respondent didn't have a license with the Maine Fuel Board. The company doesn't have to have oversight of this apprentice. That was all him. And he claims he didn't get an email. He claims he didn't know about the rules. He claims that he had no idea he wasn't out of licensure. Again, I submit to you, if I get behind the wheel of a car, like all of us do, I get pulled over and the cop's like, hey, you don't have a license. Can I turn around and be like, oh, sorry, my employer, my mom said it was okay if I drive. How is that going to avail me of the Maine Whistleblowers Protection Act? I hope that answered your question, sir.
Good enough for now. Thank you.
Any other commissioner questions for Attorney Hoffman? Commissioner Ashby.
Yes, maybe I'm misunderstanding something though, but regardless of whether he had a master from another previous company or somehow those duties were assigned to the new employer, your client, didn't your client have an obligation to provide an in-person, on-site supervisor for the work that your client sent him out to do?
I mean, I guess the answer could be yes, depending upon how the facts developed in this case. There's an open issue as to whether or not he could do an oil burning by himself. The fact remains that when he called and said that there were issues, people did come out and they fixed the work that he couldn't and didn't do. So for all practical purposes, it doesn't matter if the answer is yes or no, because he went out, the complainant couldn't do the work. And when he called out to say that he couldn't have either of the oil burners functioning, they came out and they fixed his work.
Thank you.
Sure.
Any other commissioner questions for Attorney Hoffman? Commissioner Davey.
Is it not the case that the complainant says that he told them before he went to that job that he couldn't do it alone without a supervisor? That was a safety issue, that it wasn't within his competence or licensure?
I mean, he didn't have a license, Commissioner David. So he shouldn't have been out there. He shouldn't have been working for 24 days. And I don't think I don't think he ever said that it was a safety issue.
He didn't have the apprentice license because it lapsed, but didn't he tell them that that job was beyond his ability as an apprentice, assuming that he did have a license, to do without supervision on the site as a safety issue, so he didn't blow up the house?
With respect to Commissioner, it wasn't a house, it was a community place, it's fine, right? I'm sorry, I don't mean to, none of that matters. So my response to you is he had no license. So what the complaint should have been is, I can't come to work today because I can't do the duties of my job. There's no way that I can even go out, period. We don't get to step C as to whether or not it's a safety issue and he's going to blow up the house. I don't believe he ever said that he was going to blow up the house.
No, I talk in hyperbole. I apologize.
Sure. No, I can be quite literal.
Any other commissioner questions for Attorney Hoffman right now? Attorney Hoffman, you will have an astounding minutes when you come back.
Thank you.
And then we will turn to Mr. I don't know if it's Dion or Dion. I apologize.
Dion.
Dion. Mr. Dion, you have 10 minutes.
Thank you. Commissioners, let's start from the beginning. An individual who has an apprentice license has the training and qualification to work as an apprentice. You obtain your license as an apprentice. An apprentice license allows an individual with proper training to be able to work on job sites, provided that he or she is supervised by a master technician. When an individual is hired as an apprentice, the employer is required to assign a master to work with that apprentice. An apprentice is not permitted to do the type of work that Mr. Fugier was being asked to do. The issue regarding the license that was raised during the investigation. And this is in the record. It was asked specifically to the Board of Licensure regarding the gap. It wasn't that he did not have a license. Records indicated that his license was, quote unquote, not active. When asked why that was the case, the Fuel Board responded, Christopher Fugier's apprentice oil burner technician license shows a status of not active from March 3, 2020 through the current due to his supervising master oil burners technician's electronic submission of non-supervision application regarding Mr. Fugier on March 2nd, 2020. Pursuant to the board's laws and rules, an apprentice oil burner technician must have a supervising oil burner technician on file with the board at all times. The March 2nd submission was from his prior employer. He no longer worked there, and therefore his prior employer said, we no longer have a master who is supervising this individual. It was then asked of the commission, was his subsequent employer required to assign a master technician in order to have him working as an apprentice? The Fuel Board responded, that is correct. Mr. Fugier had an apprentice license. When an employer like Patriot Mechanical hires an apprentice, they are required to assign him a master and to notify the board. The obligation is upon them. The job that Mr. Fujir applied for was for an apprentice position, an entry-level position that was advertised as requiring very little background. The claim today of not having a license should also be noted as not having been included in the letter with reasons of termination that was provided to my client, which wasn't provided immediately, although it was requested, long beyond the deadline required under the law to provide reasons for termination. The letter provided. He worked on 2 boilers at the Sebago Post Office, which were running before he serviced them, but afterward were inoperable. He likewise could not keep pace with the crew when he engaged in gas piping work. As such, representatives of Patriot Mechanical LLC determined that Mr. Fujir had overstated or misrepresented his skill set and was able to perform satisfactorily or adequately his job duties. And that is it. Very simply, my client had an apprentice license, was qualified to work as an apprentice. He applied for a job consistent with what his licensure allowed. He was hired by Patriot Mechanical, who was required to assign him a master technician and required to notify the board. They then, without having done so, asked my client to go out into the field and perform work that was beyond his apprentice license, and which created a danger to public health and safety and was a violation of the law. He notified his employer that he could not go out there and do that work. His employer insisted that he go. When he went out, he had issues on the job and he called and he got yelled at for that. And then he called again and he got yelled at again. And then they sent out a master who was able to get the burner working again, and my client was terminated. So under the law, it's quite clear here what happened. My client was hired for a position as an apprentice. Patriot Mechanical thought they could pay somebody a rate of an apprentice and send him out for jobs that he was not legally able to do. My client very clearly stated, I am an apprentice. I need a journeyman to do this job. The employer didn't like it. He repeated it. I should not be out here by myself. I'm an apprentice. I shouldn't be doing this job. They sent out the master technician, and Patriot Mechanical was unhappy and terminated him. Plain and simple. This is a very clear violation of whistleblower discrimination. And then after the fact, continuously keep changing the basis upon which he was supposedly terminated. Very clearly, my client had a license. It was active when he applied because he worked for Fields. Now, in this particular circumstance, the idea that my client needs to go back to his former employer, get his former employer to keep a master supervising him, not keeping track of him, literally supervising him on the job while he works for Patriot Mechanical, completely defies logic. This is a very simple case. I like to give credit to the investigator who actually, despite the fact that these claims kept being made in different formats, actually went to the fuel board and got very clear understanding of what the fuel board requires, what is an employer's obligation, what is an employee's obligation, what is a licensee's obligation, and adequately put that into writing into the investigation. So the only issue having been raised being that my client did not have a license is completely false. It was not active because Patriot Mechanical did not uphold its obligation under the law. I'll reserve the rest of my time, subject to any questions from the commissioners.
Thank you, Attorney Dion. Commissioner questions for Attorney Dion? Seeing none. You'll have about 4 minutes when we come back to you, Attorney Dion. Back to Attorney Hoffman, who has 8 minutes.
To just address, I hope you guys can see me now, to just address some of the points that were raised. Mr. Dion submitted to you that there's a rule or law that an employer is required to assign a master and that must be in that place of employment. We submitted testimony through the owners of respondent that it is not uncommon for a father and a son who may not work at the same place to be a master and apprentice. And so I'd like to know where that rule of law is that says that an employer is required to assign a master immediately upon employment. I don't believe that's accurate. And I think that's where the rubber hits the road on this case. Claiming that somebody's license to be an apprentice is not active doesn't change the fact that a non-active license means you don't have one. He may have claimed that he was an apprentice and stepping outside of his license, but he didn't have a license to do this job at all. Finally, I'd like to submit one more thing to you. Mr. Dion, and I believe the investigator gave some of this weight to the idea that the personnel file was requested and there was a delay in it. That delay deals with my office and me during the pandemic. It was during a time that we were platooning and there were delays of things. That has nothing to do with the respondent. As well, when he read the letter into the record to you guys, it said that Mr. Fujare had overstated and misrepresented his licensure status. That's completely accurate. And more importantly, the fact that we submitted testimony that showed after acquired evidence that Mr. Fujare had not only been aggressive and had a background with assaults, but also that he had stolen from the company, all of that should go to his veracity. That should be enough to say you need a license in order to do your job. And that's where you get to step A. You don't get to overstep step A and jump into step C. Thank you.
Any commissioner questions for Attorney Hoffman? We seem to have lost Mr. Dion.
He just got readmitted.
Okay, thank you, Chelsea. Commissioner questions for Attorney Hoffman? Seeing none. Thank you, Attorney Hoffman. Let me just make sure, hopefully, that Attorney Dion heard your presentation. Attorney Dion, did you have a chance to hear Attorney Hoffman's follow-up presentation?
I unfortunately did not. My computer froze somewhere in the middle of that, and I'm just reconnecting now.
Attorney Hoffman, can you summarize your points?
Gladly, Executive Director Sneerson. Jason, the points that I made were that I don't know where the rule of law is or the regulation that says under the main fuel board rules that an employer, as opposed to your client, is required to assign a master. My understanding of the rules and everything in the application and everything that's statutory law says that it is the licensee's job to make sure they have a license. To require otherwise would be a huge leap and a huge step and requirement for respondents moving forward. Think about the implications that would have in HVAC, nail technicians, chiropractors, law firms, medical hospitals, all these people. It would be insane to change that, delegate that back to the employer. The second thing I talked about was the fact that during the pandemic, my law firm platooned and some of us got. Yes.
I'm sorry to interrupt you, but I am not sure that that explanation for why the file was late is in the record. If it is in the record, I will gladly stand corrected.
This case has gone on for a really long time. So I definitely think that's in the record, but if it's not, it's fine. I just don't like the idea that my client is being tagged with some delay as if there's some pretext. That was the point of that. I'm happy to move on from it, Executive Director Sneerson. The other issue was the idea of saying that him not having a license was something that was presented later in the case, almost again as a notion of pretext. I think the letter that my firm wrote about his separation from employment included the fact that he overstated and misrepresented his ability to perform the job in his licensure status. So I think that the fact that he didn't have a license was clearly provided in that explanation. So I think those are all the points, Executive Director Sneerson, that I raised.
Thank you so much. I appreciate that. Okay, Attorney Dion, you have 4 minutes.
Sure. So just to respond, again, the master that is assigned to work with the apprentice doesn't simply act as a off-site supervisor, as somebody to generally keep tabs on an individual. They're required to be there on site to work with the individual. So to have the employee be put in a position of actually having to find a third-party master technician to work with him while working for another employer simply doesn't make any sense. The requirement is very simple. If you're going to have an apprentice working for you, they need to be supervised, and presumably as an HVAC company, you're going to have master technicians. You assign somebody that is responsible for the work and oversight of your apprentice, and you notify the fuel board accordingly. That is the practice. The suggestion otherwise, I would bring up the regulation here, but as I read, the email directly from the fuel board says it is the subsequent employer's obligation to notify the fuel board. So while I'm not able to bring up the regulations because my computer hasn't rebooted yet, the fuel board has indicated that the practice in the HVAC industry is that the supervisor notifies. Again, to have my client have to find his own master. And the interesting points here is that the employer does not indicate that they actually did assign him a master and that the master just simply wasn't listed with the state of Maine. Quite frankly, the only requirement for the apprentice license to be active was to have an assigned master. And therefore, on day one of the job, the employer should not have been sending Mr. Fugier out on jobs without a master to supervise him. And if they did have a master to supervise them, then they would have no reason to question the appropriate license status. It's also noteworthy that nowhere in the record is there a claim that on the date of termination that the employer suddenly learned that my client didn't have a license. Again, all of this information is purportedly obtained after the fact, after the termination. And so what's made very clear here is that the job that my client applied for was an apprentice position. The Patriot Mechanical, being in the HVAC industry, should have been very familiar or should have familiarized themselves with the process of hiring an apprentice, and that is to assign a master and to not send them on jobs that are unsafe or that their licensure does not allow them to do. In this case, there's no question that the jobs that Mr. Fugier was sent out to work on were beyond the scope of his license. And even if they were not, as Attorney Hoffman claims that it's a little bit more of an open-ended issue, which I suggest it is not, certainly my client's belief was good faith, because he certainly did believe that, in fact, he wasn't safe and he wasn't allowed to do it. He made that complaint, and he was subject to an adverse employment action immediately thereafter. So again, the obligation was on the employer. My client was clearly terminated for those reasons. The smoke and mirrors suggestion that, oh, don't look at the complaint. Don't look at what actually happened here. Focus on the fact that we have this non-active status for 24 days. And also disregard the fact that that's our obligation. So with that, I'll waive the remainder of my time unless there are questions.
Thank you. Commissioner questions for Attorney Dion? Seeing none. Thank you to both counsel. At this time, we turn to the investigator. Jane O'Reilly is presenting a report. I think that was prepared by a different investigator who left the agency.
Correct. Thank you, Amy. Good morning, commissioners. My name is Jane O'Reilly. As Amy mentioned, I was not the investigator on this case, but I have completely reviewed the file, and I was actually in attendance for this conference. And so I'm here presenting the report. I just have two comments to make, which is really just to refocus this case on the issue that we are that the report addresses, which is the reason for complainant's termination of employment. There's been a lot of discussion back and forth about the license, and I can certainly address what's in the record on that. But the issue of the license was not known to respondent until after they had terminated complainant from employment. So given that, it could not be a reason that respondent used for termination, and given the fact that the reasons were shifting and there were some after the fact reasons being presented, there was at least an even chance that it was complainant's protected activity that was the reason for his discharge. So again, I'm happy to address what's in the record regarding the license, but that's really what the issue in this case that the investigator was looking at was what was the reason that complainant was was discharged and found that it was more, at least it's like it was not, that the discharge was because of the protected activity.
Thank you, Jane. Commissioner, questions for the investigator? Seeing none. Thank you, Jane. So commissioners, we have one proposed finding and we'd be looking for a motion.
Yeah.
I move that we find that there are reasonable grounds to believe that respondent discriminated against complainant on the basis of the WPA, and conciliation should be attempted.
I believe I heard Commissioner Douglas second that.
Yeah.
Okay. So it's been moved and seconded to find reasonable grounds. Is there any discussion among commissioners?
I just want to say that I'm not saying that there's any comparison in the consideration and the decision between the two cases, but I can't help but reflect on the fact that this case compared to the case before it, this case is health, safety, violation of law, and report and retaliation, and all of those are clear. And that's what I thought relevant in this case.
And typically, it's a little, you're breaking up a little bit, but I think we got the gist of your comment, just giving you a heads up on your connection may be a little funky. Any other commissioner discussion on the pending motion? Seeing none. So the motion is to find reasonable grounds. So there's been whistleblower retaliation. If you say yes, you're in agreement. Commissioner Ashby.
Yes.
Commissioner David. Couldn't hear you. Nope, can't hear you. Have to be able to hear you.
Well, it says the mute is off, and I'm saying yes. You still can't hear me?
Now I got you. Thank you.
Sorry.
Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
The unanimous vote for reasonable grounds. Thank you very much. The commission will be in touch with the parties. And I'm going to ruthlessly move us along to the next case.
Thank you. The next case is E20-0466 Hassan versus Uber Technologies. This is also a reasonable grounds case. We should hear from the respondent.
Yes, Ms. Lemire is here. And let me make sure we have everybody in the right room. I think we're getting everyone in the right focus here. Chelsea's doing yeoman's work, getting everybody on. We need Ellen Lemire, and complainant counsel is here in person. There she is. Thank you, Chelsea. Okay, Ms. Lemire, you have 10 minutes.
Thank you very much. Good morning, commissioners, and good morning to the commission. Ellen Lemire on behalf of respondent Uber Technologies. Mr. Hassan used the Uber app beginning in January 2016 to connect with riders in the Portland, Maine, and Boston, Massachusetts areas. In order to use that app, he entered into an agreement with Uber that defined their relationship as independent contracting parties and not as employer and employee. For its part, Uber agreed that it would not control the day-to-day work of Mr. Hassan, but reserve the right to deactivate his access to Uber's app if he violated Uber's community guidelines. Over the course of the next 4 years, Mr. Hassan received 16 rider complaints, 13 of which are detailed in Uber's position statement to the commission. After each rider complaint, Mr. Hassan was reminded that additional complaints could result in permanent deactivation of his access to use Uber's app. On January 1st, 2020, another rider complained about Mr. Hassan and said that Mr. Hassan was very rude and made racist comments. That same day, after Uber notified Mr. Hassan that a rider had made a complaint against him, Mr. Hassan responded that the rider who complained about him had been trying to get more people into the car than his vehicle could accommodate. Thereafter, Uber investigated, and on that same day, due to multiple rider complaints that Mr. Hassan had communicated, Uber deactivated his access to the app. On January 4th, 2020, after Uber had already deactivated his account, Mr. Hassan told one of Uber's support team members that he is, quote, Black and Muslim. Despite those facts, the investigators' report found reasonable grounds to believe that Mr. Hassan is an employee of Uber, that Uber's complaint process was discriminatory against drivers, that the 16 riders who complained about Mr. Hassan must have been biased against him because of his national origin, and also that Uber shut off his access to Uber's app in retaliation for him reporting alleged unsafe activity. There are several material and factual errors in the investigators' report. First, that it concludes that Mr. Hassan is an employee of Uber. This conclusion is based on a footnote referencing a different investigators' report from a different Maine Human Rights Commission case from 2019 involving an unrelated public accommodation case. In that unrelated case, that driver was subject to a different agreement with Uber than Mr. Hassan was, and there are no findings as to Mr. Hassan specifically about the day-to-day control that Uber would have had to have over him in order to be deemed his employer. The investigators' report should be invalidated on that basis alone. Instead of making specific findings as to Mr. Hassan, the report makes several assumptions, many of which are false. The report claims that Uber has sole discretion over whether to allow a driver to use the Uber app. This is not true. Uber is required to follow Maine's laws before it can allow access to its app, and complying with the law does not establish the level of control required for an employer-employee relationship. Next, the investigators' report states that Uber controls topics of conversation and routes that drivers take. But again, this is false. Drivers are required to follow Uber's community guidelines and Maine laws, but there are no requirements about topics of conversation or routes that they're required to take. In addition, the report states that Uber can remove a driver with a high cancellation rate, which is not an issue in this case, something that Mr. Hassan has never alleged. And something that Uber has never done in terms of Mr. Hassan. He was never removed for a high cancellation rate. Uber had no control over Mr. Hassan's work. Mr. Hassan had no supervisors, no set shifts, no need to ask permission before taking time off, no performance reviews, no uniforms. He could work any hours he wanted, wherever he wanted. And based on the investigation, there's no evidence that Mr. Hassan was an employee of Uber, and that should be a non-starter and grounds for the report to be disregarded. However, in addition to the incorrect finding that Mr. Hassan was an employee, the investigators' report also has other legal and factual errors. One is that it seems to create its own standard for the number of rider complaints that Uber should have allowed against Mr. Hassan before deactivating his account. The investigators' report decided that 16 different rider complaints was not enough. But in doing so, improperly second-guessed the business decisions of Uber and impermissibly imposed its own standards. Next, the investigators' report credited Mr. Hassan's claim that Uber failed to provide him with interpreter services, but disregarded the testimony of Uber's representative, who explained that there were interpreter services available and that drivers were made aware of this. And more importantly, the fact that Mr. Hassan never requested an interpreter or said he had any issue communicating in English. If you look at Mr. Hassan's communications with Uber's support team members, the communications are in English, and there is no indication that Mr. Hassan has any trouble understanding or communicating. There is no basis for the investigators' report to make any adverse finding in that area. Next, even though Mr. Hassan admitted that riders could have justifiably believed that he was yelling at them, the investigators' report discounts all the rider complaints that amassed against Mr. Hassan for yelling. And there were multiple complaints. Yelling was a theme that riders complained about with regard to Mr. Hassan. And the report assumes that every single rider that complained about Mr. Hassan yelling at them must have been biased against him because of his national origin. I submit to the commission that sometimes yelling is just yelling. And in this case, everyone, including Mr. Hassan, agrees that riders were justified in complaining about yelling. The investigator's report should not have disregarded the rider complaints. The investigator's report assumes with no evidence also that the rider complaint system and Uber's process of handling rider complaints is biased against non-white drivers. This finding is based on a 2016 Boston Globe article about decisions Uber was making back then about how to make sure tipping was more fair to non-white drivers based on scientific and academic studies. There was no mention in the article of rider complaints or Uber's complaint process of handling rider complaints. The investigator's report makes a leap that goes too far when it assumes that every aspect of Uber's business is biased against non-white drivers. Uber's deactivation of Mr. Hassan's account was a result of the accumulation of rider complaints and had nothing to do with his race or national origin. And it also had nothing to do with Mr. Hassan's explanation of the incident involving the final rider who complained about him. At the time Mr. Hassan gave the explanation of the incident involving the final rider who complained about him, the incident was long since over. This was not your classic whistleblower case where Mr. Hassan brings forward a safety complaint. This is Mr. Hassan's after the fact explanation of the 16th rider complaint against him, an explanation that he made only after Uber notified him of the complaint. No business should have to continue to work with someone who has 16 separate customers who complain about them. And that's exactly what we have here. There are a number of material errors in the investigator's report, and I ask the commission to set it aside and vote in favor of a no probable cause finding. And I'm happy to answer any questions that you have.
Thank you, Attorney Lemire. Commissioner, questions for Attorney Lemire? Commissioner Douglas?
Yes, good morning.
Good morning.
Yeah, so just a couple of things. First of all, this issue of the employer versus independent contractor relationship, right? The report cites to Legacy, Bangor Publishing Company. I'm assuming you've read that case?
Yes.
Yeah, so I guess I'm just wondering, I mean, the report, the case references the power to hire and fire in terms of part of the control analysis there. And you agree, obviously, with what we're talking about here, that Uber had the power to hire and fire Mr. Hassan, correct?
Well, not solely. Like I said in my presentation, whether or not Uber allowed Mr. Hassan to access the app was not Uber's sole decision, right? Mr. Uber had to meet a number of legal requirements that are Maine's requirements, right? Not Uber's requirements. And I listed those in my papers, but things like, you know, having the vehicle insured, having a proper license to operate a vehicle, those types of things. So, you know, having a background check, which is another legal requirement. So if he met all those requirements, then he's allowed to access the app. But I would disagree with the statement that Uber had sole ability to hire him. And the same with quote unquote firing him. You know, yes, Uber has community guidelines in place. And if a violation of community guidelines is grounds for deactivating his access to the app, but those community guidelines are also required by Maine law, right? And it wasn't one instance where Mr. Hassan was alleged to have violated community guidelines. It was multiple instances. So yes, I guess Uber retains the right to deactivate his account, but only in that one instance. If he had, you know, he could have walked away and stopped giving rides at any point and stopped using the Uber app. Hopefully that is somewhat helpful in answering your question.
Right, but I mean, like, in terms of whether or not he's working for Uber or not, access to the app is pretty much the whole ballgame, right? I mean, yes, I understand he has to comply with some state requirements, but whether or not he's going to work for Uber depends on whether or not he can access the app. True?
Yes.
Okay. All right. So I guess I'm curious about your the argument in your paper about, you know, that the number of complaints and the investigator imposing a standard sort of based on nothing, as you put it, right? I mean, is there something somewhere in Uber's community, I don't know, whatever paperwork Uber has, whatever guidelines for their people that sets forth the acceptable number of complaints? Just so you know where I'm coming from. I mean, it seems to me that finding was not based on nothing, as you put it. It's more 16 complaints out of 20,000 rides is, as the investigator said, statistically insignificant. And so I guess I'm just wondering, you know, is there some guideline you can point us to that says otherwise?
No, because that there is not a written guideline that says X number of complaints equals account deactivation. That does not exist. And the reason is because that number is dynamic. Uber does take into account the number of rides that a driver has given. And as you say, in Mr. Hassan's case, they took into account that Mr. Hassan had given 20,000 rides, right? And that's why we're here talking about the 16th complaint and not the 5th complaint, right? And so, I mean, there is no set number, but the number of rides is taken into account, and it's based on also the type of incident, right? This wasn't like, you know, a minor incident. Well, I'll use the example from the report. This wasn't he canceled too many ride requests, right? And this was all the same kind of incident, that interpersonal conflict incident. And so that matters too in the determination, right? It's not just, you know, the number of incidents, but it's the number of similar and same kind of incidents that accumulated over time.
And just one more question. You agree with me that drivers have to act consistently with the community guidelines in order to maintain access to the app? Yes.
Yeah, I mean, I would actually say that drivers need to not violate the community guidelines in order to continue to access the app, right? I think, and I'm not trying to parse language here or be too, I don't know, you know, particular, but I think there, you know, there is a difference, right? That because it's not, they can do, they have much more freedom to act the way they want. There's just a small number of categories listed in the community guidelines that, if violated, become problematic, right?
Right. Okay. Thank you.
Commissioner David?
Yes, the number is statistically insignificant. 16 divided by 20,000 is 0.0008. So as you say, it has to be based on the nature and type of complaint, and that requires an individual assessment of those complaints. And the problem here is that those complaints, multiple of them, are associated with factors about him that would be discriminatory to use against him. His fluency is in English, his tone of voice, that kind of thing. So it seems to me that you haven't, there's a reference in the report that there's no statistical analysis, and you agree that there's no information from Uber as to what to compare this firing to any other. So why don't we assume that it's based on those impermissible factors about his personality?
So to respond to that, first, I just want to make sure the record is clear that Uber did provide names of other drivers who whose account access was deactivated for similar reasons as Mr. Hassan. So the commission does have those names. And even if you disregard, I believe there was one complaint about that mentioned fluency in English, but the vast majority of the complaints were about yelling, were about rudeness, were about, I mean, there was one rider in tears, right? Because she was yelled at by Mr. Hassan. And my issue is with the assumption that the investigators report made about the tone, right? The tone, the investigators report found that the tone that Mr. Hassan used was fine because it was part of his natural speaking voice, I think was what the report found. But that is not, but Mr. Hassan at the same time said, yeah, it's possible that all of these riders could think I was screaming at them. That would be a reasonable thing for them to think. And so I guess my point is he can't have it both ways, right? He can't say, this is how I normally talk. And so it was discriminatory for all these riders to complain about my tone. But at the same time, I guess that's where I'm coming from here. If hopefully that was helpful in answering your question.
Thank you.
Any other questions at this time for Ms. Lemire? Seeing none. Thank you, Ms. Lemire. You'll have about 45 seconds when we come back to you.
Thank you.
Now I believe we're turning to Attorney Wicks, who is here in the room. He's today's rarity.
Good morning, commissioners. Valerie Wicks here on behalf of Abdirazak Hassan.
You could speak up so the folks there can hear you.
Sure, happy to. So I want to start by going through points we just heard from counsel for Uber. First of all, Mr. Hassan did not say, yes, I yelled at everyone. What he said is that his tone can be excited and that he can speak really quickly. And people sometimes mistake that excited tone and pace of speech as being angry when it's not. And we have the benefit in this case from the investigator having interviewed Mr. Hassan by video conference. So she had the opportunity to have her own impression of his tone and of his speech. And I think she will confirm he got excited at certain parts in that interview, but it wasn't anger. So she was able to make a credibility determination based on her own perceptions of Mr. Hassan's speech. And that was very useful in this investigation that she was able to make that credibility determination. Second, I want to talk about Uber's claim that these complaints, once you reach some number, although they won't tell us what, just some number, it will become unacceptable. As Commissioner David pointed out, we're talking about a tiny, tiny number of complaints compared to the rides that Mr. Hassan completed for Uber. I also did the math of 0.0008. We're talking about 4 complaints for every 5,000 rides he gives. It's a very, very small number, right? And on top of that, Uber's complaint process is not built to ferret out the frivolous complaints or the false complaints. So here we had a rider accuse Mr. Hassan of being under the influence, of being drunk. And he said to Uber, I am Muslim, my religion prohibits drinking. I've never had a drink in my life. And he went and paid out of pocket $135 to a private company to get a drug test that he submitted to Uber to say, this is not what happened here. So that's just one example, but there were others. There was the one Commissioner David keyed on of someone complaining he doesn't speak English, right? And then we had the final complaint on January 1 of 2020, where Mr. Hassan said, I cannot take 5 riders. I have 4 seatbelts. My insurance says 4. Someone jumps in the trunk and he had to cancel the ride and say, I can't do that, right? All 3 of those complaints, and those are just a couple examples, Uber is counting those when they're giving us the 16 complaint number, right? So their system had no way to eliminate those false complaints. And what the investigator found was that Uber's complaint process, right? The way that they didn't have any mechanism to exclude those complaints was going to have a disparate impact on the basis of race and national origin. And a couple of things about that. So we are not, as Uber's counsel has suggested, making some claim that everything is, biased. It's not that. It's that you don't have a process that's going to ferret out the false complaints. And very interestingly, when the investigator interviewed the Uber executive, he said, oh, we have a system in our complaint process for fraud. And when she asked, what does that mean? They do go out and figure out, has this rider complained enough times that they've gotten multiple free rides from Uber? So they do have a way to identify fraudulent claims, but only when it means Uber isn't getting paid. They don't do the same thing when it comes to complaints that could be discriminatory, right? So that was very interesting. And I want to talk a little bit about the claim that the January 1, 2020 complaint did or did not involve safety in the first instance. Under the Maine Whistleblower Protection Act, it is protected activity not only to raise a safety concern, but also to refuse to do something unsafe. So when the fifth rider in the early morning of New Year's Day in the Portland Old Port jumped into Mr. Hassan's trunk, he canceled the ride and said, I cannot take you. That was protected activity, right? He refused to do something that would be unsafe, and it was also snowing that night. So that is the complaint that got him fired, right? So refusing to do that unsafe thing, although he did also tell them, why he had refused to do the ride. And I'd like to talk a bit about Commissioner Douglas's question around the employee independent contractor issue. Is that, so we have to sort of use our common sense here when we think about the relationship between drivers like Mr. Hassan and Uber. Absolutely have the power to hire and fire, right? There's nothing remarkable about a job having certain criteria you have to meet before you're going to be considered. So you have to have a license, et cetera. Teachers, firefighters, lots of jobs. There's some criteria for background checks and other things. So you can set that aside. Just because you have a license doesn't mean Uber has to hire you, right? It just means you're qualified. Then we have Uber doing all sorts of things that show control that a normal independent contractor just doesn't have, right? So independent contractor, we think, oh, my law firm is going to hire someone to do the website or something like that, right? So one-off project, it's not the core of our business. They complete the project and then they're gone. Here, we have Mr. Hassan working for Uber for 4 years, right? What he's doing is the heart of their business. He is driving people, right? That is what Uber does. Uber is tracking how many rides he does. Every time he gives a ride, he's getting a rating from a rider. He participated in Uber's Uber Pro program, which tracked how many rides he canceled, whether he had high acceptance rates, whether he drove on certain hours. And that's how he earned this diamond status, right? So more control. We have the power to hire and fire that we talked about. And we also have, and this again was in the investigator's interview of Mr. Hassan, is that he explained that there was a policy about canceling trips if riders don't show up in a certain amount of time from the appointed spot. So Uber takes issue with this footnote in the report, but there was ample evidence in the record, including in the interview of Mr. Hassan, that led to the conclusion that he was an employee, not an independent contractor. So the community guidelines, I would say too, those aren't just about things you have to do to comply with Maine law. They also say stay away from politics, right? So there's a lot of control being exerted here over the drivers. And I will leave it there for now and answer any questions, although I could go on, but I'll leave it for now.
Thank you. Commissioner questions for Attorney Wick? Yeah. None. Thank you, Attorney Wick. You'll have 3 minutes and we'll come back to you. Attorney Lemire, you have about 45 seconds.
Thank you. I'll just address the employee-employer finding. Based on, I just want to reiterate that there were no specific findings made about Mr. Hassan, right? It's one footnote that assumes because of an earlier Maine Human Rights Commission case that was the same relationship here. So I'll leave it at that, but Uber is not a transportation company. It is not providing rides. It is providing an app that connects people, drivers and riders. It's a technology company. It's not a ride transportation company.
Thank you. Any commissioner questions for Attorney Lemire? Seeing none, Ms. Wicks, we're back to you. You have just under 3 minutes.
Thank you. So back to the employee independent contractor issue, the complainant's reply brief to the commission and the interview that the investigator did with Mr. Hassan were evidence in the record, right? That counts, whether it was communicated in a footnote or written up in 5 pages. The evidence is there in the record supporting the investigator's conclusion of employee status. The fact that Uber can write a big contract saying in 100 different ways you're an independent contractor doesn't change the facts on the ground, right? We can sort of use our common sense here about the control of the relationship. Secondly, on the discrimination claim, I also neglected to say earlier, the adverse inference that the investigator drew from Uber's refusal to provide data was completely appropriate. So Uber wants to take credit here for providing a list of names of folks they terminated or they ended, deactivated for interpersonal conflict. First of all, I have no confidence based on the record in this case that Uber is properly classifying complaints as interpersonal versus safety. Mr. Hassan's January 1, 2020 complaint was originally designated safety and then changed to interpersonal. So I don't have any confidence in the accuracy without the underlying data. Second, if we're doing statistical analysis, which the investigator correctly pointed out is crucial in disparate impact cases, we need the big number and the little number. We need to know how many drivers total and then how many were terminated. It doesn't help to get a list of 10 names. That's just not sufficient. And the investigator very appropriately said, the commission has all sorts of precedent for adverse inferences when people refuse to participate in the process, as Uber did here. So it was on solid ground, and we think that the commission should affirm the decision from the investigator on these programs.
Thank you. Commissioner, questions for Attorney Wicks?
Just on the issue of control. You mentioned that there's more information that sort of came into the record that we're maybe not necessarily seen. So you could just briefly sort of list some of the facts supporting a potential finding that there was adequate control that constituted this man's neck.
Yes, happy to. So the key documents in the record would be the reply brief that the complainant submitted and the interview of Mr. Hassan and his comments about working for Uber. But to your point, a more specific question, first, the Uber Pro program. So the fact that Mr. Hassan had this diamond status meant that he was participating in Uber Pro, which was a sort of heightened way of analyzing his performance based on low cancellations, right? He wasn't canceling rides. He was driving at times that Uber found more lucrative. And he was accepting a lot of rides, and that his overall rating was high. And remember, Uber is rating him, right? He has that 4.92 rating. So there's a lot of control over assessing his performance. And right, each time a rider goes, they're assessing his performance, which is not typical of someone who, you're saying, hey, come do this project, hands off, right? It's also the length of employment. He was there for 4 years, right? He was doing the thing. I know Uber resists, they're a technology company, they say, not a ride company, but I think those of us who are approaching this with a little bit of common sense would say people go to Uber for rides, not just because they like apps on their phones. So he was doing the thing that the company does. And then, of course, there's the most crucial factor here, which is the hiring and firing, that they cut him off from the app, meaning he could no longer drive for Uber. They had the power to do that. Similarly, they had the power to decide that he could drive for Uber in the first place. And, to this day, they have not allowed Mr. Hassan to re-up on the app. So he has been unable to ride for Uber since January of 2020. So those are, I would say, the key factors that show control.
Thank you.
Yeah.
Any additional questions for Attorney Wicks? Ms. Lemire, you do not have an opportunity to offer anything else. Any other additional questions for Attorney Wicks? Seeing none, thank you. Thank you, Attorney Wicks. So commissioners, at this point, we hear from the investigator.
Morning, commissioners. I'm Courtney Byrne. I was assigned to this case as well. So one point I just wanted to hit on, just because I think there might be some confusion, is my footnote. So it's footnote 4, talking about statistical insignificance. So here, so as has been repeatedly referenced, there were 16 complaints against complainant. In one of the responses I received, there were 18 complaints included. I couldn't tell if 2 had been discounted or what had happened, but I wanted to make note of that in the record. And that purpose of the footnote was just to highlight that the difference between 16 out of 20,000 or 18 out of 20,000 complaints is statistically insignificant. It's effectively, it's I think 0.008% versus 0.009%. But I just felt it was important to make note of that. However, as I said, overall, or it has been said, that's a small percentage, and based on the information in the record, at least one of the complaints explicitly references complainant's inability to speak English, and 2 of the complaints were based on substance abuse, which, as mentioned previously, complainant had taken a drug test that was negative, had provided proof of that. Down the line, another rider made another complaint about this. He responded to Uber, complainant responded to Uber saying, hey, I've been through this. I've provided, information to show that I'm not using drugs or alcohol. I'm Muslim, and provided a credible reason why that would be an unfounded claim. Other than that, I don't believe I have anything else to add, but I'm happy to answer any questions you might have.
Thank you, Courtney. Commissioner, questions for the investigator? Mr. David?
Courtney, it seems to me that your interview of the complainant is important. Would you characterize what you learned from that in-person interview in terms of how it bears on the evaluation of discrimination or improper allegations of what people might perceive as a discrimination, which you concluded was not?
Sure. So complainant had explained through an interpreter as well that he's not fluent in English in his written communications with Uber. I know that was referenced earlier. For more in-depth responses, he would have his daughter help with written communications just because his level of fluency wasn't, he believed, high enough to respond to some of the messages he received. His tone, I would say, was louder. He did speak more rapidly. Just as his natural way of speaking, I would say. And he said that he could understand why other people riding the vehicle might interpret that as him being agitated. So yeah, I found that explanation credible.
Thank you. That's all.
Any other commissioner questions for the investigator? Seeing none. Thank you, Courtney. Commissioner, there are 3 proposed findings here. You can take them separately or together. Commissioner O'Brien?
Well, I'll start with the third. I think it's low hanging. I think that there are no reasonable grounds to believe that Uber Technology Inc. retaliated against Mr. Hassan for engaging in Maine Human Rights Act protected activity, and that claim should be dismissed.
Second.
So it's been moved and seconded on proposed finding number 3 to find no reasonable grounds. For any discussion? Seeing none. The motion is for no reasonable grounds. If you say yes, you are in agreement. Commissioner Ashby?
Yes.
Commissioner David? Sorry, I could not hear you. I see you, but I can't. There you
Yes.
go. Thank you. Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
That takes care of, that's a finding of no reasonable grounds on proposed finding number 3. Commissioner O'Brien?
I guess that was the low hanging.
Well done.
Taking number 2, that there are, I would submit there are reasonable grounds to believe that Uber Technologies retaliated against Mr. Hassan for engaging in WPA protected activity, and conciliation of that claim should be attempted.
Is there a second?
Second.
Second.
Thank you. So it's been moved and seconded to find reasonable grounds on the WPA claim. Is there any discussion? Seeing none. If you are in agreement with a reasonable grounds finding on the whistleblower claim, you will vote yes. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Thank you. And then just one left.
I'll do it.
All right, you're on a roll.
All right. In number 1, I would move that there are no reasonable grounds to believe that Uber Technologies discriminated against Mr. Hassan on the basis of race and natural origin and conciliation. That claim should be attempted.
Should not be attempted.
Should not be attempted.
Is there a second for that motion?
I'll second.
So it's been moved and seconded to find no reasonable grounds on the claims of race and national origin. Is there any discussion among commissioners? Commissioner David?
Yeah, in terms of discussion, I think there was a discrimination on the basis of race and national origin, and the reason for that is the language and the mannerisms and that kind of thing. And I remember in the record that they have a picture of him. They know who he is in that regard. And I agree with the initial impression that, well, this firing wasn't because of race, but I think in the broader sense of what the law is, that it is. And that would be the basis of my voting no on the motion.
Any other discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds on the basis of race and national origin. If you are in agreement with no reasonable grounds, you will vote yes. Commissioner Ashby?
No.
Commissioner David?
No.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
No.
So that motion fails for lack of a majority. Does anyone want to make another motion?
Yeah, I'll move that we accept the recommended finding in paragraph 1 that Mr. Hassan was discriminated against on the basis of race and national origin.
Is there a second?
Yes, second.
Thank you. So it's been moved and seconded to find reasonable grounds on proposed finding number 1, race and national origin. Is there any discussion among commissioners? Seeing none. So the proposed finding is reasonable grounds with regard to race and national origin. If you agree with reasonable grounds, you will vote yes. Commissioner Ashby?
Yes.
For David?
Yes.
Commissioner O'Brien?
No.
Commissioner Walker?
No.
Mr. Douglas?
Yes.
So the findings are reasonable grounds. And so the commission will be in touch with council, and we thank you for being present. I am going to still relentlessly push forward, even though I'm sure everybody wants a break. Okay. You with me, Jeff?
Next is MHRC number PA 20-0491. This is Leonard versus Walmart, and
Oh, actually you skipped one, Commissioner. I'm so sorry.
I'm sorry. My apologies. Sorry. I don't know why you're apologizing, but anyway, next is E20-0489AB. Dr. Richard Skipora versus Marge Wiggins and Maine Health.
I'm on the phone. I'm sorry. I apologize, Commissioner. I was trying to make sure that I believe we have my complainants counsel here on the phone, and I just wanted to make sure that we were bringing them into this focus group. I apologize.
That's fine. Are we set?
Yep. I think so.
This is a no reasonable grounds finding, and I expect that we would hear from the complainant in this case. Or the
I believe, is the person on the phone, is that Attorney Bullock? Because if it is, then we need you to unmute yourself.
Hi, this is Dr. Sapora. I believe she's trying to unmute now.
Oh, there she goes. Thank you, Dr. Skipper.
Good morning.
Good morning.
Good morning.
Yes, so
This is,
go ahead, you have
I'm
10
sorry, go
minutes.
ahead. I was just going to introduce myself. This is Mary Elizabeth Bullock for Dr. Richard Sapora versus Maine Hospital.
Judge Bullock, before you start, can I just remind you that you can't use the names of any third parties or witnesses? We've given them pseudonyms in the report.
I won't use any names. Sorry.
Great, thank you so much. Go ahead.
Okay. First and foremost, I'd like to say that the investigator's report should be set aside. An investigator's report has to be a development of impartial and appropriate factual records so that the fact finder can make a decision with the appropriate facts and impartial findings. In this particular case, the investigative report leans towards the respondent, and in here it says about all the complainant's qualifications, and it ends with the fact that they didn't make a discriminatory hire based on race, based on gender or age, because the person who they hired was a known commodity, regardless of the complainant's resume and credentials. Now, if that is so, there would be no reason to put an ad out, because that would have been for anybody. Certainly, the complainant had a doctorate in nursing, 2 master's degrees. He had certifications and at least 12 years in dialysis with all the B tags necessary for dialysis work. All of his letters of recommendation, all of his other hospital jobs, you might say, were all rated excellent. And if you are looking for the most qualified candidate, he would have been interviewed. But the fact that he was not interviewed, the U.S. courts say that that is a pretext for discrimination. And when it says that the applicant had all the knowledge and values of the hospital, well, I'm sure had the complainant been hired, he would have also had those same values. And all the time he's been in nursing, he's had those same values. So, this is a subjective hiring. It's not an objective hiring, because the applicant, the person that they picked, was already doing the job. So, ergo, she was either promised it, or, as they say, the reasons given were all subjective. They were not objective. She could not do dialysis work. She could oversee the staff. She could make schedules. She could do generalized nursing, but she could not do dialysis work, period. And the ad, as so stated, required dialysis oversight and work. And as I said, if you don't comport with the certifications and the requirements, you're not eligible for the job. He was not interviewed, even though the investigator did say, you know, he was absolutely the most qualified candidate. But if you were just going to go on most qualified, he would have been the selectee. However, subjective factors came into play, such as her already working at the hospital and already incorporating into the values of the hospital that she was selected. You can't go on subjective factors in and of themselves. And that's what happened here. Because otherwise, why would a person put an ad in the paper if they were going to pick somebody who did not have the qualifications? It makes no sense. And many of the U.S. courts do say that without interviewing someone, that indeed that's a pretext for discrimination. And that's what it looks like here. Also, you have his argument is that it was gender-based and age-based. Gender-based meaning most people think of nurses as being female, you know, blonde and beautiful, tall, lanky legs. But he was a male, and it went against what nurses, particularly people presume to be when they hire them. The other thing is that when you have an institutional bias, for instance, the EEOC is going after all the institutions and the biases that they have. If it's a nurse, if it's all female nurses, if they're all young and male nurses aren't hired, it's discrimination on its face. And it's a pretext. So his qualifications as being a doctor in nursing, his master's degree, his longer term in nursing makes no sense not to even interview. That is, if you're looking for somebody who met the qualifications for the ad. So to say that she was as the investigator said, she was a known commodity, while the complainant was not, regardless of his resume and credentials. Well, that's like an oxymoron. How can he be a known commodity if you don't give him a chance? He's a known commodity in the nursing industry because he's, you know, is so advanced, and especially in dialysis. It just doesn't, it makes no sense then not to at least even giving him an interview. So because the institutional bias of hiring females rather than male nurses, and there's plenty of studies out there that show it, you know, that male nurses are just, they're discriminated against because they are indeed male. Also, with regard to age, if he put in his report a picture of the nurses, and they're much younger, and the applicant, I mean, the person they selected was much younger than he was, and it's on its face discriminatory. I just see that the investigator's report just is slanted towards someone who, you know, was a known commodity, and well, they could not have known the applicant unless they had interviewed him, and there was no interviewing. Especially when you have not somebody, as the Supreme Court once said, whose qualifications jump off the page. No, they just have to be better qualified. And based on that, it's discriminatory not to interview them, and not to interview them is in fact a pretext for discrimination.
Is that the end of your presentation?
Yes, right now, yes.
You have another minute and a half.
Well, I would just say that the investigator's report be set aside because of the subjective reasons that the applicant was chosen. She was already working there, but she did not have the credentials. If somebody went into renal failure or something, she could not assist. She could not help the patient. She couldn't get anybody to assist the patient would be dead. Plain and simple. It's part of the accreditation of the hospital, and it was best. That's all.
Thank you. Thank you. Any commissioner questions for Ms. Bullock? I do not see any right now. I'm going to ask you to hold on. You'll have a minute left after we hear from respondent's attorney. Ms. Bush.
Good morning. My name is Michelle Bush, and I represent respondents Marge Wiggins and Maine Health in this matter. I want to start by clarifying something that Attorney Bullock just mentioned at the end of her presentation, which was that if a patient were to go into renal failure, there would be nobody there to care for them. That's not true. That's not supported in the record, and it's not factually true. Maine Medical Center is a large hospital with a very large and robust nursing workforce and with adequate nursing staff on staff, including on dialysis, to respond to any type of emergency. So back to the legal arguments. I don't think I'll take all of my time. I think I can hit on a couple of high points, what I think are most important for the commissioners to understand. We certainly agree with the recommended finding by the investigator that there are no reasonable grounds to find discrimination in this matter. Firstly, with respect to respondent Wiggins, there's a footnote in the investigator's report reminding this commission about a law court holding that individuals cannot be personally liable for discrimination, which I agree with. And moreover, there are no facts here to support individual liability for retaliation or interference, which we also agree with. So we think that the finding is properly that Ms. Wiggins, there's no reasonable grounds to believe that Ms. Wiggins discriminated in any way against Mr. Sapora. With respect to Maine Health, we also agree that there are no reasonable grounds here. What it comes down to, I think, is there's no evidence of discriminatory animus. This is a disparate treatment case, not a disparate impact case. So we have to look at what the motives were by the decision makers. And here the motives of the decision makers, there's no evidence that they were discriminatory. They chose a highly qualified internal candidate who was already functioning in the role as the interim leader of this department. They made that choice without interviewing anybody else, not just the complainant, but nobody else got an interview. So there was no purposeful discriminatory decision to decline to interview Mr. Sapora because of his apparent age or his experience or his gender. Rather, they put the current incumbent through a robust interview process, and only after that robust interview process and only after several months of successful performance in the interim role did they give her the job. That explains why they posted the position and yet proceeded to place her in it without interviewing anybody else, because they went through a robust process. The reasons that Maine Health has for choosing the current incumbent, the successful candidate, are non-discriminatory. And I think they're not really properly called subjective. I think we can view them as objective criteria. They have objective reasons to believe that this candidate is a good one, the successful candidate. Her 17 years of work for Maine Medical Center, her successful prior leadership at Maine Medical Center, her successful time as the interim leader, her objective qualifications, which though not focused on dialysis, are in fact focused on good nursing. So I think it's false to call those subjective reasons for choosing her over all other candidates. And the evidence that Mr. Sapora submitted in his filings of a picture on Facebook and of statistical shortage of male nurses nationwide, I think is also not probative of discriminatory intent. It's an anecdotal evidence on Facebook that it really is not going to give us any insight into the decision makers and their mindset, and whether there is data to support a disproportionate presence of women among the nursing population, it again does not go to the discriminatory motive or the motive at all of these decision makers. And then finally, I'll just make one final point. There are a couple of additional arguments or possibly facts that I think are in the complainant's objection that I just want to point out I don't think are before the commission here. There's a page or two in the objection that suggests that there's a retaliation claim. There is no retaliation claim. There are no facts in the record to support retaliation. There's also a suggestion in the objection that there are respondents numbers 1 through 20. There are no such named respondents, and respondents numbers 1 through 20 didn't have an opportunity to respond. And finally, there's some suggestion that prior applications by complainant that were not successful are also somehow discriminatory. This point we did raise in one of our submissions that those are all time barred. Those prior applications are from several years ago, and we think are outside the scope of this investigation. So I don't have anything further. I'm happy to answer any questions or yield the rest of my time.
Thank you, Attorney Bush. Commissioner questions for Attorney Bush, Commissioner Douglas?
Just one question, Executive Director Sneerson.
Thank you.
There was a suggestion by complainant that the incumbent, as you referred to, this person was not qualified for this position, that they didn't meet the criteria set forth in some advertisement, as I understood it. Can you just briefly address that for us?
Yes, so if I understood the argument, there is a minimum criteria that was listed on the advertisement as well as on the job description that requires 5 years of direct patient care. This candidate has well more than 5 years of direct patient care. What this candidate, I believe, may not have, and I'm going based on the record here, I haven't actually asked this question of the candidate, but the record suggests that the candidate may not have 5 years of dialysis specific experience. That is not required in the job description. This is a leadership position that oversees multiple departments within the hospital. One of them is dialysis, but another is a medical surgical unit. And that was not required that you have dialysis specific patient care treatments. The other piece of it, I think if I understood the argument, was this CMS VTAG requirement that you need a nurse manager who has dialysis specific experience. I actually debated whether I should go find the answer to that because I believe this is the first time I've seen it, so I'm not sure it's really in the record and properly before you, but I wanted to answer it anyway. And I did learn that we do have a nurse manager overseeing that particular unit that has the requisite experience, but that's unit specific, whereas the candidate here in the director role oversees more than one unit.
All right, thank you.
Any other commissioner questions for Attorney Bush? Seeing none, you will have 5 minutes left if you choose to use them. Attorney Bullock, we'll come back to you. You have 1 minute if you want to respond to anything.
Yes. First of all, if the naming of individuals, if you do read the complete footnote at the bottom of the investigator's report, it does say that there are cases where individuals can be held responsible. We asked for a lot of a discovery. We got precious little. And getting precious little means that when the information is in the hands of the defendant, when we don't get the information that we asked for, it makes it hard for us to put forth a case. Secondly, with those rigorous notes from the interview, we have to have those. Those must be kept. And you did not surrender those. By law, you have to keep those. And those were never given to us. So as to how rigorous, as to what was said, what made their decisions, you have to turn
Attorney
those
Bullock.
over.
Attorney Bullock, I'm sorry to interrupt you, but that is your minute.
Okay, thank you.
Thank you. Attorney Bush, I'm sorry, hold on. Commissioners, any questions for Attorney Bullock? Seeing none, Attorney Bush, any follow-up for you?
I have nothing further. Thank you.
Thank you so much to both counsel. This time we will turn to the investigator, Mr. Beauchene.
Good afternoon, commissioners. Just to touch on a couple of points here. Number one, as has been pointed out, the respondent made the decision here not to interview any external candidates, which would presumably include both males and females of various ages. So in that regard, complainant was treated no better or worse than any of the other external applicants, suggested that neither one of those were factors in this particular case. Respondent did place far more weight on complainant's longstanding tenure as an employee than they did to complainant's conceitedly stellar resume and credentials. As I had noted in the report, if it was a strict resume comparison and they were both external or both internal applicants, then I believe complainant would have a very strong case here. However, in this case, as they had mentioned, the employee had been a part of the hospital for approximately 17 years, had served in a variety of leadership and director roles, and as was noted, she was a known commodity. It's very possible the complainant would have been successful in the position as well. However, that's still pure conjecture, whereas the successful person had already demonstrated her ability to run the two units in question, the R5 unit as well as the dialysis unit. She had been overseeing one for 5 years at that point and had been performing successfully for 4 months over the other unit. So in that case, taking a risk on somebody who may have been stellar versus somebody who's already demonstrated the ability to perform, while one can question whether or not conducting any interviews was a wise decision, there's certainly nothing to suggest here the complainant was excluded from consideration because of his age or his sex.
Thank you, Bob. Any commissioner questions for the investigator? Seeing none. Thank you, Bob. Oh, I'm sorry. Hold on.
No.
Commissioner Walker.
No.
Nope. Okay. You're ready to go.
No. I don't know proper procedures or protocol, but I need to recuse myself from this matter.
Oh,
I
okay.
have a business, longstanding relationship with Maine Health.
Okay. Thank you for letting us know. In the future, the time to do that is before we start hearing the
Well,
case.
before we voted, I did.
Which is great.
I didn't wait to recuse. I wasn't sure, but I will in the future as we begin a hearing. I will
Thank
let that know.
Any questions for the investigator? Oh, Commissioner Davis?
No, ready to make a motion.
Oh, okay. No questions for Bob. Let's just clarify. No. Okay, great. Commissioner David?
I move that we find that there's no reasonable grounds to believe that respondents, both of them, no reasonable grounds to believe that they discriminated against complainant on the basis of age or sex, and the complaint should be dismissed.
Second. Thank you. It's been moved and seconded to find no reasonable grounds. Is there any discussion among commissioners?
I would just say that clearly the factors about her familiarity with the culture, the relationships with staff, the long tenure, they are not subjective factors whatsoever, and we're not going to substitute. We ought not to substitute our judgment for a reasonable decision by the company.
Any other discussion among commissioners? Seeing none, thank you. So the motion is to find no reasonable grounds to believe that complainant was discriminated against based on age or sex. If you are in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Recuse.
Commissioner Douglas?
Yes.
So the finding is no reasonable grounds, and the commission will send council a letter to confirm that. We thank you for your participation. And commissioners, I would propose that we push through this one last case in the morning session because we have counsel here who's representing one of the parties, and then we can maybe take a few minutes and food should be here soon.
Okay.
Thank you for indulging me.
All right, we're ready now to proceed to case PA 20-0491. This is Lindsay Leonard versus Walmart. And this is a reasonable grounds. This is a reasonable grounds case. And we would hear then from the respondent or respondent's counsel.
I believe Mr. Hanush.
Yes, hi.
Hold on, let us get you into the room, the Zoom room. And then we have Ms. Wicks here in person. And I apologize if I have butchered your name, counsel, for the respondent.
No, Hanush is great.
Yay for me. Okay, so you have 10 minutes.
Great. Good afternoon, commissioners. My name is Andre Hanush. I'm an attorney that represents Walmart in this matter. It is our position that this commission should decline to accept the investigator's recommendation, as the investigator's basis for their conclusion differs from the evidence that we produced in this matter. By way of background, this matter stems from an incident that took place during Ms. Leonard's visit to Walmart on August 18, 2020. Ms. Leonard alleges that an associate who dispensed her online shopping order made sexually inappropriate remarks to her. Ms. Leonard reported the incident to Walmart, and Walmart took Ms. Leonard's complaint seriously. The store manager met with the associate who denied Ms. Leonard's allegations. Although this was a he said, she said situation, the Walmart manager believed the associate could have handled the situation better, even if it occurred as he described. As such, the Walmart manager issued the associate a third written disciplinary action, RED, which is the final step before termination in Walmart's disciplinary process. From the time the associate was disciplined to the time the associate was no longer employed by Walmart, there was no similar incidents involving this associate. Ms. Leonard met with the Walmart manager on the same day of the incident to report it. However, contrary to her allegations, during her meeting with the Walmart manager, Ms. Leonard did not raise any concerns about future visits to Walmart at this meeting, and no one told Ms. Leonard that she would have to call in advance if she wanted to avoid this associate in the future. Had Ms. Leonard expressed concern about shopping at this specific Walmart location, she would have been told that the associate's supervisors could easily direct the associate not to deliver Ms. Leonard's online orders when her name appears on the list of customer waiting for their orders. This is similar or the same procedures that's already in place to prevent personal shoppers like this associate from delivering orders to people they personally know, like friends or relatives. Thus, it would have been very easy to accommodate Ms. Leonard's request if she expressed any unwillingness to return to this Walmart location. Going forward, it is our position that Walmart did not unlawfully discriminate against Ms. Leonard because Ms. Leonard cannot establish that she was denied access to services due to her sex, because she was not in fact denied any access to any services. She received her groceries and merchandise on the day of the incident, and some items were even provided twice. Ms. Leonard is welcome to shop at any Walmart store, and Walmart remains willing to listen and address any concerns she may have about doing so. Ms. Leonard asserts no facts establishing that she was denied access to services that are granted freely to Walmart's male customers. To address the investigator's report, the investigator cited several factors which formed the basis for their conclusion. However, none of them accurately reflect the evidence produced in this matter. For starters, the investigator based their finding on the fact that Walmart managers could not say with 100% certainty that Ms. Leonard would never encounter the associate again at the Walmart store. The investigator indicated that there is no oversight to prevent the associate not to fulfill Ms. Leonard's future orders. However, for starters, there was no reason to conclude that the associate would have made any attempt to contact or to have contact with Ms. Leonard, and any assumption to that would be speculation. There was no reason to conclude that the associate would have attempted to contact Ms. Leonard, as the surveillance footage that was provided did not corroborate Ms. Leonard's account of her exchange with the associate, nor did the associate in close proximity to this associate in the video report this associate for anything. There was no complaints made by that associate. In the video, the associate appears to be standing at a reasonable distance from Ms. Leonard. Also, management placed the associate on a red level disciplinary action, which is the highest disciplinary action before termination. Thus, if the associate knew the associate knew Walmart's disciplinary policy and was aware of his position. And he would have known that if he disregarded the supervisor's directives of not to contact Ms. Leonard or dispense her order, he would have been terminated. Walmart also has, as mentioned, Walmart has procedures in place to prevent personal shoppers like this associate from delivering orders to certain individuals like Ms. Leonard. However, Walmart cannot absolutely guarantee, as the investigator noted, Walmart can't absolutely guarantee a customer from ever encountering with a certain associate. And that's because, and I'll give you an example, if Ms. Leonard placed an order for pickup using her father's Walmart account, Ms. Leonard's father's name would pop up on the system and not hers. So we wouldn't know if she was the one picking up the order or if it was someone else. Next, the investigator indicated that an asset protection associate credibly reported sexual touching by the alleged harasser, the associate, months before Ms. Leonard's complaint. This former asset protection associate's statement is incorrect. For starters, the asset protection associate in question is no longer a Walmart associate, and at the time of the interview, he wasn't an associate and has no records, no Walmart records available to him. And Walmart does not have any records from this asset protection associate ever complaining about the associate. And in fact, the individual, the asset protection associate, claims to have reported sexual touching, told management that any touching between her and the associate was consensual. Given the fact that the asset protection associate gave a hazy recollection about the associate, which were contradicted by Walmart's records, as well as those who are still employed at Walmart, it's not fair or accurate to deem the former asset protection associate's recollections as credible. Lastly, there is nothing in the record that put Walmart on notice that the associate would sexually harass a customer, although the associate was issued a yellow disciplinary action prior to this incident for horseplaying and making jokes in the associate back room. Such act of joking around amongst coworkers does not put Walmart on notice that he would sexually harass a customer. Right after this incident, Walmart took prompt remedial actions regarding Ms. Leonard's complaint, as evidenced by the fact that it received no further complaints about this associate. To wrap up, Ms. Leonard asserts no facts establishing that she was denied access to services that are granted freely to Walmart's male customers. We request the commission to decline to accept this investigator's recommendation and find that Walmart did not unlawfully discriminate against Ms. Leonard.
Thank you. Any commissioner questions for Attorney Hanoush? Seeing none, you'll have about 2.25 minutes when we come back to you, Attorney Hanoush. Now we will turn to counsel for complainant, who is here in person.
Afternoon, Valerie Wicks on behalf of the complainant, Lindsay Leonard. This is a case that's about credibility determination and whether the investigator believed Ms. Leonard's account of what happened when she tried to get her groceries from the Augusta Walmart. The investigator interviewed Ms. Leonard and interviewed Walmart witnesses and found that she believed Ms. Leonard when she described the harassing conduct she endured while sitting in her car having her groceries loaded by the Walmart associate. There was Ms. Leonard's account. There are also 3 signed declarations in the record that the investigator had to consider. One from the friend who was with Ms. Leonard for part of the interaction, one from Ms. Leonard's father, who she called in tears immediately after this happened, and one from Ms. Leonard's stepmother, who she also called right after the incident. So those are objective evidence, and that's objective evidence in addition to Ms. Leonard's own testimony. We also have the video, which unsurprisingly, I disagree with Walmart. I think the video corroborates what Ms. Leonard has said. First, and sort of a very common sense point, Walmart says the video doesn't corroborate. The video has no sound. So this is about comments largely, right? These are harassing sexual comments made by a Walmart employee to the complainant. The video doesn't have sound. It cannot it cannot fail to corroborate when we don't hear anything. Secondly, there are moments in the video, which we watched and the investigator watched, where the associate is standing behind Ms. Leonard's vehicle, so you cannot see exactly what he's doing vis-a-vis her. So there are gaps in what we know from the video. But the video does corroborate certain really innocuous details that Ms. Leonard had in her sworn complaint of discrimination before she had, had any opportunity to view the video. For example, the order of her arriving and her friend arriving, how long the interaction took, and the fact that it took so long that someone else was waiting for her spot by the time it was done. So again, objective evidence that further bolsters the testimony that Ms. Leonard provided here to the investigator. Very important, it's the claim by Walmart that she somehow had to be unable to get groceries in order for her to have been harassed in a place of public accommodation under the Maine Human Rights Act is just wrong as a legal matter. So the section in question, it doesn't say you have to be barred from ever entering a Walmart. The statute says it's discrimination to deny the full and equal enjoyment on account of sex, any of the accommodations, advantages, facilities, goods, services, or privileges of public accommodation. So if you cannot get your groceries using the pickup service without being subjected to lewd sexual comments, you are not enjoying full access to the place of public accommodation. And it is broader than just you cannot use it at all. I also continued to, I can't let go the fact that Walmart keeps emphasizing we provided some groceries twice, when those groceries are the things that melted in the sun while Ms. Leonard had to sit in her car for a half an hour being harassed, like a frozen pizza and ice cream, that Walmart then provided her unmelted versions of those when she in her own time went back later that day. So no credit for the twice there. I also have to point out that what Walmart did do when it came to confirming for Ms. Leonard that she wouldn't have to see this associate again. So what Walmart's witness testified to at the Issues and Resolution Conference, they said, oh, we have a system if someone orders alcohol and is using the grocery pickup service, we have to make sure we don't have a minor employee delivering alcohol. So we have a screening process for that. But we don't have a screening process for things like, hey, this employee has harassed me, right? So they do have an official way to bar someone out for alcohol purchases. But here, Walmart's own witness said, yeah, it's going to be an honor system for this guy to make sure that he just will say, oh, I'm not allowed to deliver groceries to that person. And the investigator very sensibly said, well, if this is an employee who's harassing people, I don't know why we can defer to his judgment that he's just going to select himself out when appropriate. And then as to his record, right? So I will just catalog. We had the asset protection associate testify at the IRC when the investigator asked him what was associate like to work with. He said, oh, he was inappropriate constantly, sexual comments. Yeah, one woman I worked with complained he was touching her inappropriately. That was his firsthand account of what it was like to work with this associate who harassed Ms. Leonard. And secondly, Walmart's own document, when they issued the level red discipline after the incident with Ms. Leonard, said, this has become a pattern. Other customers have complained. That's why we're going to level red. And then there was a third investigation against this associate for inappropriate sexual comments in the employee back room. So this guy was a known problem. They let him do this job where he was interacting one-on-one with customers unsupervised in the parking lot. And they kept letting him do this job unsupervised with customers in the parking lot after this third incident came to light. So I think it's very clear here that Ms. Leonard was denied equal access to a place of public accommodation on the basis of her sex when she was egregiously sexually harassed by a Walmart employee. And I'll answer any questions and save the rest of my time.
Thank you. Commissioner, questions for Attorney Wicks? Seeing none, you have 4 minutes left when we come back to you. Attorney Hanush, you have about 2.25 minutes.
Yes, just briefly. Walmart, like I said, took prompt action following this incident. And Ms. Leonard never expressed concerns about returning to this specific location. If she did, like, and as my sister mentioned, we have programs in place to prevent associates from dispensing certain orders. However, the burden would be too high on Walmart, as she suggested, to have a supervisor run a conflict check each time an associate wants to fulfill an order for a customer to ensure an associate does not deliver orders to certain individuals. That's where she mentions the honor system. But we do have that. We do have that program in place, and quite frankly, it works. And it's not like the alcohol example where you can screen younger associates who are under the age of 21 from dispensing alcohol, because that's that's a one-time thing. Everyone under 21, you cannot take alcohol to customers, where this would be, if this individual name pops up on the screen on the system, you cannot dispense their order. While you can have directives from supervisors and managers, like we do, like Walmart does, to say that there should be more level of supervision would place a unreasonable burden, more than would place an unreasonable burden. You would have to have someone flipping through each person's list of conflicts, including friends and family, to determine whether they can or cannot dispense groceries to an individual. In terms of other acts involving this specific associate, there was as mentioned, the associate was issued a yellow level warning for a previous incident involving joking in the back room with other co-workers. This was mentioned in the investigator's report that this was.
Yes. I'm awfully sorry to interrupt you mid-sentence, but that is the end of your time.
Thank you.
Any questions from commissioners for Attorney Hanoush?
I can't help myself.
I see that. I see
I'm
that,
sorry.
Commissioner Douglas.
Did I hear you suggest that it would be unreasonable for Walmart to remove from public contact somebody who made the remarks that are set forth in this investigator's report? Is that your position, Attorney Hanoush?
I'm sorry if I understood the question. If it would be unreasonable for Walmart to remove an individual in this certain context.
What I'm saying, what I'm hearing you say is that it would be unreasonably burdensome. I thought you used the word burdensome to remove somebody like, I mean, we'll call them allegations, right? Let's assume for a second that these allegations are credible, right? We have somebody making some explicit sexual comments to members of the public. Is it Walmart's position that it would then be unreasonable to remove this person from a place of public, a position of where they're going to encounter the public on a regular basis? Is that your position? Because I thought that's what I heard you say.
No, just to clarify, my position is Walmart has programs in place to prevent certain associates from dispensing orders to certain customers. My argument that it would be too burdensome does not go to specific incidents like this, but would be as a whole. For example, if I was dispensing a order to my brother, it would be burdensome to have a supervisor know exactly the list of names of my brothers, my relatives, and do that in real time to screen me from dispensing those orders. That's what that was suggested by the investigator in the investigator's report. But no, it's our position that there are certain procedures that we have taken in place to screen specific individuals.
Thank you.
Any other commissioner questions for Attorney Hanoush? Seeing none, thank you, Attorney Hanoush. Attorney Wicks, do you have 4 minutes left?
Thank you. 2 things. One, Ms. Leonard did express concern about returning to shop at Walmart. She did that when she went back to the store later that day on August 18th, 2020. She said to the 3 people she met with, I don't feel comfortable coming back here. How can I shop here again? So she absolutely did that and made that concern known in that meeting. Second, take him off the gig. Tell him he can't do customer service anymore. That's not hard. You might have a complicated algorithm about, who can serve who, but this guy's not fit to interact with the public. He's not a customer service qualified employee. Don't let him do that job anymore. That's not that hard.
Thank you. Any follow-up questions from commissioners for Attorney Wicks? Seeing none, thank you, Ms. Wicks. At this point, we'll hear from the investigator. Yeah, go ahead.
Good afternoon, everyone. My name is Kit Thompson-Crossman. I inherited this case. I don't have much to add. I will just say Walmart has said a couple of times that they took prompt remedial action against the associate, as I think you'll see in the report. Although they got complainant statement on the day that the incident happened, and they took the associate statement a couple of days after that, it took them, this was in August, it took them until October to issue that warning to the associate. So I don't know that is actually prompt remedial action. I'm happy to answer any other questions you have. I'm happy to answer any other questions that you have.
Thank you, Kit. Commissioner, questions for the investigator? Seeing none. Thank you, Kit. Yes.
I'm ready to go.
Okay. Thank you, Kit. Commissioner O'Brien.
Thank you, Kit. Sorry. I would make a motion that there are reasonable grounds to believe that Walmart discriminated against Lindsay Leonard on the basis of sex, and conciliation should be adopted.
Second.
So it's been moved and seconded to find reasonable grounds regarding discrimination based on sex. Is there any discussion among commissioners?
Only that it's patently obvious in this case that this gentleman is clearly not fit to interact with the public. He's been removed from that position immediately. I mean, and the fact that he wasn't, I think, fully supports a finding of reasonable grounds here.
Commissioner David, sorry.
I concur. Walmart's reaction is too little, too late. Tries to put the burden on the complainant as to what she has to do so that they can accommodate the employee. I can think of 5 different ways to discipline that employee and still retain him and give him that one more chance.
Any other discussion among commissioners? Seeing none, the motion is to find reasonable grounds based on sex. If you agree with that, you will vote yes. Commissioner Ashby?
Yes.
Commissioner O'Brien? Nope, that's not right. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Finding is a unanimous finding of reasonable grounds, and we thank parties and council for being here. Commissioners, at the risk of being terribly rude and pushy, I'm going to suggest a 10-minute break because we are an hour behind. We're 45 minutes behind in starting the afternoon session. You can absolutely say, Amy, you are unreasonable, but that's what I'm.
We have 15 minutes. My apologies to folks that are waiting, but 15 minutes.
Okay, so 12:48.
Good God, 12:50.
12:50.
So I am a practical girl.
Thank you to the folks who are waiting. We appreciate it, and we'll see everyone back here at 12:50.
Thank you.
Some feedback. That did it. That's good.
Two. Thanks, Chelsea.
Oh, right, why are there two of her?
I don't know.
But that's her.
Yeah, that's the first case.
She got it.
Oh, our microphone is very good. Ms. Amundsen, you have two
Hi, this is.
videos open. Can you hang up? You have a phone on here too?
Yeah. Should I turn off my
Two of them.
computer?
Turn off two of them. You
Do
have
that.
two of your videos and one of your phones, and it's giving us feedback.
I'm gonna mute her.
I think it's just your phone.
Okay. Hello? Okay. Hello? Oh. Hello?
Yeah, we can hear you. We're just hoping you
Okay.
can hang up. Do you have your phone on here too? Now we can't hear you. You're muted on one of your.
Oh, yeah, that is her.
Can you unmute the one where we can see your picture? Oh, no, I see there's two of you again. There's your iPhone and there's otherwise. Can you maybe bring it down to one? While we're working on that, Commissioner Ashby, I think some of the folks on the afternoon session were not here in the morning. Would you mind doing the intro again?
I don't mind. Bear with me just one moment.
Yeah, thank you.
All right, we're ready. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and I'll ask you to introduce yourself as you come to the podium or are identified. Thanks. The next case then, if we're ready, Amy, did we resolve our technical difficulties?
I believe we did. Thank you.
Great. The next case then is PA 20-0518. That's Adina Berkowitz on behalf of a minor child versus respondent Maine Academy of Gymnastics. And I understand this is a reasonable grounds case, so we'll hear from the respondent or their representative first.
Yes, and I believe Ms. Amundsen, are you here for respondent? We cannot hear you at the moment. Ms. Amundsen, can you unmute? one of your devices? We cannot hear you. You have two devices in here, I believe, an iPhone and something else, a computer. Can you unmute one of them? There should be a little box in the upper right-hand corner or the picture of a microphone with a red line through it. If you click on that, it will unmute. There you go. But we actually can't hear you. How about your speaker? Can you turn on your speaker? I think before you were calling in on your phone. You need to choose a microphone, choose your speakers. If you hit on, there's a little caret on the unmute button on the bottom of your screen. You can choose your speakers and choose your microphone. Nope, can't hear you. So can you hear me, Ms. Amundsen? If you're talking, we can't hear you. Can you hear me? Can you nod if you can hear me? Okay. Okay. Do you want to call in again using your phone? Or we can come back to this case and start another case and come back to it. We don't know what you're saying. Yeah. We'll give it another minute, and then if we still can't get you, then we will move on to the next case and come back to this one.
Hello.
Hello, we've got you, Ms.
Oh,
Amundsen.
okay. I'm going to take my phone into the other room.
Yeah. I'm gonna try to
Oh, sorry, you guys. Can you hear me?
You can.
Okay, I
Great.
really apologize. I'm sorry. Sorry.
All right, you've got 10 minutes, and I'll remind
Okay.
you not to use the names of any third parties, okay?
Okay, yep.
Go ahead.
Okay, what am I saying next? I hardly hear you. What am I saying? What would you like me to say?
We don't tell folks what their presentation should be. This is your opportunity.
Okay,
to-
okay, my presentation then, I guess, would be that we were accused of not providing handicap parking and discriminating against a child. Neither one of those are the case. We do have handicap parking and always have since we opened our gym in 1991. We do have an enrollment minimum for our classes, 3 students per coach in order to hold the class. That did happen at the same time as Ms. Berkowitz had stated that someone had discriminated against her by parking in the handicap spot. What had happened was someone did park in the handicap spot. She came into the office and spoke to one of our secretaries who was new. She had told me about this, and my response to her was, well, I was mad and upset about it because that was just not a good thing to do ever. And told my husband, and we decided that we needed to make it more clear where our handicap parking spot was. We had a sign on our building, but someone parked in the spot. So we replaced the sign on the building with poles and a sign adhered to the top of it and put it directly in front of the parking spot. And my secretary had written to Ms. Berkowitz and said that she had told the owners about her concern and that we were addressing it. And we would put handicap parking in the front of the building, I think she said by the end of the month. which is a misrepresentation of what I said, because what I said was, can you please tell her that we're very sorry and we're going to address it immediately? That was what I said. And it was translated to Ms. Berkowitz in a different way. And she felt that I think she felt that we just didn't regard her concern as valid, which is certainly not true. And I have been trying to tell her and tell you guys for, I believe, over 2 years now that that's not what happened. And we're very sorry. And we've done all we can to make it more evident where our handicap spots are. Actually, now we have more of them. And, I think that the only thing that I would say that we are guilty of is having our sign not big enough, or not, because people parked in the spot. Although I can say people still park in the spots. And we tell them now more, it rarely happens. It's happened a couple of times, and we'll have to go into our lobby and say, did someone park in the handicap spot? And some perfectly able person will get up and move their car. And it's it's kind of a moral and an ethical thing that people just tend to do sometimes, but that's not the kind of people that we are. We would never park in a handicap spot. We don't condone it. And we always try very hard to take care of our students and take care of our families. And so it was not only insulting, but kind of hurtful for us to hear that someone would think that we would ever do something like that. Right now we have close to 800 kids a week attending our program. We've never had anyone say anything like this before. When it was told to me, it was told to me in a list of things that I needed to know for the day, and down the list. And she just told me that someone came into the office and said that someone parked in the handicap spot. That was all that I heard. Then it escalated, and that's what happened. And again, Adina, I am very sorry that this happened. We've done everything we can to make it more evident where the handicap parking is. And we're just very sorry that you feel that we would ever discriminate against you or your son. That just is not the case. And that's all I can really say. It's just, it's not true that we would do something like that. And we always have had handicap parking. No one ever came out to look at our building to see that we have a sloped edge right next to our handicap parking spot. On one side, the other side is a curb. Clearly, it's been there for quite some time. It is handicap parking right next to the handicap spots. And all I can do is keep saying it, sending pictures, telling you these things. But if no one were to come out to look at the building, it's just really my word against hers. So that's my presentation.
Okay, thank you.
Mhm.
Let me just hold on. Any commissioner questions for Ms. Amundsen at this time? Commissioner Douglas?
Yeah, good afternoon, ma'am. It's just not clear to me what the deal was with the sign. I mean, at the time of the complaint, was there a sign sort of designating this parking spot or spots as handicapped? So where was it located? Like, what did it look like?
Yeah, I had sent pictures. It's right in front of the handicap spots on the building. We had it adhere to the side of the building. But it was not directly in front of the spot. That's true. And she pointed it out, and we fixed it immediately because someone parked there. Now, like I said, people still do have the nerve to park there, but it was on the building, not on a pole at the front of the spot.
Right. And is it your contention that when somebody parks there, or when somebody parked there at the time, that you can't see the sign?
I would think that they could, like they can,
Okay.
right? They still park there at time to time. They
No,
just
I-
do. They just do because they see it open and they think it's convenient and they take it. And they maybe think that they're only going to be there for a little while, although that's not been the case with the two instances I'm thinking of. It was a mom sitting there chatting with other moms and parked in the handicap spot. I think it's just some people do that, whether there's a sign there or not.
Sure. And was this parking spot or spots, was this in the main lot or was this in some other location?
Well, we have a lot in the back of our building. We used to rent the building, and the back of the building was the entrance. We rented the back half of the building, and we had a handicap ramp that entered the back of the building where our gymnastics school was. When we purchased the building, we took the wall down and put there's parking in the front and in the back. So it's more convenient because the front entrance does not have a ramp that you need to go up to, and it goes to the front of the gym where the office is, and that's where the handicap parking spots are, right in front of the building.
Okay, thank you.
Commissioner O'Brien?
Thank you. Well, I think you can answer this question. If not, our council maybe could. Regarding the sign, does it have to be that the blue handicap signs that we see, or what, how is it designated?
Well, we brought the regulation sign, which is 12 inches wide, 18 inches high, and 60 inches off the ground. That's what we purchased, what the regulation sign was. I believe it's white with blue letters, and there's a blue handicap logo on the ground.
Thank you. Any other commissioner questions for Ms. I see both Commissioner Ashby and Commissioner David. Commissioner Ashby?
Yeah, just to clarify that last question that Commissioner O'Brien asked. So you say you purchased that, what appears to be a standardized sign. Do you mean you purchased that for the sign that you affixed to the pole that you purchased after this complaint was raised?
Yes.
Or are you referring to the, how about the signs?
We had one. I'm sorry. What'd you say?
How about the signs that were affixed to the building that were present before the complaint was raised? Are they also those standardized signs with the logo and the blue letters?
You know what? I honestly, it was a handicap sign that we purchased somewhere, but honestly, it was probably maybe 20 years ago. I don't know what it looked like. I can't tell you exactly what it was because I don't remember. It did say handicap. No, you know, I think it didn't even have that on. I think it just said reserved for, I don't even know. I think it might have, honestly. It said reserved for something. I looked at pictures to find it because I don't know what it looked like, but it wasn't enough. And that's our mistake. You know, I do have to say that wasn't enough because someone parked there and Adina felt the way that she did. But, you know, again, people still park there and it is the sign. Was it the specific sign that we should have purchased? I honestly can't tell you. I think it may have been, but I'm not sure. I know it said reserved on it. That's all I could see in the picture.
Great, thank you.
Mm-hmm.
Commissioner David, did you have something?
Yes, Ms. Abinson, I heard you say you have 800 kids in the school from time to time. Are you aware of a requirement in the law, and there is one, as to how many handicap spots you need?
Yeah. Yes, and we got that from the city of Westbrook. The code enforcement told us that you need 25 spots. We have
need one per 25
people. So we don't have 800 people at a time. We have 800 kids throughout the week. And most of the parents drop their kids off and pick them up. We do have viewing, but there is never 50 people in the gym viewing at one time. If we have a gymnastics meet or a function, which is rare, we have a relationship with Lee Dodge across the street, the Lee Auto Mall, and people can park in their parking lot. They've been very grateful about that, or gracious about that.
Sorry, could you not use the names of third parties?
I'm sorry. Yes.
Thanks. Commissioner David, did you have any other questions?
Yeah. So how many parking spaces do you have front and back spaces?
I'd have to count. I don't know. I know that there's 5 in the front. Down the side, there's probably, I really don't know. Maybe 10 and 20 back.
That's all. Thank you.
Any other commissioner questions for Ms. Amundson? Okay, Ms. Amundson, when we come back to you, we're going to hear from complainant next. When we come back to you, you will have about 5 minutes. Okay.
Yep.
Ms. Berkowitz.
Hello, thank you for having me today. My name is Adina Berkowitz, and I feel a little strongly about this case. I'm sorry if I come across, obviously this happened to me personally, but I also work in public health and I'm a patient advocate. And so I am wanting the respondent to understand that this is not a personal complaint, but this is a complaint. So there is equal access and accessibility for everybody who comes to that business. So I would like to first note that when I sent my original email to the office on February 26th, I did copy and paste the parking requirements by the federal ADA laws. Of course, I understand that on a state-by-state matter, those vary. I did let them know that I had a few weeks prior gone into the office to make a complaint that there were no parking spaces. So I want to clarify some of that information that the respondent gave. The secretary, Sammy, was not the person that I originally spoke with. It was a gentleman that I had spoken with. I'm not sure.
Berkowitz?
Yes.
Sorry to interrupt. Can you not use the names?
I'm so sorry. Okay, yes. That the secretary that the respondent is noting that I had come in to speak with is not the correct person that I spoke with. And I was not coming in to complain about somebody parking in the space and discriminating against me. There was no parking spaces labeled for disabled parking spots. There is a block of tarred parking spaces in front of the building. It was not striped in any way. It wasn't even striped to separate regular parking spots. It was just one big black tarred area. No disabled parking signage on the ground that was painted. There may be now, but there wasn't then. And there wasn't about 8 months later after my complaint when I drove by in October during the pandemic. Things were likely still shut down there and weren't they may have not been open at that time. I'm not sure, but I drove by just to see if they had, installed poles, signage, striping. None of that had taken place. So at that point in time, I had taken a photo of the front parking space, which I had submitted to the Maine Human Rights Commission when I made my complaint. And of course, through the investigation, the respondent had sent in a receipt for a sign that they purchased on Amazon, which again is still not the correct signage on a pole with, striping needed. And there were satellite photos that were acquired through the investigative process showing that there was no signage striping on the flooring. So I just want to know that, obviously we know that ignorance of the law doesn't negate that the law needs to be followed. But I'm just wanting to make clear that just because there's, parking in front doesn't mean that that is reserved parking. It has to specify. And if there are people who are parking in those spots, after they have installed signage, then I would like to note that it should be the responsibility, or my opinion, that it should be the responsibility of management and ownership to, get those vehicles towed. So those people aren't parked there. There should be access to the building for everybody who comes to visit. Maine is an aging state. Grandparents are coming to bring their children, for gymnastics activities, and they may have health issues and need that parking space. So I think that's really all I have to say. Yeah, there was just nothing there when I was there and my son had been attending that gymnastics academy for over 2 years, and there never was designated parking at any of those points in time.
Thank you. So Commissioner questions for Ms. Berkowitz? Seeing none. All right, so Ms. Berkowitz, you'll have about 5.5 minutes when we come back to you. We're now going to turn back to Ms. Amundsen. Ms. Amundsen, you have about 5.5 minutes. You don't have to use them, but you can. Oh, hold on, you're muted.
Oh, hi.
There you go. Yep.
We opened our business in 1991. In the back of the gym was our handicap parking. There is a mark on the wall still for where the handicap ramp was. In the back of the building, there was a sign on the building that said no parking reserved for handicap. I really do not remember the language. I don't remember if it was what the sign looked like exactly. The signs that we purchased are we were told that they are regulation signs. They said, 12 inches wide, 18 inches tall, 60 inches above the ground. We did that. We have had painted lines on the ground. They fade, we paint them again. We have a curb where the wheelchair access directly next to the handicap parking is. That's clearly for easier access for someone that has a disability. But, I would agree with Ms. Berkowitz that it wasn't enough. We needed to make it more clear because this happened, and we did, and we will always continue to do that. And I'm very sorry that it happened to her. However, we have always had handicap parking, and it's never been a concern in the past. As soon as anyone has a concern in our business, for whatever the reason is, we always take it seriously and always do everything we can to address it and correct it if we are in the wrong. This situation, the sign on the building was not the right sign. And people parking there now, having their car towed, I guess, I feel, again, we feel if that's what I have to do, then I will. I'll do whatever we have to do to accommodate everyone. And I think that sometimes people park there and we don't know it. I don't know. I know that I have been there on 2 different occasions. I can recall when someone did park there and I went in and asked them to move the car. If there's something that I should do above that, we will do that. But I'm looking forward to better, and we've addressed it and have made it very clear. And we sent letters to our entire mailing list about parking there. And I don't know, other than having their car towed and apologizing for Ms. Berkowitz's inconvenience. I don't really have much more to say, because I can say that we've always thought that our handicap parking was regulation and adequate until it was brought to our attention that it wasn't. And that's really all I can say.
Thank you. Any commissioner questions for Ms. Amundson?
Yeah, I do have one more thing to say. Can I say one more thing?
Yeah.
It's been interesting for the past 2 years exploring this, talking to the town or the city of Westbrook, exploring other people's businesses, and our handicap parking is beyond most businesses. And I think that businesses aren't aware of the rule, and that if they were, they would all comply. I wasn't aware that we didn't have adequate signage. I don't know what can be done, but I think that maybe a letter to all businesses in the state of Maine should have simply a letter, an email, telling them that it's the law. You must conform, and these are the regulations, because we didn't know. And I really think most businesses don't know, because most businesses do not have what's required, from what I've noticed. That's all.
Thank you. Any commissioner questions for Ms. Amundson? Seeing none. Thank you, Ms. Amundson. Ms. Berkowitz, you have about 5.5 minutes left.
Thank you. With the respondent noting or making a statement that most businesses do not have the correct parking in the city of Westbrook, that would imply that more than 50% of businesses in that city or district do not have adequate disabled parking, and I think that's unlikely. But I do want to note that the back door, maybe, when they opened in 1991 and they had the back door, maybe signage was there. I never noted signage. I surely didn't notice it in the photos that were sent in the investigation to the commission. There is a ramp that was back there that doesn't look usable by anybody that could be in a wheelchair, because it looks very, it's just steeply inclined. And I don't know what the regulations for that is by the law, you know, but I mean, certainly the back door hasn't been used during the time that my son was participating in gymnastics events, and we had always gone through the front door because that's the entrance to the building, regardless of if there was something in the back years ago that is not used any longer. And again, there was, you know, with the lack of visible signage in the door, you know, anywhere on the property, it just, you know, and the respondent noting that they have fixed it since, and that they didn't know anything about the lack of parking that, or the laws. It just, you know, seems like they're not fully taking responsibility by just saying, you know what, we didn't know, we fixed it, and it's fixed for future people, and that's it. That it could have been that simple. But I do want to make one last note too to the respondent. Note that, you know, they apologize for my inconvenience that this happened. It's more than an inconvenience when somebody has severe declining health and has to walk a block and a half with a walker, need an inhaler by the time they get to the door. It's an adverse health effect and or outcome for that person. And I just really want that, you know, the respondents to understand that, you know, it is and was a burden to me, and likely a burden to other people for many years because there was the lack of space and signage. Thank you.
Thank you. Any commissioner questions for Ms. Berkowitz? Commissioner O'Brien?
Thank you. Maybe I missed it, but I didn't hear you comment on the other allegation about your son. Could you speak about that for a second, please?
Absolutely. And, you know, that I do feel, I know there was no reasonable grounds found by the investigator on the discrimination against my son. That is a little more subjective because that's how I felt with the close proximity and time to my son being removed from the class. We did not, you know, he was based on the attendance records, you know, he was in the class during the same time for a long time with the same amount of low attendance in that class with students. And I know there were some students who moved to a different class or somewhere on a trial, but it was always a low attendance. And we were never told that if somebody moves out that he was taken out. So I did make the assumption that my son was discriminated against, or that our family was discriminated against because we made this complaint. Nobody was doing anything about it. I had mentioned multiple times in the management office about the parking spaces. I mentioned in person and in email that we would have to remove my son from the class if they couldn't get parking, because I just could not physically get into the building anymore. That way, if there was no parking available. And so again, that is the perception that I had, and the investigation found that there were no grounds against that. It's a little more subjective than objective proof showing that there's no signage by photos or satellite images, or, you know, that the fact I had to send them any of the other information for the parking law. So I'm open, you know, I don't want to try to object against what the investigators or the commission rules against as far as that concerned, but that was my perception. But it is subjective. And I did mention that in one of my statements to the investigator, that it is more subjective to determine that kind of discrimination. So there's no way that I could fully prove that, or, you know.
Thank you. Any other commissioner questions for Ms. Berkowitz? Seeing none. Thank you, Ms. Berkowitz. Now we'll turn to the investigator.
Good afternoon, Commissioners. Courtney Byrne again, also assigned to this case. I don't have anything to add, but if you have any questions, I'd be happy to answer them.
Any commissioner questions for the investigator? Seeing none. Great job, Courtney. So commissioners, you've heard from the parties and the investigator, and I will note that the proposed second finding, the no reasonable grounds regarding retaliation, Ms. Berkowitz actually did not object to that. So that's one where typically you would adopt the recommended finding if there hasn't been an objection on it. So we have two findings here. All right. Commissioner O'Brien.
I would move that there are reasonable grounds to believe that Maine Academy of Gymnastics discriminated against Dina Berkowitz and her minor child on the basis of disability, and conciliation of this claim should be attempted. And also that there are no reasonable grounds to believe that Maine Academy of Gymnastics retaliated against Dina Berkowitz and her minor child for engaging in MHRA protected activity, and this claim should be dismissed. Do I really have to read the whole deal?
You don't. We can fill in most.
All right,
of the-
thank you.
Thank you for doing it. I
All right,
appreciate it.
thank you.
Very thorough. Is there a second?
Second.
Okay. So it's been moved and seconded to find reasonable grounds on the disability discrimination claim and no reasonable grounds on the retaliation claim. Is there any discussion among commissioners? Seeing, Commissioner David, I say yes.
I just want to say to Ms. Abinson, I appreciate her candor and understanding that they were in the wrong on these things. These cases are published. We as a commission need to adhere to the law and to the findings, and the results will be talked about and the remedies will be talked about at a later stage in the proceedings.
Is there any other discussion among commissioners? Seeing none. So the motion is to find reasonable grounds on disability discrimination, no reasonable grounds on retaliation. If you're in agreement with both. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
So the findings are reasonable grounds for disability discrimination and no reasonable grounds for retaliation. The commission will be in touch with the parties to discuss the next steps, and we thank you for being here.
Next on our agenda is MHRC number E21-0215. That's Christopher DeCapua versus the town of Leamington, and this is a no reasonable grounds case. So we'll hear from the complainant or his representative.
Yeah, and before we do start that, I just want to note that there was a typo, which was my fault on the agenda, in that the case caption read Capua versus Town of Leamington and Melissa Perkins. And I did hear from Melissa Perkins, who was very concerned about this. And I just wanted to apologize for my error there. That was involving a completely different case, and she has nothing to do with this case at all. So we would be looking to hear from Mr. Chapman, I believe.
Yes, ma'am. Hi, John Chapman here. It's my privilege to represent Christopher DeCapua here, who is a longtime veteran of the EMS system in the state of Maine and with the town of Leamington in particular. This is interesting in that it's a case you would think would be a discipline case in light of the investigator's findings, but it's not. The investigator's findings specifically were that and I'm calling attention to page 4, item 6. To the contrary, the evidence establishes that the entire department was dissolved and restructured to prevent the town from losing its license to provide emergency services. That's interesting in that it suggests that eliminating the job or the job function of Chris DeCapua advances the ball somehow in the town losing or not losing its license with EMS. And there is no allegation, no suggestion that Christopher DeCapua, Deputy Chief DeCapua, did anything wrong. in fact, the finding is that he was one of the complainants that started the ball rolling, both in 2019 and more recently. He, as recently, and I pointed this out in my submission, as September, had indicated that there were problems with the way the department was being run. And it is strange to see that the evidence establishes that they dissolved the entire department and restructured to prevent the town losing its license. And you would think, given the way that the shifting burden works in these cases, that there would have been something from EMS, the main emergency services, indicating administratively that that somehow, in some way, would have been the case. It's not, it never was. In fact, we have a couple of different stories being told by the emails submitted in the final submission to the investigator in this case, Ms. Brindley. We were told that the department was extremely top-heavy, and that was on the November 21st email, or excuse me, text message that was submitted. That was by the chief, who, interestingly enough, was one of the subjects of complaint by AT, who started this off. I think if you look at the submissions, you'll know who that is, but I don't want to use any names. So we have the top-heavy argument, and we don't have any justification of that, which would involve an economic analysis. Are these people being paid too much? Are there too many of them? Or is this what happens a lot of places where you get more pay, and the way they justify it is by giving you a better position? Or perhaps a situation where they have some, for some reason, that he's been doing a poor or substandard job, and so they're shifting responsibilities back to the chief. But there's no allegation, no suggestion, no hint, and no evidence that Chris DeCapia was doing anything bad or wrong. Instead, he made a series of justified complaints. And against that backdrop, he was found to be somebody that needed to be reorganized to avoid the department losing its license. And of course, there is an answer to whether they lost the license or not. That doesn't appear in the record, so I'm not going to talk about it. But it just never happened. And there was a third, by the way, in the materials that were submitted to Ms. Brindley, justification for why this was being done. We have a full-time chief to develop and implement policy. The chief should be the disciplinarian. And it's interesting in light of what had actually been done. And the town's HR, unfortunately, is the select board. I don't think it's a secret that this department is and has been a tinderbox waiting to light up. Again, submitted to Ms. Brindley, but somehow not acted upon in the mix. One would think if the town's license is somehow in jeopardy, absent this restructuring, that would have been in some way substantiated. But in fact, the opposite was. It is a situation where Deputy Chief DeCapua and Deputy Chief AT were both complainants, both made justified complaints that were acted on, and somehow both of them ended up getting reorganized out. It doesn't make sense. And there are some other things that could have made sense too, the top-heavy argument. I agree that in a town of 3,900 people, which is what Leamington is, there seem to be a lot of deputy chiefs, but that may have been what they needed to do to get people to do the job at all. But we don't know that because that analysis was never done. And I don't think it would have turned out, I don't think it would have turned out very well had it been done. So we have a shifting burden of proof, and the burden of proof shifted according to investigator Brindley's analysis. And we have a statement not proof. And the statement flies in the face of all the evidence in this case. The statement would make sense if this was a disciplinary case about Christopher DeCapua, and that was substantiated somehow. And I had to chuckle to myself listening to one of the earlier cases regarding somebody that said, this is not a case that's a classic whistleblower case. I believe the person's last name began with an H earlier today. Well, the one we have is, we've got an individual who made complaints. They were all justified. And that person got reorganized out of a job along with AT. And supposedly it was required to maintain licensure. How? That's unexplained because it's not explainable rationally. That's all I'm going to say right now.
Thank you. Attorney Chapman. Commissioners, any questions at this time for Attorney Chapman? Seeing none. Attorney Chapman, you'll have about 3 minutes when we come back to you.
Thank you.
Turn to Mr. Brogan.
Thank you, and thanks for hearing this today. I'm Jonathan Brogan, representing the town. I was a bit surprised at Attorney Chapman's presentation in that he seems to have lost the thread of this case. This is not, again, despite his client's belief and his client's pressing of this case about Mr. DeCapua, it's about the fire and EMS service of the town, which was about to lose its accreditation because of mismanagement by the chief and who was fired. In the process of dealing with that, the town made the decision to reorganize the whole management structure of the fire department. It was not directed at Mr. DeCapua, as has been proven and as was shown through the investigation, but was directed at the whole group of officers who were there. And in fact, one of the assistant chiefs resigned. Another assistant chief recently filed a similar complaint to this one, claiming that somehow he was discriminated against because he was a whistleblower. None of these people were discriminated against because they were whistleblowers. The whistleblowing resulted in the investigation, which led to the town having to take this drastic action of redesigning and putting together a fire department and EMS service so that their citizens would be taken care of and so that their fire department would work properly. It has not been an unbumpy issue. What's happened today, what has happened is a continuing problem, and it's hopefully going to be taken care of soon. But the theory, as the investigator pointed out, that somehow this was a conspiracy to get Christopher DeCapua is absolutely without fact, and the investigator pointed it out. The investigator made no factual or legal errors in her analysis. She analyzed the facts that were there, which was Christopher DeCapua was not removed because he was a whistleblower. He was not removed at all, in fact. He kept his pay. He kept everything but his title. And obviously, for the legal analysis, the title is enough to say that there was the ability to shift the burden to the town. And then the town appropriately responded and showed that, in fact, there was not a causal connection. In fact, there is a causal connection in Christopher Capua's mind that there was some sort of conspiracy here. Attorney Chapman has not been successful in showing what that conspiracy was or why the town would want to have this tumult going on where they don't have a fire chief and they have to reorganize. But they did it. It was not directed at Mr. DeCapua. And there is nothing here, no facts here, as the investigator pointed out, to prove the case that the complainant has to prove. When the burden shifted back to the town showed that, in fact, there was probative evidence to demonstrate a non-discriminatory reason for the adverse action of removing the titles of all of the management in the fire department. And that was because they needed to have a fire department that worked and they needed to start again. Mr. DeCappo was not removed because he pointed out what, as Attorney Chapman correctly pointed out, was a problem, and that problem was addressed. He was removed along with the other people in the management structure so that the fire department could try to renew itself and go on. And Attorney Chapman is correct. It has. This investigation demonstrates exactly what the investigator told, and she has not made any factual errors or legal errors in this case. Thanks.
Thank you. Any commissioner questions for Attorney Brogan? Seeing none. Attorney Brogan, you'll have about 5.5 minutes left. We're going to turn back to Mr. Chapman. Attorney Chapman, you have about 3 minutes.
Thank you. Couple things. First, on page 3 of the chronology that accompanied the initial complaint, there is a reference to a selectman whose initials are SH, that they were looking into ways to deal with people that make that in essence do things against the town. Now that's not only something that he recited, that's something that's in the December 30, 2020 recorded video of that meeting, where they also discuss the restructuring, which is, it isn't often we have direct evidence as advocates like this, but it's nice to have it, and it's sad when it's ignored. The second thing is that the term restructuring isn't a magic word. Restructuring is pretty well, actually, it's usually called reorganization when the EEOC uses the term. There's a Quaker Oats case that talks about it, as well as Karen versus Scott Paper Company, which is a 1993 case. Both of those talk about age discrimination cases where somebody finds out that somebody's looking for his job when they get their pink slip. That's not this case. This is a town of 38 to 3,900 people that it's pretty well known who's involved. And this is a case that apparently starts to address the problem that they decided to address by getting rid of these people's jobs. That is just standing reality on its head. You'd think that they might have given them more responsibility if they're the ones that are pointing out the problems instead of getting rid of their jobs. And I have tremendous respect for Mr. Brogan. He and I do a lot of cases together, but this is a stretch.
Thank you. Any commissioner questions for Attorney Chapman? Commissioner David?
Attorney Chapman, I understand you to be arguing that the termination is in retaliation for him reporting the violations of the hazmat materials and the training and that kind of thing. Is that correct?
That would be one of the reasons. The question is it retaliatory? Whether you like or don't like the person, if he's a burr under your saddle and you do this to get rid of him, it doesn't matter whether you like him or not. But that's certainly one of the inferences that one could get from that December 30, 2020 meeting and the comments made there.
Is that your allegation of discrimination?
Yes.
Because I understood as I read through this that the allegation of discrimination was because of his involvement helping a coworker in a prior complaint before the commission.
Well, if you look at the actual materials that are submitted, it wasn't just that. That person who is AT, and ultimately they were successful, and we submitted, or I should say my client submitted, the offer of judgment that was accepted by the town in that discrimination case where he testified. He also submitted to the investigator the additional activity on protected activity on his part that he was making
John-
complaints, as I pointed out, right till September of 2020.
Isn't it a yes or no question? Is your allegation of discrimination based on his helping that prior complainant?
Yes, in part.
Okay, and the other part is your allegation of discrimination is based on him making the report about the training and the hazmat and that kind of thing, correct?
Yes. He continued to be
Thank you.
a problem.
He continues to be a problem?
A problem for somebody that views complaints like this as a reason that they might lose their license, which is interestingly dovetailing with what the investigator found.
So you're arguing that the whole reorganization was a cover for getting rid of him?
Not the whole, no. It was a way to get rid of not just him, but by the other primarily affected person, AT.
Thank you.
Any other commissioner questions for Attorney Chapman? Seeing none. Thank you, Mr. Chapman. Mr. Brogan, you have about 5.5 minutes.
Thank you. Hopefully it won't take that long. The selectman quote that Attorney Chapman has referred to, the reason that the Maine Human Rights Commission does investigations because it gives the investigator a chance to look at the witnesses and assess their credibility and determine what is and what isn't. In this situation, that comment was made not in the way that Attorney Chapman refers, but in a way to allow, as they were talking about, the problems that the fire department had, the legitimate problems that were reported by Mr. DiCapo and others, and how to fix them, and how to respond to complaints. And that selectman was saying that they needed to do better at responding to complaints, and they needed to do better at dealing with complaints. Not that they needed to fire people because they made complaints. That's turning logic on its head. As Commissioner David just pointed out, this claim is based upon a belief by Mr. DiCapo that it was a conspiracy against him and another person who made complaints, and that the town selectmen decided they would terminate the whole department, fire the chief, and redesign the department just because they made complaints. There's no evidence of that, and the investigator showed that. This is not a Quaker Roads case. This is not a Scott Paper case. This is a small fire department and EMS service that had real problems. Those real problems led to the firing of the chief and the restructuring of the department, not because it was easier for these selectmen who serve as volunteers, but because it was the right thing to do to get EMS back on track and to get the fire department back on track. Mr. DiCapo does not have any evidence of this ongoing conspiracy and never did. And the investigators' findings have no factual or legal errors. Thank you.
Thank you. Any commissioner questions for Attorney Brogan? Seeing none. Thank you, Mr. Brogan. Then we'll turn to the investigator. This report was written by Alex Brindley, who is not available today. So we have lead investigator Jane O'Reilly.
Hello. Yeah, I'm Jane O'Reilly. As I mentioned, I was not the investigator on this case, however, I have reviewed the file as well as support the report. So I don't really have anything to add. I will clarify just again, Commissioner David, since you asked, the allegations from the complaint are both MHRA retaliation and WPA retaliation. The retaliation for engaging in this protected activity of reporting unsafe illegal conditions, as well as supporting a coworker in a prior commission action. Those both of those different allegations that were analyzed in the complaint. I'm happy to answer any questions.
Any commissioner questions for Jane? Seeing none. So commissioners, you have heard from the parties and about the investigators report. We have one proposed finding here, and we will be looking for a motion. Geez, Julia today.
Oh, Julia today. I would submit there are no reasonable grounds to believe that the town of Leamington discriminated against Christopher DiCapio. You fill that one in for engaging in
Maine Human Rights Act and WPA. Protected activity of the complaint should be dismissed.
Is there a second?
I'll second.
So it's been moved and seconded to find no reasonable grounds. Is there any discussion among commissioners? Seeing none. If you are in favor of a no reasonable grounds finding, you will answer yes here. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien. Yes. Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
So the findings are no reasonable grounds, and the commission will send a letter to parties and council, and thank you for being here today.
Thank you.
Thank you.
Yes, ma'am.
Our next case is MHRC H22-0219 AD. And it's also filed as HUD number 0122202338. That's Stephen Savoy versus Musam River Campground Inc. et al. And that's a no reasonable grounds finding. And so we will hear from the respondent.
From the complainant, sir.
Let's try that again. We'll hear from the complaint. Well, we'll hear from the respondent as well, but we'll start with the complainant.
Good catch. I'm actually not sure if any of the respondents are present. I haven't seen anybody. We haven't seen them on the Zoom. No. But Mr. Savoy, you have 10 minutes.
Savoy.
Savoy, sorry about that.
It's all right. Thanks for having me. I'll try to be as quick as possible. The problem that I'm sure you guys read through the case and whatnot. Myself and my wife had purchased this place up in Maine. We're from Massachusetts. Purchased up in Maine as a getaway for us and the kids and whatnot. Back in 14, roughly. I don't know exactly when. 2014, had been there for, up until just recently. It was in the summer. Let me just pull this up real quick. Sorry about this. Yeah, so in the summer of 2014, we had purchased the place. At no point during our tenure there had we been given rules or anything of the campground. I like to try to deal in facts and only, try to take the emotion out of it. What ended up happening, we put in wooden posts with lights on them. I was told that the light posts were unacceptable and we couldn't have them, and they were not part of the common scheme of the campground. My big thing that I said to the general manager was, he said they're not allowed. I said, well, how would I know that they're not allowed when we have no rules in the campground? I wouldn't know if I should ask permission to do anything. How I should park. There's no rules, so it's very difficult to assume what I should and shouldn't ask for. So I installed the lights. Gentleman came over, the general manager, Mr. Emmons, came over, said these are coming out. I said, well, I'd like a meeting with the owner. And he said, nope, these are coming out. These are coming out. I said, listen, can we just please have a meeting, the three of us, with the owner, and we'll see what transpires. Well, the way that it was worded from Miss Brindley was that I refused to go to a meeting and all that. I have text messages that were submitted that were talking about the meeting that never happened. There was never a time set up or anything like that. So I would still love to have the meeting. But so the polls ended up coming out. He ripped them out when we were gone for the week. He ripped them out, left them there, and we came back up the next weekend, and they were on the ground and lights were broken and everything like that. No big deal. Just kind of went on with my this was in August. We are out of there in October. closed up, did all of our stuff that we normally do for the week, the year-end closing. In December, we received a letter saying that we were terminated from, returning there due to things that were basically they couldn't prove that these allegations that we used electricity too much, we didn't fit in with a common scheme of the campground, and I forget the last one. There was rudeness to staff. Again, none of these were substantiated. They were not proven. So we were kicked out and told that we couldn't come back. I don't know if it was retaliation because I asked Bob to Mr. Emmons that we couldn't, that we wanted to keep the lights up. I really don't understand. My big thing is, and there's no rules in there, so why would I go and ask to put up lights that would help me with my disability when there are other people, again, pictures and everything that I submitted, pictures of plenty of other people, I would say half the other people in the campground out of 114 people have lights similar, if not the exact same ones, which I have pictures of. Just doesn't make sense to me. You wouldn't go to a place of business and ask someone to use a wheelchair ramp. You would use a wheelchair ramp. Anybody would. It's no different. If someone else can have lights, why shouldn't I be able to have lights? That's all. That's all I have.
Thank you. Any commissioner questions for Mr. I'm probably going to say your name wrong again. Savoy.
That's close enough.
Sorry, I apologize. Commissioner O'Brien.
Thank you. Real briefly, if you can, you use the word when you began of purchase. So that you purchased something that here in Maine, and I'm a little confused in that it sounds as though you leased it, but is it a spot that you come in and bring a camper in, or could you explain a little bit?
Certainly. It's a seasonal campground. So I don't know the exact dimensions of it, but let's just say a 50 by 100 spot that you put your own camper on. And like we had purchased one that was already there. So there's 114-ish campers throughout the whole campground. You each get maybe 60 by 100 foot area that you can utilize. That's basically your land, your thing that you are essentially renting that space from them.
Any other commissioner questions for Mr. Savoy? Seeing none. Thank you, Mr. Savoy. And I don't see respondents present. So in that case, Mr. Savoy, unless you have anything you want to add, we're going to move on to hearing from the investigator.
Not at this time.
Well, this will be your last opportunity. Yeah.
I think, let me just check real quick here. So the only other thing I had, the poles were installed in 2021. And contrary to what Ms. Brindley's claims of not believing I had to ask permission, which was one of her things on the factual background, it didn't make sense to me that she felt that I didn't have to ask permission. I wouldn't know what I should or shouldn't ask permission without rules. Very difficult to deal with a place without rules. That's it.
Thank you. Any commissioner questions for Mr. Savoy? Okay, thank you, Mr. Savoy. And we'll turn back to lead investigator O'Reilly.
You're just gonna have me for the rest of the day. So I don't have anything additional to add. If you have any questions.
Any commissioner questions for Jane?
Well, I mean, Mr. Savoy is, I hope you're probably, I'm pronouncing your name right, sir. Mr. Savoy stated. there were
It's
no
Savoy.
rules. Yeah. He stated there's no rules here for him to adhere to or to notify him as to what the requirements are. Do you have any idea if that's accurate or not?
There are none in the record. There were none that were provided. The issue that was focused on in the record was not so much whether or not there were rules, but whether or not Mr. Savoy was being treated differently based on his disability. It ultimately isn't relevant to the determination in this investigation, whether or not there were or weren't, or even whether or not he was in violation of them. It's whether or not he was being treated differently in this instance because of his disability. And the investigator found that they had no knowledge of a disability, therefore it couldn't have been based.
No, Mr. Savoy, your opportunity to talk is over now. So I'm sure you disagree with something she said, but you don't get to say it now. Any commissioner questions for Jane? Seeing none. Thank you, Jane. So commissioners, I'm sorry, Commissioner David? Oh, was that a question?
Jane, I know this is a little bit unfair because it's not your report. Is there anything in your reading of the report and then in comparison to the presentation by the complainant that causes you question? Are you
No.
fully behind the report? None?
Yes, yeah, absolutely.
Yeah, okay, thanks.
Thank you. So commissioners, you've heard from the complainant and from, we presented the investigator's report. At this point, we'd be looking for a motion. There's one proposed finding. Long now. Julie can't do everything. Guess you might have to. Do it. Okay, that's good. Oh, Ed, there you are. Okay.
I'll move that we find that there's no reasonable grounds to believe that respondent unlawfully discriminated on the basis of disability, and the complaint should be dismissed.
Second. So it's been moved and seconded to find no reasonable grounds on the basis of disability. Is there any discussion among commissioners?
All I would say is that I appreciate where, I'm just gonna call him Mr. S, is coming from. I just don't think it's a discrimination case. Maybe some other kind of case, but I don't think it's a discrimination case.
Thank you. Any other discussion among commissioners? Seeing none, thank you. So at this time, there's a motion to find no reasonable grounds. If you say yes, you are in agreement. Commissioner Ashby?
Yes.
Got to see your hand. There you go. Thank you. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Okay, the finding is no reasonable grounds to believe discrimination occurred, and I thank you for participating, Mr. Savoy. And we will send a letter to the parties confirming the finding. Now we are at our last case hearing of the day.
Holy, forgive me. The next case is H22-0222 AB. That's Zelia Korea versus Bayview Apartments and Bob Hutchinson. Remind me, Amy, this is a no reasonable grounds case?
It is a reasonable grounds case,
Oh,
sir.
I guessed wrong. Reasonable grounds case, we'll hear then from the respondent.
Thank you. I believe Ms. Millenden, and I'm sure I pronounced that wrong. Oh, we can't hear you.
Mellantine.
Mellantine, I would not have guessed that. Thank you for telling me.
Thank you. Good afternoon, commissioners. My name is Kelly Mellantine. I represent Robert Hutchinson and Bayview Apartments. From our perspective, there is no evidence of discrimination in regards to the reasonable grounds that was found by the investigator on the basis of public assistance. This issue really is based upon a storm door in an apartment. The storm door was repeatedly damaged. The inspection found that the door was damaged from where the complainant lives. The agency provided my client with 3 options as to addressing that issue: repairing the door, replacing the door, removing the door.
My client removed the door, which was one of the options provided, because it was the most financially advantageous option provided to my client. It would be more expensive to repair it. It would be more expensive to replace it. This is the same behavior that my client engaged in over the last 2 years for all of these structures on the property. The complainant was treated no differently than any other tenant at the property. I would note that there were several factual errors in the investigator's report, including the fact that the storm door on the complainant's property is not included within the contract with the agency. Here, I think the issue is the course of conduct from my client. Certainly, there are issues of credibility. There are conflicting statements of the complainant about when the door was broken and how it was broken. There are conflicting statements by the complainant in regards to when complaints were made or not made regarding the damaged door. There were conflicting statements. And in fact, there's a factual error saying that she complained repeatedly, and yet the record evidence shows that my client was told he was not allowed to access the door by the complainant. Certainly, I think that those issues are in dispute. My client made a good faith response based upon the directive from the agency on how to address this issue. He engaged in the least financially expensive option with the knowledge of the agency, as the agency had inspected the door after it was removed and then said that there were no issues with the premises. Certainly, there's an opposition that I filed with the commission dated November 11th, which details the factual issues by the investigator, including the fact that the investigator alleged that my client did not repair the door because she was a recipient of public assistance, when my client made no such statement during the IRC or in any of the documents provided to the commission. The investigator failed to denote that there were multiple and repeated statements made by the complainant that the investigator did not find credible. Furthermore, that the fact that the investigator also omitted from the report that my client acted in regards to the direction from the agency. The investigator's report also excludes statements made by the complainant, including the fact that she did not know why the door was removed and certainly didn't allege any discriminatory intent at that point. Certainly, the investigator also failed to inquire as to the nature of other repairs that were being made to other units in the premises, the timeline of those repairs, whether those apartments were occupied or unoccupied, which certainly lends an issue for failure to include additional information. We agree with the statements that there are no reasonable grounds made by the complainant in regards to the basis of sex, sexual orientation, or gender identity, disability, or familial status. We ask that the commission decline findings on reasonable grounds, and I'm happy to answer any questions.
Thank you, Attorney Mellentine. Any commissioner questions for Ms. Mellentine? Mr. Ashby?
It just, don't you think it's problematic if your client's position is we are not going to do any repairs at all for those people who have public assistance, but we are for everybody else? Now, I know that the respondent's position is that they did repairs on vacant properties, but to say we're not going to do work for people that are on public assistance is really kind of challenging on its face, isn't it?
It would if that were the case here, but certainly there were repairs that were made repeatedly to the complainant's unit and other units, as noted by our response, and emails between them in which she said there are issues that needed to be fixed, and they were fixed. The only issue in dispute is about whether the door should have been repaired or replaced or removed, and for which my client got guidance, and he followed that. So I understand the investigator's position was that he didn't do any repairs to any other units for people that were occupying them. That simply isn't true. I agree, if that were the case, if my client said, I'm not going to repair things for people who are receiving public assistance, that would absolutely be discriminatory. except that's not what happened here.
Well, and I don't want to argue with you, of course, but did the repair of the door fall into a class of repairs that were sort of more than repairs and were in fact what sort of rehabilitative changes to the apartments that your client was not willing to make for folks that were going to be moving out? I mean, I know no one said, I don't want to help people on public assistance, but didn't someone say, we don't want to make these class of repairs for these apartments when they're going to be vacated soon?
No, I think the issue was a question of how many times that the door had been previously broken by the complainant, and it didn't make financial sense to repair it or replace the door when it was more financially beneficial to simply remove the door, since the door was not part of the contract and had been added on subsequently.
All right, thank you.
Any other commissioner questions for Attorney Mellentine? Commissioner David?
In that same vein, the investigator does say at the top of page 4, comments made during the IRC were wherein respondent indicated it did not make repairs to complainant's door because she is a recipient of public assistance. And those are direct evidence. And that's because the thing's going to be rehabbed. You're saying that didn't happen at the IRC? I'll ask the investigator, but.
And I realize the investigator isn't here today, which makes that a little bit problematic. But no, my client didn't say, I refuse to, repair that because the complainant receives public assistance. Quite frankly, everyone in that community receives public assistance. And to simply say there was no such statement, what he said was, I didn't do it because it was too expensive to engage in that conduct. Instead, I took another, possibility that was offered to me by the agency.
Which was what?
To simply remove the door, as he did with 7 other units in that facility over 2 years.
So for 2 years, with his plan to convert them to non-Section 8 housing, he didn't fix any doors.
Well, I think he simply chose to remove them as they broke. There's no information in the investigator's report as to the age of the doors, because my client wasn't asked, or the condition of the doors, or how long the doors had been there, or the nature of which the doors were removed. There were no questions by the investigator as to those issues.
Could one view the declining willingness to do maintenance as being encouraging people to move out sooner so that he can get to the rehab of the apartments?
I think that was the conclusion that was drawn by the investigator, but I think that's an incorrect conclusion, since the investigator kept assuming that my client didn't want to do maintenance. He did a substantial amount of maintenance when he was asked by the complainant. The only issue was in regards to the door that had been previously broken twice, and it was more financially advantageous to remove it as opposed to continuing to replace it or repair it at that point.
Okay, thank you.
Any other commissioner questions for Attorney Mellentine? Seeing none, Ms. Mellentine, you'll have just under 6 minutes after we hear from the complainant.
Thank you.
Ms. Correa, I'm sorry, Attorney Mellentine, I forgot to confirm, do you represent both respondents?
I do.
Thank you. Ms. Correa, you have 10 minutes, and I've probably pronounced your name wrong as well, for which I also apologize.
I pronounce it Korea because I'm actually Portuguese and I do speak several languages. I really do have a really high education level. As a matter of fact, I just also acquired a BA degree in graphic design because of my conditions. I'm trying to do something from behind the computer. And it is considered an LLC business. That's what I have the license for. And I am trying to better my life. I do have really have background. I also used to work for the Center for Human Rights, which is DHHS. I was the junior counsel for the state of Massachusetts when I was younger. I have several disabilities. I was hired by them despite those disabilities, and I performed my job very well. I have been living here at Bayview Apartments since February 3rd, 2011. I have been stalked by one of his employees. I have been groped by another. I have been they actually walk into my apartment without knocking, even though the outer door's closed. I've been told to make sure my doors are closed. That way they wouldn't do that, but that's upon the Bayview Apartment, the respondents, to make sure that their employees are following the rules. The respondents don't provide any security. I have complained about that. I have also complained about the fact that I want things fixed here. At that door, I asked for 11 months. I have emails sent to the respondents asking for that door, which was a lock, that the respondent was actually the owner, was here, present in this apartment, and they both came to the back door. There was nothing wrong with that door when they came to the door. I was in the back bedroom discussing the screen door, the screen that was supposed to be provided, and a bush to be cleaned up a little bit because I needed to, there was an access exit, which I was told that the bush was going to stay like that because even though I would not be able to propel myself over or even go around it because the window needed to be open for me to be able to exit, I had to call the code enforcement for that. So the owner is here. I actually let them both in. He sent his employee to the back door. He went to the back, out to the front. They were discussing that. Then the employee tried to come into the back door, and he pulled on the nose so hard that he broke the pin inside the lock, which is the mechanism that does this. And of course, it hooks onto the thing. Then, of course, he could not open the door. I couldn't open the door from inside because it broke it. So I couldn't open it. I couldn't put the lever up and down. I told him, come through the front. He did. And then, of course, I called over the owner. I says, hey, your employee just broke the store. He's like, oh. So we went back to proceed to where we were discussing. And then as they were leaving, I discussed the employee and the owner with the respondents. I said, hey, that needs to be fixed. He said, well, he's done for today. I says, okay, I'll remind you emails. I've asked for that door to be fixed for 11 months. Okay, which was the only thing wrong with it was the lock. Their door was not broken in any other way. As a matter of fact, the respondents had provided me a screen for there so I can get some more circulation because there's windows in this apartment that I cannot even open because they don't work properly. And I have an injury to my right shoulder because the respondent also refused to fix the front steps. HUD, I know this for sure, HUD walked into this complex and this complex failed miserably for total repairs. I suffered an injury that's for the rest of my life. This is inoperable on its own. And they can't touch me for operations unless it's life-saving because of the conditions of my lungs. I'm borderline needing oxygen. I was born this way. I have this illness that my mother has, my grandmother's had it. I have it, and plus I was also born premature. That's why I have this illness. And I was also in a car accident previously to be hired by DHHS, which is the Center for Human Rights Incorporated. And I have injury to my lower back, my hip, and of course I have discs missing in my spine. So the part that supports me is the part that would help me. I need to access the back door. And the inspectors do not specify exactly what is wrong with the door. They only say, oh, it just needs to be repaired, fixed, you can do this, this, and this. But the only thing wrong with it was just that one little bitty lock. And a cheaper one, I estimated this to be about $40. That was a cheap one where he could have placed there. He's claiming that his actions was to remove the door would have been cheaper. In actuality now, by me only having heat in 2 rooms, which is the ones I'm in, because I have a heat pump and they attached the water heater to the system. So now I can't use the radiant heat inside the apartment. I have bedrooms that have no heat. I mentioned this verbally to the inspectors during the meeting. I also mentioned this to the respondents when they actually did that first. I said, hey, they just did this. I can't use the heat this winter. That was in 2019. And then, of course, the heater just broke and they came in here and replaced another one. But I tell people, I'm disabled. You cannot come near me without a mask on because I cannot get sick. I'm immune compromised. So much as even a sore throat makes me sick. It moves into my lungs. Has what is called a lung infection. And I cannot have that because that can kill me, causes more and more scarring, and I'm already borderline needing oxygen. The respondents refused to fix things in this apartment. Since I actually filed a criminal trespass against the original first employee. And this person is also on another video assaulting another person who's actually physically and mentally disabled. So even though I repeatedly asked the respondents to make sure that he wasn't allowed here in my home, I said, I don't want him in my home. I don't want him coming over here. I repeatedly told the respondents about this other employee that attempted to break into my home because the respondent gave him the key. I said, do not give him the key. I live in this apartment. I'm renting a whole apartment. It's not just pieces of it. It's not what they decide to fix or not fix. My stuff is paid by the United States government, okay? By HUD, by Main Housing. The contract that that the respondents have with them to pay rent, it doesn't specify, oh, you only fix only what you feel like. I live here. That means that windows need to be open because it gets hot in here. Doors need to be operating correctly. I should be able to step out the door without causing an injury to me. That's going to be permanent for the rest of my life, and it's inoperable. It's been going on more than one time, more than one occasion, and I finally decided to file because of the door, because that is the last straw that, like I could say, broke the camel here, because I have repeated verbally and in writing. I've been threatened verbally and in writing by the respondents and their employees, and that's not something that they should be doing to me. I feel that they might not be doing to someone else, or maybe they are, I don't know, but I know it's happening to me. I don't have to prove they've done this to somebody else. I need to prove that they've done this to me. And I feel that with all the paperwork, everything that I filed, and the inspectors' reasonable findings, that yes, there has been discrimination being found. And I agree with that 100%.
Thank you. Any commissioner questions for the complainant? Seeing none. Thank you, Ms. Correa.
Thank you.
Now we're going to turn back to Ms. Millentine. Do you have about 5 minutes if you want to add something?
Thank you. I will point out to the commissioners the investigators report, specifically on page 4, the footnote, in which the investigator found that the complainant has a long history of making complaints and that there's no evidence to support that the respondent retaliated her for making multiple complaints. The investigator also found that my client was unaware of any of her disabilities, which the complainant also acknowledged that's on page 1 of the report. There are a significant number of complaints that were made to my client in regards to issues with employees and issues with the apartments themselves, all of which were addressed immediately. Certainly the record was provided to the commission in regards to emails, and that if things were, and my client was notified on the weekend that people were there on Monday to address those issues as quickly as they could bring people over. There were also a number of complaints about things like shrubs and screens and heat and water, for which there was no finding made by the investigator that my client had failed in which to respond in any way. So I would point that out to the commission as well.
Thank you. Any commissioner questions for Ms. Millentine? Seeing none, Ms. Correa, you have 2 minutes left.
Yeah, thank you, ma'am, for allowing me this time. I was charged 2 deposits, a second deposit for this, well, I already live here. I feel that this is in retaliation for me filing against that employee for criminal trespass. I also feel that, and also the respondents also assigned paperwork with housing, Main Housing, to attempt to have me illegally removed out of this apartment. Okay, even though rent has been fully paid for, I am up to date with everything always. I was not notified by the defendant, but I'm sorry, by the respondent, that the check for July, I think it was, or July 2022 was missing. And I did put that in the mail. Of course, once I put it in the mail to them, I'm not responsible for what happens to it. I did send the check. I was not notified, except into the meeting, Zoom meeting, that he claimed that I owed him money. Well, I sent another check, and that was actually cleared the bank for that month. This month, it was cleared my bank on December 2nd, 2022. So I'm up to date with everything. I just already sent out the rent for this month, my portion that I'm supposed to provide. Yeah, and also I've also repeated, like I said, I have emails asking for that to be fixed. It was completely ignored. 11 months I've been asking for that. There's other repairs that I've asked for. which is actually being ignored also. Currently, there is a window downstairs in the basement that I reported to the inspectors, and they say, well, nobody's gonna be breaking through here. They can't guarantee me that because the window is broken, somebody messed with it. And now there's water that leaks through the side of it. I've been here 12 years and there was no water coming through there until last October. When I went downstairs and there was a big, like water gushing through there, I'm like, what's going on here? Somebody messed with the windows. Those windows attached to the sides, and then so people can just like, push the window in and get, bottom in. And of course, they're supposed to have other mechanisms there to protect. And of course, I don't feel safe living here because I have to put a chair on my basement door to make sure if I'm asleep, nobody can come in through there, because things are not addressed on a timely fashion. Why would it take over a year for him to provide me screens for doors? Screens for windows that he actually told me he had to do because it was access windows. Told me I was going to get him. First, they came in here several times to measure those windows. Of course, he said that he was still looking for them in a box.
Ms. Correa?
Yeah.
Sorry to interrupt you, but that's your time.
Sorry.
Any commissioner questions for Ms. Correa? Seeing none. Thank you, Ms. Correa. At this time, we're going to turn to the investigator.
Good afternoon. I'm going to ask Barbara a quick question, which is, investigator notes are generally confidential. Can I read from them or should I paraphrase? In this instance?
Let's paraphrase.
Let's paraphrase. Okay. So, and that question is for this issue of the statement that was made at the conference. Yes, I wasn't in attendance, but investigators are required to make notes of those conferences. Legal reviews our reports, and so there are notes in here that indicate exactly the statement that the investigator makes in the report, that there was an indication that because of the changeover to that they're going to do these remodels on these units, that's why the door wasn't repaired or replaced. That's why it was removed. I also wanted to point out this issue of the discrepancy between what the respondents are saying, how often they were contacted or knew or aware of the door being broken versus them saying, that it wasn't an issue until they're focusing on the issue of when the inspection took place. At least as early as January 2021, respondents indicated they were aware of the door. So complainants saying it was as far back as March, even if that weren't correct, which the investigator in this case found it was, respondent themselves report that complainant contacted them and said the door needs to be repaired as early as January, and there's no explanation in the record as to why still at June it was failing inspection. So I just wanted to clear up those issues in the record, and I'm happy to answer any. Yes.
Just real quick, someone mentioned about, I think, Ms. Mellencamp, that it's not part of the contract, it's not a contract issue. What is that?
Yeah, I think what they're referring to is the contract with HUD, which there is no copy of in the record, but in terms of what they're required to do to maintain these units, HUD gave them the option of removing the door, which was within HUD's requirement. However, the issue that the investigator was focusing on is why that decision was made, including why the repair hadn't yet been made. And even though respondent was making the statement that all the doors had been replaced, all of the tenants were recipients of public assistance. So it doesn't really sort of refute the fact that public assistance was the reason that the door was being removed, as indicated by the statement in the conference. So regardless of what the contract was requiring the landlords to do, the investigator still found that, and my reading of the record supports, that it was the reason they were making the decision in this instance was due to the receipt of public assistance by complainant. I hope that answers your question.
Thank you.
I also have no understanding of the HUD contracting step. We don't generally look at this.
Commissioner David?
I'm reading the factual background. I'm confused about the timeline. It says that the respondent had notified the tenants he would not be renewing the leases because he was terminating his Section 8 contract when it expired. And then the contract was set to expire December 29th, 2019. And here we are in 2022. What was the status of those tenants? I mean, how many left on their own? How many were evicted? Are there any left now?
Sorry, keep going. Didn't mean to interrupt.
Yeah.
Go ahead. The status of other tenancies is not in the record. What is in the record is the indication that that the tenants were given extra time to try to find other housing. So I believe that's why there's no, the complainant still resides there and there's no, or resided there as far as the record was concerned. I didn't actually find out if that's still her address, but there's nothing in the record to describe when other tenants left or why they left or what the status of their tenancies is right now. Based on the record at the time it was closed, that transition was still happening.
It was still happening 3 years later,
Yeah,
2 years later. Yeah, 2 years later.
yeah. That respondent was giving people time to leave, but once they left, the apartments were then converted to market rates.
Okay.
Any other commissioner questions for the investigator? Seeing none. Okay, thank you very much. Thank you. So commissioners, you've heard from the parties and heard the presentation of the investigator's report. There are 2 proposed findings here. You can take them separately or together. Commissioner O'Brien.
I'm just gonna do one. Number one.
So you say.
No. I would recommend that there are no reasonable grounds to believe that Bayview Apartments at Bob Hutchinson discriminated against Delia Correa, I apologize, on the basis of sex, sexual orientation, or gender identity, disability, and or familiar status. Or retaliated against her for engaging in MHRA protected activity. These claims should be dismissed.
Second.
So it's been moved and seconded on the first proposed finding. I find no reasonable grounds. Is there any discussion among commissioners? Seeing none. So if you agree, no reasonable grounds on the claims of sex, sexual orientation, or gender identity, disability, familial status, and retaliation for MHRA, we'll vote yes. Commissioner Ashby.
Yes.
David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Okay. That leaves the second proposed finding.
So I'll move to accept the recommendation that there are reasonable grounds to believe that there's discrimination on the basis of public assistance. If permitted, I will just combine that with my commentary now.
Nope. Gotta have a second.
Okay, well,
I wish you would.
We need a second. We need a second.
I'll say.
Mr. Douglas, do you want to speak to your motion?
I would love to make some. Yeah, I would just simply say that I think confirmed here that there is direct evidence of such discrimination in the record. So, low hanging.
Any other discussion among commissioners? Seeing none. The motion is to find reasonable grounds to believe that Bayview and Bob Hutchinson discriminated against complainant on the basis of receipt of public assistance. If you are in agreement, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
So the finding is reasonable grounds to believe discrimination occurred based on receipt of public assistance and no reasonable grounds on the other claims. The commission will send parties and council a letter confirming that vote. And that is the final case on the hearing agenda. We thank Ms. Valentine and Ms. Correa for hanging in there. And at this point, we are close to being done. We're so close. I know you have to leave, right?
I have to leave.
Okay.
Run.
I won't make this mistake again. I keep making this mistake.
I appreciate it. Thank you. All right. So, are you?
No, now I'm making this way.
Okay. So at this point, what we need from a commissioner, is a motion to go into executive session that cites the appropriate part of the statute.
Pursuant to 1 MRS section 405-6E, I move that we go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second.
Been moved and seconded that we go into executive session. Any discussion among commissioners? Wait, there's 2 here. Hold on.
That's enough.
Oh, 2 there. Okay, right. I forgot about you guys there.
Do you want me to do a breakout room or should
I have a breakout room ready. Okay. But first we need, was there any discussion of the motion?
Why is the recording? Do you want me? I thought we were going into a breakout. I can unpause
You
it.
can't pause yet. Okay. Actually, we can't pause it all. So all the, oh, no, I have to go one by one. Commissioner, if you are in favor of the motion to go into executive session, you will vote yes. Commissioner Ashby,
Yes.
Mr. David,
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
Okay, so now I'm gonna move us theoretically into executive session and we are not pausing.
I think we did last time because of the YouTube channel. If that makes a difference to you.
Barbara says that we don't.
No, I don't know. I think the problem was the audio was picking. Yeah.
But if we turn, we have to make sure that's off because right now it's on.
Okay, so I'll
We are back in an open session. We don't even need a motion to adjourn. If anyone wants to make one, you can, but it's unnecessary. Say adjourn, boom, like Deb used to do. Boom.
They didn't come back.
Thank you
Oh,
all
we're
very
still
much.
in the breakout room.
No, we're not.
Yeah, just said we're.
Oh, I forgot to record again.
No, we're in the main room.
Yeah, we're in the main room. Yeah, thank you all.
Thank you.
That's fun. Merry Christmas, Happy Hanukkah.